Good morning, everyone. We're waiting for it to start. I have a killer headache, so I'm not gonna probably be talking for a little bit. Just want to give you guys a heads up. uh, so I took a bunch of aspirin. I'm hoping it goes away. But for right now, I guess we're just waiting for it to start, and see you guys in a minute.
So there's nothing, just so you see, there's nothing below this portion of the page, right? No information?
Correct.
All right. And again, the date and time of that the remains were received.
September 17th of 2020 at 2:08 a.m.
Now, Dr. Richmond, I want to walk through State's Exhibit 152 with you, which is your postmortem examination or autopsy report.
Yes,
All right. And do you have a copy with you? Do you need me to provide you a copy to refer to?
I do have a copy.
All right. And so let's talk. I'm on the back side of page 1.
Okay.
And can you describe how you received the remains?
Yes, she was, as I mentioned earlier, she was received as tentative Jane Doe, and she was received on September 17th of 2020, and they were the skeletal remains.
And what was accompanying the remains?
Her clothing and some personal affects.
Was there anything?
Sorry about that, guys.
Yes, there was a ligature that had been cut at the scene.
I'm going to approach the witness and show her what's been marked as State's Exhibit 150A through Y. And so if you can, take a look at all of those, please.
Okay.
Are you familiar with those?
Yes,
And what are they?
those are the photographs we took during the autopsy and some x-ray images as well.
And x-ray images as well. And do those fairly and accurately depict the remains as they were presented to you on September 17th of 2020?
Yes,
And would that showing these photographs and displaying them visually assist you in your testimony today or reviewing your findings?
yes.
Your Honor, permission to publish various photographs.
Any objection to publishing photographs? Please proceed.
And Dr. Richmond, when the remains arrive at the Montgomery County Coroner's Office, what are they contained in?
They're in a body bag.
And are they fastened, secured in any fashion?
Yes,
And I'm going to place State's Exhibit 150Z on the overhead. Can you explain what this is?
yes, that's the bag that's around the zipper, and that's placed when the body is collected at the scene. And so we cut that to access the bag.
And this is the tag that was on the bag for Ms. Noble's remains.
Correct, yes.
And once you did that, what happened next?
Well, then we remove the body from the bag and start our external examination. In her case, she also received some x-rays. So that would have been done from the beginning as well.
going to show published States Exhibit 150. I'm zooming in at the juror's request. And can you explain for the jury what this?
Yes, so here we have the skeletal remains of, at the time, Jane Doe, but of Miss Noble. So the head is on the left. What we're looking at is the bottom part of her head. And this is her hair here. And then her legs are bent, which are on the side here. And the body is mummified and skeletonized.
Does this picture depict clothing still?
It does, yes.
And you collected that clothing?
Yes, we did.
And that included tennis shoes as well?
Correct, yes.
States Exhibit 150B.
So here's
Hold on, I'm gonna zoom out just a little bit. So
certainly.
there we go. And please tell the jury about this.
So yes, so here we're looking at the left side of Miss Noble. Here's her head and her feet would be here. So we're looking at her hair and her shoulder here. And here we're starting to see some of the ligature, the USB cord that was received on her neck.
And 150C.
Yes, so here we're still viewing the left side of her body, but now we have a view of her legs and her shoes. And here's her head, and here would be her feet. And so we're still viewing, here's a portion of the ligature, and here are her tennis shoes. And this here is her case number that we see. So
I'm
it,
marking on the screen quick, sorry.
okay.
Continue.
Oh, I'm sorry.
No.
Yeah, so 4941 is her autopsy number, and then 20 is the year 2020, and MV are the initials of our photographer, Miles Warren.
In States Exhibit 150E.
So this photograph is to show a portion of how the ligature was on the remains of the neck. So here's the ligature here, and it gets lost in her hair. This here is all of her hair, and here's a portion of her. I believe that's her mandible that's been sort of displaced.
And when you were examining the ligature, did you find a knot?
Not in the portion that we received, no.
(150F), publishing it to the jury.
Yeah, here's another image of the ligature. It would be here. Here's a portion of it, and here's another portion. And it's covered in her hair. And here's another view of her mandible at the bottom that's being partially obscured by our ruler and the number.
One 150H, I'm placing 150H on the overhead.
So here's a clear photo of the ligature around the remnants of the neck. And so there's two portions of a USB cord on the neck, which is this structure here. And then here's, this part here is part of her skull.
And does the USB cord end right there?
A portion of it does. We do have a continuation because it was actually in two pieces that I received because it had been cut at the scene.
And this right here, though, is that one of the cut ends? And if you need me to zoom in, I can. Whoops, move this. There we go.
I believe so, yes.
Oh, it's not touching it. All right. But then the other end continues off to the right.
Correct.
Placing State's Exhibit 150B again on the overhead. And that part that continued off to the right, is that?
Yes.
Placing State's 150I on the overhead.
Yeah, so this is a photograph of the two portions of ligature we received. So I measured it in aggregate, it was about 20 inches. And they are these U-shaped pieces of USB cord with one having the connecting part.
And this part was around her neck,
Yes,
and this is the part continuing down her back.
correct.
State's Exhibit 150X.
Yeah, so here we have her skull with her maxilla, which is here, this portion here in her nose with the hair attached. There's some mold and growth on the remains.
Where is that?
Oh, it's this white material here.
And while you were conducting your post-mortem examination, did you observe any fractures to the neck area?
Well, the fracture I observed was to the hyoid bone.
Placing State's Exhibit 150K. What is that?
That's the hyoid bone.
And on this bone, what fractures did you observe?
We observed that there was a fracture on this side. This is also irregular, but our exam did not identify the other portions because at that point we deferred the examination to anthropology then.
Then you indicated x-rays were also taken?
Yes,
And is that part of the standard procedure at Montgomery County Coroner's Office?
yes.
Placing State's Exhibit 151. And what is that?
So this is an x-ray of her head, of the skull, and here are her shoulders. So it's the upper part of her body, including the skull.
What is this?
That's the USB cord. And
What
we
is
also,
this? Oops,
yeah,
sorry, go ahead.
Yeah, I was about to say, that's a necklace that we found on her person.
Can you circle that, please?
Certainly, here. So that's the necklace, and here's a pendant that was on the necklace.
What is that?
I believe that's still a portion of the USB cord.
State's Exhibit 151A.
So this is an X-ray of her torso from mid-chest down, including part of her pelvis and part of her right arm.
What is this?
That's some, probably from a tank top. They're just some clips, probably from her clothing.
State's Exhibit 151B. What is this?
So here we're X-raying the bottom portion of her body, including her pelvis and her legs. And this is one of her feet. We do have an e-cigarette being X-rayed here as well. It's this stick-like figure.
And then what is that?
That I'm not sure. It might be just some debris.
Dr. Richmond, I want to now get into showing the physical evidence. You have gloves right there and scissors. If you could please put them on. I'm going to hand you what's been marked as State's Exhibit 156. Can you identify that?
Yes, that's a ligature that was in two pieces.
And how do you know?
It's indicated on, as it's labeled on the bag.
And is that one of the labels from the Montgomery County Coroner's Office?
Yes,
You recognize it?
yes.
If you can, please cut it open. And looking at that, does it appear to be in the same or similar condition as when you first found it on Emily Noble's remains?
Yes.
And if you can, hold up the two pieces. And that piece that you're holding up right there, that is the piece you indicated earlier was around her neck from the photographs.
Yes.
And can you hold up the other piece, please? And that was the piece that was dangling down her back.
Yes. This was also around her neck, and then that was dangling on the back.
And so was this around her neck or tucked into the cord around her neck?
Well, they were both tucked into each other. Yes.
Kind of like a shoelace.
Yes.
All right. But this is what was around her neck.
Yes.
Showing it, holding it up for the jury. All right, I'll let you put those back in the bag, please. All right, now I'm going to hand you what's been marked as State Exhibit 157. What is this?
This is her hair tie.
And again, a Montgomery County sticker on there.
Yes, and
To
it's
recognize
labeled.
it.
Yes.
I'm not gonna have you open the hair tie-ups. And then State's Exhibit 157. 158, excuse me, hold on, let me mark that, sorry, thank you.
Yeah, this is, it's labeled as e-cigarette and necklace.
Is that from the Montgomery County Coroner's Office?
Yes, but it doesn't have our standard label on it.
Do you recall retrieving the e-cigarette and necklace from the remains?
Yes.
I'm gonna have you change gloves and open that up for me, please. Can you just hold them up to show to the jury? What is that?
So here's the e-cigarette, and here's the necklace with the purple pendant that was around her neck.
And those were both visible on the x-ray.
Yes.
All right, I'll have you put those back in there. Do State's Exhibit 159. Are you familiar with that?
Yes.
And what is it?
It's clothing from Miss Noble, Old Navy leggings. It's labeled.
All right, if you could please open that up. And what are those?
The pair of cancer leggings that she was wearing that we collected.
Are you able to put them back in the bag?
I can try. It's not easy.
Can you read that exhibit label and tell me what number I'm on, please?
It says 159.
Okay, that's what I thought. 161. Are you familiar with that?
Yes.
And what is that?
It's the tank top that we collected.
And can you please open that for the jury?
Yeah, it's in a second bag with our label on it as well.
record, she's holding up the item, and what is that?
It's a tank top.
And you recognize that from the remains of Emily Noble.
Yes.
That's 161.
The court reporter's nodding her head, so,
Yes.
yes. And now I'm going to hand you what's been marked as State's Exhibit 160.
Oops.
I'll try that again.
Okay. Sorry.
We'll throw your dirty ones in there.
Yeah, that'd be great. But thank you. Yeah, so this bag is labeled Old Navy shirt.
And what is that?
A portion of her clothing. She had a shirt on.
And please open it.
So here we have her shirt.
It's mostly intact.
It is, with some defects in the fabric.
You indicated you also recovered her shoes.
Yes.
Right. And I'll hand you what's been marked as Defendant's Exhibit JJ. It was opened yesterday, so I'll just ask you to remove the items.
Okay.
Do you see one of your labels there?
I do.
And
Yeah.
what is in that bag?
It says it's a left shoe with our label on it.
And I'm going to hand you what's been marked as State's Exhibit 163.
Okay.
Okay. Can you open that, please?
Yes. Yeah, it's labeled as right tennis shoe. So it's a right tennis shoe.
Did you see your label on that bag from the coroner's office as well?
I do, yes. Our label in it with the writing our shoe.
And that's one of the right shoe of Ms. Noble's.
Yes, correct.
And Dr. Richmond, I should have asked this with each piece, but I forgot. With regards to the shoes, do they appear to be in the same or similar condition as when you removed them from the remains?
Yes,
And with regards to the necklace and the e-cigarette,
yes,
same or similar condition?
yes,
The Old Navy t-shirt, same or similar condition?
yes,
The Old Navy pants or leggings, same or similar condition?
yes,
And the tank top, same or similar condition?
yes.
Now, when you collect evidence like that, is there a document created at the Montgomery County Coroner's Office?
Yes,
And I'm going to hand you what's been marked as State's Exhibit 164.
yes. That's the evidence sheet of our documentation of what we collect.
Set the trash can there.
Okay, thanks.
Is this a fair and accurate copy of the evidence collection sheet for the items you received from Ms. Noble's remains?
Yes,
Permission to publish from the jury? No objection. Just scroll down again. What were the date received?
September 17th of 2020.
And those items were given to whom?
Detective Steve Grubbs.
And again, a listing of those items.
Yes,
Now, you described that in this case, a decision was made to send the remains to OSU.
yes.
And for what purpose?
Well, because the remains were mummified and skeletonized, they have additional training to evaluate skeletonized remains. And so we decided that they would be the best person to evaluate the Miss Noble's remains.
Do they have other tools at their disposal that you do not at the coroner's office?
Yes. They have more visual tools like special microscopes and such that they use that we don't use, and additional training to evaluate bones.
And do you recall when those remains were sent to OSU?
I believe it was October 2nd, I believe.
Oh, hold on. Is there something that would refresh your recollection?
Yes.
And what is that?
The chain of custody form. Yes. Yeah, so they were released on October 2nd to a representative of Ohio State University 12:22 p.m. p.m.
And then after they were released to OSU, did you have any further involvement while you waited for their conclusions?
No, we just awaited their conclusion and then they took custody of the remains. We never received them after they were sent.
At some point, though, did you receive a report from a Dr. Agnew with the Ohio State University?
Yes,
And after reviewing Dr. Agnew's findings, did you then author the post-mortem examination report for the remains of Emily Noble?
yes,
And did you include a cause of death?
yes,
Now, were you able, after reviewing not only your own examination of the remains as well as Dr. Agnew's report, able to give an opinion as to the cause of death for Emily Noble?
yes,
And that opinion is rendered to a reasonable degree of medical and scientific certainty?
yes.
And what, I'll place your report on the overhead. And what was your opinion?
Yeah, our opinion was that the cause of death of Emily Noble was multiple injuries of the head and neck. And then we elaborated that on a comment. Most of our findings, I did see that we noticed a fracture of the hyoid bone, but most of the examination was conducted by the anthropologist. So we reflected what was in the report, where there was injury identified not only to the hyoid bone, but to the ossified thyroid cartilage, the left and right nasal bones, and the left maxilla.
And you indicated you reflected the findings of Dr. Agnew, but you
Yes.
reviewed the findings, correct?
Correct.
In conjunction with your own review of Emily's remains
Correct.
and formed your opinion therefrom.
Yes.
And this, is your signature contained here?
Yes.
And what was the date of this report?
It was January 22nd of 2021.
And who is this individual?
Dr. Lehman, he was my supervising pathologist, forensic pathologist at the time.
And he also assigned his signature to this report.
Correct.
Thank you, Your Honor. I have nothing further.
One moment, Your Honor, if I could. I am going to ask you, yeah, I'll ask you. Good morning. Good morning.
Sarah needs a recess to put her strap on.
Hi.
Got some follow-up questions with you.
Okay.
Just wanna, let's begin with one thing you said. You were asked, do you render those opinions to a reasonable degree of scientific certainty? You would agree with me as a forensic pathologist that there is no absolutes in science.
Yes.
And so we use the term reasonable degree, right, to scientific or medical certainty.
Correct.
And I am assuming in, and tell me if I'm wrong, but in your expertise, and I know you've just been tendered as a forensic expert, that you would never testify under oath and say anything is an absolute.
Correct.
Would you mind opening the hair tie bag?
Okay.
And tell me if you, I think you have photos. Um,
157. Thank you.
and that hair tie was found around which wrist? Does it note?
It does not on the bag.
Do you have independent recollection of that, or would a picture refresh your recollection?
The picture would help.
Let me, one moment, if I look for one. Well, let me ask you this, as you're looking at that photograph, or I'm sorry, at that hair tie. I want to just show you a photograph that's been marked as Defense Exhibit P, and I'm just going to zoom in. I'll zoom in here. I just want to. Is the band that was found in the bag, the hair tie, a single hair tie or a double hair tie, like what's pictured there?
Well, I see a single hair tie here, but I'm not sure if it's looped twice on a wrist.
Fair enough. But what's in the bag is a single, right?
Correct, yes.
If it was looped twice on the wrist, I assume that we would see that in the pictures. Would you agree with me on that?
Yes.
I want to talk now, thank you. I want to talk now about, I want to go through your report. Showing you what's been marked as State's Exhibit 152. The signatures on the report, there's 2 signatures.
Correct.
Yours appears as the first signature.
Yes.
And it's, and as you testified to, it's because at the time you were a fellow, and Dr. Lehman essentially was he doing a peer review of your work? Is that what you would call it?
Well, he was present at the autopsy. He was supervising the entire case with me.
And so his is the second signature on the report.
Correct.
But you were the one that was actually performing the majority of the work in this case.
Yes, in conjunction with Dr. Lehman, he was there the entire time. So it was the 2 of us together.
So I want to go to the remains received. Remains received right here includes the date, and it says skeletal remains. Do you see that under remains received?
Yes.
And then I want to go down to the external examination section. You would agree with me that the remains received, that is the bones, there is not an inventory or itemization of the bones that were received in your report. Is that fair to say?
Correct. Yes.
And the only thing that you note in that paragraph as missing is where you say some teeth absent.
Correct.
And you know, despite you being shown this picture, one moment. Showing you what's been marked as a State's Exhibit 150C. The shoes, I'm curious about this. Let me zoom in. When the remains arrived at Montgomery County, were the shoes off the feet?
Yes.
So they had been taken off the feet.
Well, they were in the bag with the remains, but they were not attached to the body.
So, and I want to really be clear about this. So when you zipped the body bag open and removed the remains, that's why I wanted to follow up. It appears that the shoe has been removed from the remains.
Yes.
And that is true of both shoes?
Well, in that, I believe, I can see it on that shoe, but I'm not sure of the other one.
Let's see if there's a different picture you weren't sure. One moment while I look through the other photos that you weren't shown to see if there's a picture of the other shoe. Doesn't appear to be. Well, let me show you 150. 150C has the shoe in it, and 150 appears to have neither shoe in it. Would you agree with me on that? I can approach if you'd like it closer.
Yeah, that would be good if I
Okay,
could see
absolutely.
it.
May I, Your Honor? Showing what the witness has been marked as State's Exhibit 150, and for orientation is 150C.
Yes. Yeah, I don't see a shoe in 150. Yeah.
And this is how you got the remains, like this.
Correct. Now, the shoe may have fallen off the body with the bones in it. That's the part I don't remember 100%.
Sure.
But it was received, it was not connected to the body.
And so you don't know how it became unconnected, but it was unconnected in the body.
Correct, yes.
So then, returning back to your report with respect to the external examination, I know that you note that the body at current weight when it came in for autopsy was 18 pounds.
Correct.
Teeth in good repair with some teeth missing. And then here with respect to the clothing, you've got the black shirt, which you held up and you said that it was still intact. I think that was the word that was asked of you.
Yeah, with some defects, yes.
And defects in the actual material itself.
Yeah, it looked frayed, yes.
And then there was the tank top. Fair to say that as you recall collecting that evidence, that as those items were layered, that the shirt was over the tank top
I believe so.
and was down below as the body, I forget the word now, but condensed or, well, I forget the word. But the shirt had fallen down and was collected from sort of the mid-waist section.
Yes,
And the tank top in the x-ray, you saw that little clasp. Now that you've seen that tank top, does it appear that that was the clasp of the back of the tank top where you would adjust it?
yes.
And then I know the e-cigarette was shown in the x-ray. The e-cigarette is actually shown in the x-ray because it was in the pocket of the pants.
I believe so.
Was it not? I just want to show you that picture. If you can tell, and I believe you can, showing you what State's Exhibit 151B. Let me zoom out. This would be the, what body part?
Yeah, that's the femur, the right femur. So it's the right bone here.
And so this would be the left femur.
Correct.
And so it appears that the e-cigarette is in the left pocket of the pants that were being worn at the time.
Yes.
You were asked some questions about the cord and shown a number of pictures. I want to go through some of those. Showing you what's been marked as State's Exhibit 150I. So just so I'm clear, you or anyone from your office did not make those cuts.
Correct.
So if you could hold up that cord again.
Certainly. Oh, no problem.
Thank you. And if I may, and I have a fresh set of gloves on. So this was your testimony that this was what was around the neck.
Yes.
You would agree with me that this is, what do you think that total distance is? And I won't hold you to exact.
Approximately 4 or 5 inches.
And just so I'm clear, you didn't cut this.
Correct.
And it's your understanding that someone at the scene was able to get in close enough to cut that
Yes.
4 or 5 inches, and you believe that this was around the neck.
Yes.
We don't, there are no pictures of that from the lower portion, right? The pictures that you were shown are from the back of the neck. And let me show you those again. For instance, State's Exhibit 150H. Now, help orient me, but I believe this is the neck.
Correct.
And this is the back of the neck? And you can also use your screen.
I believe so, yes. Yeah, this is the back of the neck.
Okay, so that picture is looking from like this perspective.
Oh, correct, yes.
And this showing you what's been marked as 150F. That would help. And I know the placard or the tag is seemingly in the way.
Yes.
But are we, I know, is this the back of the neck again?
Yes,
So I'm curious because this is essentially the jaw.
yes, the head had turned, like it was in the main photo, you can see the head is a little bit turned.
So let's go back to that. In the main photo showing you 150 States Exhibit. Is this the photo where we can tell it's turned, or I'm happy?
Yes.
Okay. And tell the jurors how it's been turned.
Well, we're looking at the bottom of the skull here. So the head is sort of turned in this direction, at least in this photo,
And this direction would be
to the left.
to the left.
Yes.
I'm going to go now. How many photographs were taken in all by the photographer at the coroner's office? Do you know?
I'm not sure of the exact number.
But certainly all of those photographs were turned over to the state of Ohio through the course of your work.
They should have been, yes, with a request.
Sure. Showing you what's been marked as States Exhibit 150K.
Yes,
This is the hyoid bone.
yes,
Now, I want to talk about a little bit about just anatomy. So obviously you're a forensic pathologist. Hyoid bone is above the thyroid cartilage.
correct.
Is that right?
Yes,
You took this picture because your testimony is that the only fracture you saw was the hyoid bone.
yes,
And this exactly why you, I'm assuming, inventoried that and took a standalone picture of that.
correct.
You would agree with me, and I presume that you had an opportunity to review all of your photos today. There is no standalone or other picture of the thyroid cartilage. Would you agree?
We did not examine the thyroid cartilage. At that point, we decided to have the anthropologist conduct their exam, so we never examined it.
No, just question though, is there isn't an independent photograph of the thyroid cartilage.
Correct,
So the only photograph we have in your collection of photos is of the hyoid bone.
correct.
Which takes me back to your report. When you would consider the hyoid bone in the neck,
Yes,
you would consider the thyroid cartilage in the neck as well, would you not?
correct.
So I want to go to your findings and conclusions in this case, which are multiple injuries to the head and neck.
Yes,
So let's separate those. The only fracture that you personally saw was of the neck.
correct,
If there were also fractures to the thyroid cartilage, that would still be the neck.
correct.
So your opinion with respect to any injuries to the head is exclusively relying upon Dr. Agnew's findings.
Correct, and of the thyroid cartilage. I did not examine that.
So let's break those up.
Okay,
You didn't examine the thyroid cartilage.
correct.
So you're relying on her findings as to the thyroid cartilage as well.
Yes,
And you're aware of the I know you don't have the technology, but you're aware when you sent the bones off for forensic processing that there is a process
Yes,
which the tissue can be removed from the bone, and then the bones can be more closely looked at once the tissue is removed.
correct.
And it was your understanding when you had the bones sent to OSU that that was the work that they would engage in.
Yes,
Tell me if I'm wrong, but it's very important to capture bones. Let's just use bones. Bones, when you receive them, just like you did, you really captured a detailed snapshot of the remains as you saw them from all angles. You captured several photographs of the ligature, right?
yes,
Because you know that this day might come when you come to court and you have to testify. And of course, not only are you giving the jurors a visual of what you saw, but it also helps to refresh your recollection.
correct.
So in terms of best practices, you want to make sure that you photograph everything, do you not, before you manipulate.
Correct.
So let's just say hypothetically, in an autopsy of a human who has recently died, you would first take the photographs of the body without any cuts whatsoever, would you not?
Correct.
You would take it so that the viewer could see the full integrity. And then as cuts were made, right, then the layering of work would be captured on photographs.
Correct.
And that process of capturing that work is important, is it not?
Yes.
So going back to your report, I know that you reviewed Dr. Agnew's report as to the thyroid cartilage fracture.
Yes.
There is not a picture of the thyroid cartilage in your stack.
No, we couldn't see it because there was soft tissue over it, so that we did not examine it.
You did not examine it.
Correct.
And her report was dated January 11th of 2021. And I see that your report is dated 11 days later.
Yes.
Tell me the day you received her report.
I don't recall the exact day, but it must have been during that interval.
So you received her report at some point, and we know that from the date of her report being issued to the date of your report, there's 11 days of time.
Yes.
And you're essentially waiting for that report, are you not?
Correct.
And then, and that is the conclusion as to the multiple injuries of the head is her finding as to perimortem fractured on the left maxilla.
Correct.
Absent that finding, there's no multiple injuries to the head.
Correct. We relied on Dr. Agnew's report and findings, yes.
I also just want to make sure we know, because it's included in your report on page 2, where you literally copy her report, do you not? Into
Correct.
your report.
Yes.
It's even, there's a quote there. Do you see that?
Yes.
And then at the end, you're end quoting.
Yes.
So you've literally taken this whole thing from her report and put it into your report.
Yes.
Because the only perimortem injury that Dr. Agnew identifies is the left maxilla, correct?
Well, my understanding is she found a perimortem trauma to the nose and the left maxilla.
Tell me which sentence you're reading it.
Let me see.
Sure.
So on the top, my understanding, in quotation, perimortem trauma near the time of death was observed on the following skeletal elements: hyoid, ossified thyroid cartilage, right and left nasal bones, and left maxilla.
One moment, if I could.
Certainly.
Sure. I just need to find the report. Fresh copy.
I'm not sure which number it is, so give me a second.
Certainly.
If I may approach, because I want to, well, I'll just do it on the overhead. Show you what's been marked as State's Exhibit 130. And this is important, and thus me asking you about it. That section that you just read,
Correct.
is this section right here.
Yes.
Okay. Would it's right and left nasal bones and left maxilla? Do you see that?
Yes. Correct.
1 second. I don't have my marked up copy. 1 second. Right and left nasal bones. Is this what you're relying on? And the left maxilla.
Correct.
Do you believe that she's consistent throughout her report as to where she sees perimortem trauma?
Objection, possible speculation as to consistency on Dr.
Yeah,
Agnew.
she could read the report.
Sure.
Answer
Tell me if you'd like
question
to,
accordingly.
to read her report. I can certainly approach you with a copy. If I may, Your Honor, State's Exhibit 130. Just to orient you,
Okay.
this is the trauma section. Sorry, didn't mean to.
In my opinion, it seems consistent.
Okay, let me show it to you. Let me approach again.
Okay.
That was super, super meek of
And
a.
I'm asking you this because you said that there was multiple head and neck injuries. So just want to make sure, right, and obviously accuracy in your field is important.
Yes.
So you see here that it talks about in this first section, the left maxilla,
Yes.
and then you actually see here that now for the first time, the right maxilla is mentioned. Do you see that down there?
Correct.
And with respect to your findings, and then I know you copied the portion of her report into your report. The portion you copied, shown on page 3 of your report, this is what you relied upon in your findings as to the multiple head and neck injuries?
Yes.
Absent that, the only fracture that you had seen is this fracture right here.
Yes. But I did not examine the body.
No, I understand.
Yeah.
This is the one fracture that you saw.
Correct.
That's why you sent it out.
Correct.
And you were trusting the work of someone else.
Correct.
And then you literally adopted their work and plopped it into your report.
Correct.
We could go to the shoes. Do you have one of the shoes still out, or are they back in the bag?
Oh, I put them in the bag.
Perfect. Have you ever, because you were asked about your experience in training, have you ever examined a body that's been dragged?
Yes.
have you ever examined a body with shoes that had been dragged?
Yes,
And did you, as you look at those shoes, did you look at those shoes and question or ask yourself whether there was any evidence of dragging on those shoes?
no, I did not examine those shoes for that purpose.
If you could pull out one of the shoes again. And Doctor, when I say dragging, I mean, through the course of your experience and work, you're certainly familiar that there are instances where a body is dragged by another person.
Correct. And I'm more trained in examining the injuries secondary to dragging on the person, not so much on their personal items.
Fair enough. But you've seen dragging, certainly abrasions, that kind of thing. If someone was dragged without shoes on, you would expect to see that.
On their skin, yes.
Yes. And so in this instance, we just have the shoes, and I know you didn't examine them for dragging, but certainly the shoe is knotted up top, and it is what it is it not?
Correct. Yeah, I that's beyond my level of expertise.
You were asked questions about, in your experience in the autopsies you performed with respect to hangings. I'm sure that you are, as a forensic pathologist, aware of the American Journal of Forensic Medicine and Pathology.
Yes.
And I'm showing you what's previously been marked as Defendant's Exhibit II. Outside of your own experience with 70 autopsies, and let me approach, Your Honor, if I may. This is the actual marked copy.
Okay.
And Matheau, are you familiar with that article that's been published in the American Journal of Forensic Medicine and Pathology?
No, I'm not.
And I understand in your own experience, but if you go to page 3 of 6, there is a chart at the top of 3 of 6.
Yes.
Objection, Your Honor. She's indicated she's not familiar with this article, so I'd ask that the witness be given the opportunity to thoroughly review the entire article before asking her to testify to one part of it.
I'll give the witness the opportunity if she wishes to do that.
Okay.
Yeah. Raghav, it's because what she's doing is relying on somebody else's determinations to make her own determinations. And if that first guy's wrong, she's wrong. And as we saw from yesterday, there's some issues with how these determinations were made. And, garbage in, garbage out. If you're given bad info, you will make a bad determination. So that's the issue there. It also just shows everybody was sloppy. Everybody relies on everybody else, so nobody actually did the work on their own. Exactly, JT. That's the other issue. Well, and it's not like as though you're copying a work report where you did all the work before and it's the same results. Fine. But if you were giving this off to a colleague and they were they did an analysis of things based off of what you did, if you were wrong, they're going to be wrong. And they should probably do some of their own data gathering to make sure they have the proper data results sometimes. And especially in a case like this where it's not clear how this woman died. There's not a lot we know, and everybody kind of just worked off everyone else's math. And I will also agree that, like I copy, I'll reuse briefs or motions that I use. I simply change the names on them. But if I need to do something brand new, I don't just copy and paste and hope it works. I doubt you do that either. So, Jill, we'll probably cover that tonight. Maybe I might do a stream or something about that. But he's letting his attorney do most of the work. Now he's just doing it, it sounds like, to screw with his ex-wife. So I don't think we're going to hop over to that. This is, I think, a little more interesting now. Matt, we'll watch that later. I don't want to disrupt the flow here because this is actually getting really good again. And I think, once again, this is just laying more reasonable doubt.
Well, I've read it quickly once.
Okay. And I won't get in the weeds with it, but it is
Okay.
marked as an exhibit, so the jurors will certainly have an opportunity to see it.
Okay.
I just want to ask you, because you were asked about your experience, but certainly your testimony is not that it's not possible, because would you agree with me that this literature actually indicates that in 109 cases, let me go back, so 109 cases of suicide or accidental hanging, we have 7 individuals, so 10% where there's the 4 fractures.
Yes, according to the article.
That was published in the American Journal of Forensic Medicine and Pathology.
Yes.
And then we have here this chart. If we add these numbers up together, of course, we get to the 7 of the 109.
Yes.
Just a couple, thank you for taking the time to do that.
Oh, no problem.
Just a couple questions, if I can, about State's Exhibit 154 and the chain of custody. The remains come to the coroner's office, and I think, and tell me if I'm wrong from my memory, they go to they first go to a receiving area, or
Correct. Yeah.
and they are held in that receiving area until you or Dr. Lehman or the pathologist on call can actually perform the autopsy.
Yeah. So they're first received in a receiving area where a car enters a garage, and that's how we receive the body. But then the body is transferred to a cooler. So the body is then stored in a cooler until we are ready to perform the autopsy, and then the body is taken to the morgue. So the trace 7, BB, and MI, those are locations in the cooler where the body was stored at different times during her stay at our morgue.
And so you can use your screen if you want to mark, but
Okay.
the car pulls in to the dock,
Yes,
and then the remains are put into a cooler in the receiving area.
correct.
And then the remains are taken from the cooler and put essentially in the examination room on the slab or table.
On a tray, yes.
And then after the examination, the remains are again moved back to a cooler.
Correct.
And they are held in that area in the cooler until and unless the next law enforcement or other agency comes for those remains.
Correct, or funeral home, yes.
So arrival to the cooler, to the exam room, and then back to the cooler.
Correct.
I want to ask you about your reliance on photographs. You testified, just as an example, that the placard that's seen, showing you what's been marked as 150A, just as an example. This is the case number that's been assigned,
Correct,
and this is actually the initials of the photographer in the room.
yes.
You would agree with me that taking photographs, right, is obviously important. We've walked through that.
Yes,
And when you received Dr. Agnew's report, there was a number of photographs attached to her report.
correct.
And you reviewed those photographs?
I did, yes,
And I'm assuming that you looked closely at them?
I did.
And those photographs alone were sufficient for you to incorporate her findings and conclusions into your report?
Correct.
At no point in time after the bones were processed or at OSU, did you personally go back and look at the bones to see if you saw the same or similar fractures?
Correct, I did not.
One moment, Your Honor. Just ask about preempting a possible question.
Okay.
With respect to toxicology, was there a toxicology exam done in this case?
No, we were unable to do the toxicology on the remains.
And a toxicology report, had there been a specimen that could have been taken, what types of things could a toxicology report show?
Various pharmaceutical medications, drugs of abuse, and then we can also look at the fluid of the eye for chemistries, and that would all be documented if toxicology could have been done.
And in addition to drugs of abuse, toxicology could also test or determine whether there's like nicotine or alcohol.
Alcohol, yes, we don't look for nicotine, but certain labs do.
Yeah.
Yeah, they actually look for codeine.
Codeine, that's
Yes.
right, that's right.
Yeah.
Be ready, please.
Thank you, Your Honor. Dr. Richmond, defense counsel was talking to you about observing the fracture on the hyoid bone.
Yes.
And you indicated you did not observe the thyroid cartilage because you did not examine it.
Correct.
And so can you explain that to the jury?
Certainly. Although Miss Noble's remains were skeletonized, she did have some soft tissue, so not all the bones were visible to me in their entirety. And because we decided early on that she would be best examined by the anthropologist, we did not do any dissection or examine any other structures except for what was visibly accessible to us without any form of manipulation. So I did not examine her neck structures beyond the hyoid bone, which was evident.
And so it's not that you didn't see the fracture, it's that you didn't examine it
Correct.
to protect the integrity of her bones.
Correct.
Now, going back to the hyoid fracture that you observed,
Yes.
can facial fractures injure the hyoid bone?
Not per se. The face is distant from the hyoid.
And so the facial fractures that you relied upon in your report have nothing to do with you relying upon the hyoid fracture, the neck fractures that you observed yourself.
Yeah, there's separate locations.
Can nose fractures, like you noted in your report, cause death?
Not per se, but it's just, we were just documenting the injuries that Dr. Agnew in particular identified in that case on the face, because she was the one who examined the skeletal, the face per se.
And then the injuries to the neck of the hyoid and thyroid cartilage would be life-threatening.
It possibly could.
and lead to death.
It could possibly, yes.
Thank you. Nothing further.
Recross?
No, thank you.
Okay, jury's going to ask questions, so I'm going to ask if they have any questions and we'll address it. By the way, I'm sure we'll address it during the time. If you give my regards to the
Will do, thank you. Okay, fantastic. Also, will do. Yeah, I love
I don't know what you thought about all that, but that was further not super impressive. I mean, the way they have to admit, like, okay, the head's moved and all the different body parts have been moved, the body's shifted. Like, I don't know how they can attribute these injuries to what he's alleged to have done here. Jody, no, they've never tested what's in the water bottle. I was going to bring this up about the, Diane using the fake larynx and body thing up to her throat. Yeah, but she was doing that to point out this is not correct to scale. And this is not for a woman, it's for a man. So it's a demonstrative aid that really isn't applicable. And she's trying to show that they're not doing things properly, that they're being a little sneaky and dishonest because they don't have a woman's, neck set up there, and it's not to scale. So it's not really meant to be a gesture. It's just meant to show that that's not accurate. You guys are worried about to the water bottle. Why wouldn't they test it? I mean, unless they thought she was drugged, I don't know if that matters too much, guys. I know we want to know what was in the water bottle, but it doesn't change much.
From your training experience knowledge, do you know how long it takes for a body to be mummified or become skeletal?
Yeah, that varies. There's multiple factors. There's the environment, the age, the condition of the body prior to passing. Like somebody who has a fever may decompose and mummify faster. So there's too many variables to determine an exact time. One would say just in generalities, it would be months.
When you originally received the remains and made your first external examination, were the feet intact to the body?
I do recall the feet were per se intact. The bones were present, most of the bones, some of them, but they for the most part were intact.
And what if any part of the feet were missing that you observed?
I didn't examine the feet to that extent. At that point, we deferred to the anthropologist to do an inventory of the bones. So I'm not 100% certain if there were bones missing. I did collect some bones for DNA. So before we sent the body, I collected some molars and some the small bones of the feet for DNA. And then we sent that off to BCI, or it was sent off at some point for BCI because she came to us unidentified.
Obviously, you testified to examining the remains on a certain day.
Yes.
Did you do any further examinations of the remains prior to releasing the remains to OSU on October 2nd?
No, except for going back and collecting some of the bony structures of the feet and the molars, which was done at the end of the autopsy. We did not examine the body at all afterwards. We just sent it directly to OSU after it was coordinated.
In cases of your examinations of bodies and conditions like were present in this particular case, is it standard or normal procedure to do the post in one day?
Yes, it depends on the case. Sometimes I do have to go back and examine some other things, depending on if I get additional information or if there's something I want to look at a little closely. So it varies. It's hard to say. Each case is a little different. They vary from one to another.
From your observation and examination, did you note whether or not the USB cord was across the front of the neck once or twice?
Well, the cords were somewhat intertwined, and I could see it at least once. The head was tilted, but we saw it once, and the cords were, as I say, a little twisted.
Did you submit a report with your own findings that did not include everything Dr. Agnew stated in her report?
No, the only report I have is the one that was presented as evidence, and we relied heavily on Dr. Agnew's expertise and exam in this case. Except for some findings that we had, we deferred to her to do the examination pretty much.
And the events that occurred regarding Dr. Agnew in your report, is this standard practice with all autopsies?
It varies from case to case, but in circumstances and in the condition of the body in this situation, it typically is that we have somebody with higher level of expertise help us.
Was either foot attached to the body or did they come off in her shoes?
They were off in her shoes. She was very fragile, but I recall the shoes and the feet were separate from the body.
There's evidence in this case there was a water bottle next to where she was found at the scene. No toxicology report could be done for obvious reasons, as you testified.
Yes.
But could it have been done on the liquid still in the water bottle that was found on the scene with Emily?
Well, I did not receive the water bottle. It's not part of my inventory, so I'm not sure. Also, toxicology is usually done on body fluids like blood, urine, the fluid in the eye. So I'm not, the water could be evaluated for other reasons, but we were not involved and we didn't even receive it.
Were you ever aware there was a water bottle found at the location?
I saw it at the scene photo, but that was after the autopsy.
But it was never provided to you?
Correct.
Okay, thank you.
Yes.
Questions from the seat?
No, Your Honor, thank you.
No, Your Honor, thank you.
Thank you. You're
Okay.
excused.
Okay, thank you very much.
Take a break.
Yes, Your Honor.
Ladies and gentlemen, we'll take our mid-morning break. Please recall the court's admonition. We'll be back in 10.
It's not clearly he's clearly innocent. It's just that he's not guilty. And I don't know what you guys are thinking yet, so I'll probably put up a poll. Give me 1 minute, I'll work on that. Hold on 1 second, guys. Put that up. How do I? Well, you know what? I don't know if I can do it from the car. Guys, I don't know if I can do a poll from in here. I think I'll have to wait till I get back to the office. I had to go run an errand that took a little while. So yeah, exactly. Sweet Tooth. I haven't seen anything that shows beyond a reasonable doubt yet either. Stabby, you brought this up earlier, and I wanted to touch on it. Undoubtedly, they told him, you need to have emotions like a statue up there. It's also been a little while, and also, maybe he hated her. But he's glad she hung herself, or maybe he's glad he killed her and looks like he's getting away with it. I don't know. Um, but generally speaking, when you're in trials like that, you're told, I tell my clients, you write, you do things, you look up, like you don't do it like Amber, but you kind of just keep your emotions out of it because the jury clues in on that. Platinum, I'll be there in like 1 minute, but yeah, we can do that in the meantime. Yes. Sweet Tooth, you're right. He could be just numb to everything now at this point. I mean, can you blame him? I think the jury is right. Give me 1 second. I need a Can you guys hear me? I didn't see if anybody responded yet. Hopefully it's not as roboty right now. Anyway, I'm going to say it. For Law Nerd Clips 199, thank you for the super chat. I appreciate the support. Money to free you from the bots. Thank you very much. What I was saying before, guys, is with these juror questions, sometimes, and I've said this before, sometimes at trials, you can get a feel for what they're focusing in on, what they're buying, what they're not, what they're not buying, what side they're leaning towards. These jurors are focusing in on, I think they're focusing in on not guilty, but I'm not 100% sure. Because they're focusing in on like the toes, the feet, the shoes being. I mean, it was a skeleton wearing shoes. Like it's not gonna keep wearing the shoes if you move it around. I understand what they're trying to look for, but I don't know if they're looking at the right things necessarily. So, well, I could be entirely wrong, but I'm just, kind of like Ed Sheeran. I'm just thinking out loud. Thinking out loud. It's just, it's a little hard to put my finger on right now, And the water bottle, I mean, the toxicology would be important, except you don't know her toxicology. So that water bottle is pretty full. So did she even drink out of it? And even if she had drank out of it, how, would she have been intoxicated? Like, would it have been a fatal intoxication, an incapacitating amount? We don't know because all of her juices leaked out of her as she was rotting away. So I don't think that's really going to do too much for everybody at this point. And I have a phone call to take, so I got to take this quick, guys. But I will see you guys in a second when I get back to my office. And I'm going to switch this back over to the main screen. Real quick, I can ask this. I'll save this, Matt. That's a good one. Oh shit, Matt. Matt, I didn't mean to block you. I'm sorry, Matt. My bad. This StreamYard thing does not work well.
Thanks, have a seat. You may call your next witness.
We're missing the other half of the aisle.
I think you're ready to go.
Judge, apologies.
Your Honor, the state will call Dr. Mark Hickman. Raise your right hand, please. Do you swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Good morning.
Good morning.
Can you please state your name?
It's Mark Hickman.
And can you spell your last name?
It's Hickman.
And how are you employed?
I'm currently a family doctor in the Delaware County Coroner.
And as a family doctor, did you receive education and training to perform that role?
I did.
And can you summarize that for the jury?
I went to Miami University for undergrad, Ohio State University for medical school, and did my family practice residency at Grant Medical Center in Columbus.
And did you graduate with a medical degree then?
I did.
In what year?
1998. Completed my residency in 2001, and then I'm board certified in family medicine.
And when were you board certified in family medicine?
That was 2001 as well.
And are you continue your board certifications in that specialty of medicine?
Yes.
So you are a doctor.
Correct.
And you indicated you practice in Delaware County.
I do. I have a private practice here in Delaware.
And for how long have you had that practice?
Since 2001.
And you still have that practice today.
I do.
And then your other form of employment is what?
The Delaware County Coroner.
And how do you get to be the Delaware County Coroner?
You have to be a medical doctor, and then it's an elected position.
It is an elected position.
Correct.
And what year did you first become the Delaware County Coroner?
2005.
And as the Delaware County, you continued since then, excuse me.
Correct.
And as the Delaware County Coroner, do you perform post-mortem examinations or autopsies?
I do not.
And why is that?
That is done by a board certified forensic pathologist. So there are 4 autopsy centers in Ohio. We currently use the Montgomery County Coroner.
But you obviously review the findings in your role as a coroner.
That is correct.
And have you received any other certifications or specialties regarding your experience as a doctor?
From a coroner standpoint, I'm certified with the American Board of Medical Death Investigators.
And what does that entail?
It requires over 600 hours of scene-related and death-related investigation.
And is that continuing? Do you have continuing education requirements?
We do.
And what are those?
You have to maintain so many hours. I think every 5 years to get recertified.
And that includes re-attending training?
That's based on hours. We also do annual coroners conference, which are educational conferences annually.
And have you attended those since you've been the Delaware County Coroner?
I have.
And are you up to date on your certification or required experience, and can you please say it again, National Medical
So
Investigator?
it's the American Board of Medical Death Investigators.
Thank you. Are you up to date on that training and certification?
I am.
All right. Your Honor, at this time, I would tender Dr. Hickman as expert as a medical physician.
This is a medical position.
Okay.
Now, I want to talk to you a little bit about your role as the Delaware County Coroner. You indicated the only requirement to serve is that you be a medical physician or a medical doctor.
That's correct.
And you have that qualification.
Yes,
And you do not perform autopsies because you're not a forensic pathologist.
correct.
And has it been that way ever since you became the Delaware County Coroner in 2005?
It has.
If you know, has any Delaware County Coroner performed autopsies?
Not to my knowledge.
And so when did the Delaware County Coroner's Office or you start asking other agencies to perform the autopsies for Delaware County?
I mean, not in the modern era has there been a local family doctor that's done autopsies. So when I started in 2005, I know my predecessor, they used Franklin County. We've used Franklin County in the past. Again, currently use Montgomery County, but it's probably been a long time since we have not used an outside autopsy facility.
And how often or how long, strike that. How long has the Delaware County Coroner's Office used the Montgomery County Coroner's Office to perform autopsies?
I believe it's been the last 7 years, approximately.
Now, who determines if a postmortem examination on a body in Delaware County will be done?
Do you mean an autopsy?
Yes.
Yes, I do.
You do.
Correct.
And when there is a dead body in Delaware County, does your office respond to the scene?
Yes.
Do you personally?
Not always. We have a team, so we have investigators. Sometimes it depends on who's on call. Sometimes it's me. A lot of times it's an investigator. Someone from our office will go to the scene.
And there are deputy coroners with Delaware County as well.
Correct.
And they have to be medical physicians as well.
Deputy coroners have to be medical physicians as well.
But you're the head coroner, so to speak.
Yes.
All right. Now, when there's a dead body in Delaware County, and you make the decision on whether or not to send it to Montgomery County Coroner's Office.
Yes.
All right. What influence or impacts your decision to do that?
Obviously, whenever, in a case that we accept jurisdiction to, obviously there are people who die at home that have a physician, so those cases don't come to the coroner. They report all deaths. However, in cases that we accept, we will go to the scene and do an investigation, which means that we'll talk to family, look for medications, we do an examination of the body, and then based on that information, if we have an obvious cause of death, then there are instances where we don't do an autopsy. I think typically about 50% of the cases that we take jurisdiction on end up going for autopsy. The autopsy obviously is an internal examination. They do toxicology, slides. So it's a much more complete exam. So if we feel like that is necessary to determine the cause of death, then we will order an autopsy.
And when you are requesting an autopsy, how does that process occur?
So we contact, in this case, Montgomery County. We'll place a phone call, and then we have a form where we'll fill in information about the decedent, any information from the scene that we feel is pertinent, and then it's an autopsy request form, and then we have to verbally call and report the case as well.
And all of that takes place over a short period of time.
Yes.
All right. And then once that decision is made, the body's transported to the Montgomery County Coroner's Office?
Correct.
Do you transport it?
No, we use a transport service.
Now, as the Delaware County Coroner, what are your responsibilities as the coroner?
Primarily, it's to determine the cause and manner of death and complete the death certificate, as well as to work with the family.
And in doing so, you rely on the opinions of others.
Correct.
Because you are not a forensic pathologist.
Correct. Yeah, in cases where we require an autopsy, then we use the autopsy as a guide as well.
But if you did not order an autopsy, is it your responsibility to give a cause or manner of death?
Yes.
And you can do that based on your training and experience.
Correct.
When we use the words cause of death, what does that mean in coroner's world?
It's the ultimate, what initiated the death from a physiologic standpoint. So what happened to the body that caused the death?
And what do you rely upon in rendering a cause of death?
So again, we'll go to the scene and examine the body and do an external examination. There are cases where we don't do autopsies, where we draw blood and do toxicology. We obtain medical records if they're available. We'll talk to family. In certain cases, there were people actually in the home when the person dies. So we gather all that information, and sometimes that's enough to render a cause of death.
And if an autopsy is performed, does that come into play in your decision regarding a cause of death
Yes.
or in formulating your opinion?
Yes.
And when we use the word manner of death, what does that mean?
So the manner is whether it's natural, whether it's accidental, whether it's a suicide or a homicide. So it's really the classification.
And what do you consider in forming that opinion?
Typically, once you have the cause of death and the circumstances surrounding the cause of death, then you can classify it as to which manner it was.
And what are the circumstances that you consider?
I mean, again, it's really the whole picture. It's the person's past medical history, the events occurred around the time of the death, the body itself. If we do an autopsy, the autopsy findings, toxicology.
And I just want to be clear. So when you rely on the autopsy reports and the opinions of others, do you set aside Dr. Mark Hickman's experience as a physician?
No, I mean, really all those things, I mean, we take and process all of them and use them as the whole, really.
And so you rely on your own training and experience as a medical physician since 2001.
Yes.
Now, you indicated you have a family practice. How many patients do you usually see?
Typically about 25 a day. So our patient panel is probably about 2,500 to 3,000 patients.
A day?
No, that's the whole group. I mean, my practice has about 2,500 to 3,000 patients. So we see about 20 to 25 a day.
Sorry,
It's
I
okay.
misunderstood. And you've been doing that and seeing that number of patients since 2001.
Yes.
Now I want to turn your attention now to a body that was located on September 16th of 2020. And you're familiar with that.
Yes.
And who went to the scene that evening when the body was reported to your office?
It was Charles Carlson, who's our lead investigator.
Did you go to the scene?
I did not.
And from your understanding, after the scene was processed, what happened to the body or the remains that were found there?
They were transported to Montgomery County.
And for what purpose?
For an autopsy.
And at some point, is your understanding that those remains were transferred to the Ohio State University to a forensic anthropologist?
Yes.
And were you part of that decision?
Yes. I mean, Dr. Harshberger, who's the Montgomery County coroner, based on the condition of the body, felt that a forensic pathologist would be helpful and had a relationship with Ohio State. So he asked us whether it would be okay to use them, and I was fine with that.
And while the remains were at Ohio State University, did you have contact with the Dr. Agnew or Amanda Hardin while they were there?
We did.
And what kind of contact?
We actually visited the facility as they were in the process of evaluating the skeletal remains. And spent about 2 hours one day there.
Do you remember when that was?
I believe it was early December of 2020.
And did you get to see any of the remains yourself?
I did.
And did you observe anything about the remains while you were there?
At the time, they had found fractures in the hyoid bone of the neck and evidence of fractures in the thyroid cartilage, which is in the same area. Those were the two main things, I believe.
And so when you learned in December of 2020 about the hyoid fractures, at that time, did you observe where they were?
I mean, they had the bones displayed, and you could see where the fracture sites were.
And how many fractures to the hyoid bone were there?
I believe there was one on each side.
Would you call that bilateral?
Yes.
And then in December, did you get to observe the thyroid cartilage as well?
I don't remember. I know the hyoid bone was the main focus at that time.
And then after that time in December, did you have any more conversations with the forensic anthropologists until their report came out?
I don't believe so.
And then did you receive a copy of their report at some point?
Yes, I believe that was in January of 2021.
And upon your review of their report, did you learn of the additional fractures?
Yes.
And where were those reported?
So I believe those are the superior thyroid cartilage, as well as the hyoid bone was reported as well.
And what were the fractures reported, or the number of fractures reported to the thyroid cartilage?
There were two, one on each side.
And so a total of 4 fractures.
It's the same.
What was the total number of fractures?
4.
After OSU authored the report and you reviewed it, did Montgomery County Coroner's Office issue an autopsy report?
They did.
And did you review that?
I did.
And after reviewing that, did you form an opinion as to the cause and manner of death of Emily Noble?
So by that point, we had reviewed medical records and had the forensic pathology report, and now the Montgomery Coroner's report. Obviously, we reviewed the scene photos. So at that time, in my recollection, I felt like based on the trauma and the circumstances as to how we found the body, that it was highly unlikely that it was suicide. And in my mind at that point, it became a homicide.
And that was after considering, again, like you said, the whole picture.
Correct.
And then after that, though, was an expert consulted?
Yes.
And who was that?
It was a Dr. Smock.
And what did you understand him to be an expert in?
I believe strangulation.
And had you worked with him before?
We had one other case, yes.
And was that also a strangulation case?
It was.
And while the expert was being consulted, did you have any conversations with Dr. Smock?
I did not.
And at some point, though, he authored a report.
Yes.
And did you review it?
I did. I believe that was in May.
Now, going back to January and indicating that you believed it to be a homicide, what was it about the observations, either from the scene or the injuries, that led to that conclusion?
No, he testified he wasn't at this.
But he's testified he's reviewed the scene materials. I can rephrase it.
Rephrase.
Based on your review of the scene materials, I think you also indicated medical records.
Correct.
Your scene materials include photographs,
Yes,
any information obtained from witnesses,
yes,
medical records,
yes,
and the postmortem examination of Montgomery County Coroner's Office,
yes,
and the report of Dr. Agnew.
yes.
What from that whole picture led you to that conclusion?
So again, I mean, and I don't know what you've seen, I mean, but
I think this witness doesn't have the qualifications to answer that. He's been tendered as a medical expert in the medical field. I think his death certificate speaks for itself. I don't think he has the qualifications to further opine.
Well, he's legally responsible under Ohio law to determine whether it was natural, accidental suicide, or homicide.
Well, and I think he testified as to what he's relied upon,
But
and
he-
that's why he said what he said. Or maybe it's an asked and answered, but I guess.
Well, I appreciate that, but and he probably has asked and answered that, but I'll let him respond to the question.
so again, I mean, if you've seen the scene photos.
Go ahead. I'm
That's
sorry.
okay, thank you. If you've seen the scene photos, she's kneeling down, there's a thin cord around her neck. And it's tied to a small tree branch. So once we have bilateral fractures to two areas of the neck, I believe that is not consistent with leaning forward on a cord in the position of the body. So at that point, my belief again was that there had to be significant force placed to cause those fractures in the areas that they were in that were not consistent with how the body was found. And so since it wasn't suicide at that point and it wasn't clear it wasn't accidental, I believe again that the amount of trauma that would have to happen to cause the fractures and death would have to be inflicted, therefore it's a homicide.
Now, you indicated that as part of your responsibilities, you have to issue a death certificate.
Yes.
I'm going to show you what's been marked as State's Exhibit 165. Are you familiar with that?
Yes.
And what is that?
It is the death certificate for Emily Noble.
And is that, well, it's a certified copy, so it doesn't matter. Is that, though, to the best of your recollection, the death certificate that you filled out for Emily Noble?
It is.
All right. Permission to publish to the jury? One moment. May I borrow your white out? I'm sorry. Over there. Thank you. All right, again, the name at the top of the death certificate.
Emily Ann Noble.
And you indicated the date of death. What is that?
So typically, we will list that as the date that the body was found, given that we didn't know the actual date of the death.
So you put other.
Correct.
What is this?
It was the date that the death certificate was filed.
What is this?
Again, it was the date that the body was found and therefore pronounced.
So it was a year to the day that you issued the death certificate from when her remains were found.
Correct.
Did you do that on purpose?
No.
And what took so long to get the death certificate issued on September 16th of 2021?
So once the reports were in January, and then the final report was Dr. Smock's in May, at that point, in my mind, knew I was going to fill this out. The problem was, and this is a technicality, but basically because she was at Ohio State, for us to file the death certificate, it actually has to be initiated by a funeral home. And so, again, because she was at Ohio State, there wasn't a funeral home involved. And what it boiled down to is we couldn't find anybody at Ohio State that would initiate the death certificate. So it took from end of May, early June to September to actually get the okay for our office to initiate the death certificate, which we've never done before. So it was really more of a procedural problem.
So when you say you've never done before, meaning you've just never had that paperwork nightmare before?
Well, in the past, I mean, we've always had a death certificate initiated by a funeral home. And in this case, there was no funeral home. So we had to work through the channels at Ohio State, and just couldn't find anybody who would do that. So finally, long story short, they said, well, in this case, the coroner's office can actually initiate the death certificate. And once we knew that, then we filed it.
Let's review the findings. What is this?
It's the manner of death listed as homicide.
And that's the one you indicated where you have 4 to 5 options?
Correct.
Whoops, that's terrible. What is that?
That's the cause of death listed as multiple injuries of the head and neck.
And this, box B.
Again, it says manual strangulation, which is, again, the manner or the cause of death due to, so it's multiple injuries of the head and neck due to manual strangulation, and that comprises the cause of death.
Thank you, Your Honor. Nothing further.
Morning. Diane Menashe on behalf of Matt Moore.
Oh, here comes Diana.
To meet outside just briefly at the break.
Yes.
Here comes our girl.
Go through the things that you did in this case and mark a few exhibits. You said several times during your testimony that as part of the investigation of your office is that you obtained medical records.
Correct.
And fair to say that your investigator, Charlie Carlson, helps with that process of issuing subpoenas and getting records.
Yes.
And through that process, you obtained Emily Noble's Ohio Health medical records, did you not?
Yes.
As a family doctor, tell the jury what osteopenia is.
So osteopenia is a term for thinning of the bones. So if anyone's ever had a bone density study, there are several of those. There's normal, which is basically compared to a 16-year-old female, what normal bone density is. And then after 16, most women actually will lose some bone density over time. Osteopenia is the first level of not normal. And then there's osteoporosis, and it's based on standard deviations from the norm. So osteopenia is kind of that between normal and osteoporosis.
And it's a condition with respect to bone density or bone strength, is it not?
Correct.
And you talked to the jury in your direct examination about how you reviewed the medical records that were obtained in this case.
Correct.
And so I'm showing you what I've marked as Defendant's Exhibit LL from her Ohio Health records. let me make sure on top here, just so you can identify it. There's an affidavit on top here. Through the course of your work, are you familiar with this process of when you subpoena records, the medical entity will send the records with an affidavit attached, such as this?
Yes.
And you have.
This
the
is weird. I don't have it on my
affidavit, this page
camera.
one, and it's notarized on the bottom here. Do you see that?
Yes.
Want to draw your attention to it's technically page 68 of 71 in the records, but it's marked as page 1 here. Let me zoom in. Would you agree that this record is from 2008, November of 2008?
Yes.
And so if it's 2022, this, let me measure from 2020. 2008 would have been 12 years before 2020.
Correct.
So if a woman was 52 in 2020, she would have been 40 when she presented to the doctor's office in 08.
Correct.
I want to scoot it up here. In 2008, Emily Noble's medical records indicate, do they not, that she's there for a follow-up bone density test, and that she was found to have moderated osteopenia. You see that?
Yes.
She's taking calcium and vitamin D, and then her risk factors are her small frame. And what are those 3 letters for?
I'm sorry, which 3?
I believe it's family medical history, but I was deferring to you.
Sure. I think that sounds reasonable.
And
Mhm.
it indicates that she's a smoker.
Correct.
Those are increased risk factors for the bone issues that she's diagnosed with.
Correct.
There. And you're aware, I presume, that the bone density test in 2008 followed, and you're aware from the medical records that you reviewed in this case, followed from a break of her ankle, which required surgery.
Correct. I believe that was in 2007.
Yes, and then after that break in her ankle in 2007, she had another break in her elbow. Do you remember that?
I believe she had a rib fracture. I don't remember the elbow.
She had a rib fracture.
Correct.
And in the surgery for the ankle, if you recall, she had pins. Actually, she had to have some hardware put in there.
Yes.
And then also, as a result of your work in this case, and I'll just show you, you obtained, was it your office that obtained the mental health records, or was it Westerville Police Department?
I believe we obtained those.
Okay, and just showing you what's been marked, if I can, I'll just have you identify those as well. Defendant's Exhibit S. There's an affidavit on the top. Sorry to crowd the box.
Oh, it's okay.
Do you recognize that back cover sheet and
Yeah, from Serenity. Yes.
Serenity?
Mhm.
And I asked you these questions because you talked about the work that you did and how you came to the conclusions that you did. You know, do you not, that Emily Noble was going to counseling as of August of 2019.
Yes.
And that her presenting problem was that she had recently suffered a tragic loss and was traumatized by the death or loss. The presenting problem went on to say,
Objection.
sure, let me show the records. Sure. Well, you reviewed them in the course of your findings and conclusions.
I did.
So I just want to go over that. This parent.
Objection, may we have a sidebar, please, regarding these records, Your Honor?
Okay. Well, wait a second.
Let's go back
You fucking.
where we were. Her counselor, based on your review of the records, and tell me if you recall, her therapist, her clinician was Angel Kessler.
Correct.
And this is the first record as 2 of 43. Do you see that up top?
Yes.
And presenting problem is it not, that the client reported she'd recently suffered a tragic loss and is traumatized by the death loss. The presenting problem goes on to say she reported she has difficulty focusing, making decisions, feels sad, empty, guilt, has sleep disturbance, early waking, trouble falling asleep without medication, strange lucid dreams, easily startled, intrusive memories, loss of interest in activities, loss of energy, and paranoid about her husband's well. Do you see that?
I do.
And then the counseling records go on. She goes to counseling a number of times between August and then let me get to this. She stops counseling altogether, does she not, at the end of 2019?
I believe January of 2020 was her last visit. Is that right?
We were discussing this earlier, we being counsel. The last record in the group of papers indicates January 8th, 2020, and it says patient discontinued services. Is that right?
It does.
I just want to make clear, though, for the jury when they have it, that it appears the presenting problem, right, is the same presenting problem. On August 16th of 2019 and on January 8th of 2020. Do you see that?
I do.
Happy to approach if you ever want me to. And those records were 43-page facts.
Yeah, I reviewed all those visits, yes.
You what?
I said I read all those visits, yes.
Okay. And then I just want to make sure then that you also read the counseling notes from August 16th, where she stated she was depressed in 2021 and had counseling and didn't find it helpful. She attended grief counseling after her first husband died in 2011. And then the trauma history. The client's son died by suicide in July of 2019 and was still in shock, starting to experience depression. And you remember reviewing that in the work that you did in this case?
I do, yes. And I think there were also, her family doctor had records that kind of alluded to that and talked about treatment as well.
And those were in her medical records. I think of Dr. Renna. Does that sound right?
I believe so.
Renna Henriquez. Just so we're clear on the timeline, and also, let me back up. You did not issue a report in this case?
I'm sorry, what kind of report?
Any report, other than the death certificate?
Correct. I mean, we have an internal coroner's report, but our official report is the death certificate.
And you reviewed the internal coroner's report. Do you not?
Yes.
And in this case, the internal report is 4 pages long. Let me know if I need to approach, if I may.
You can.
Yes.
And that appears to be the internal report.
Correct.
And it's sort of, I think on direct, you were asked about sort of the head guy in the office.
I guess.
You review the work that's done by others, and certainly you review the internal report. And if there's any inaccuracies or addendums, you would certainly make sure that those were made.
Yes.
So just want to go through the timeline here. The remains were found on September 16th of 2020.
Correct.
You were not at the scene.
I was actually out of town that week, so I was not physically in Columbus.
So the whole week you were gone. Charlie was there though.
Correct.
And Charlie is not a doctor.
Correct.
He used to be I think he used to be a cop or a detective.
Mm-hmm.
And he's worked for your office now just, I think, 2 years since 19 maybe?
I think it's more like 3, but yeah.
Okay.
Mhm.
September 16th, remains are found. Remains are, they're taken to the Montgomery County Coroner's Office, who does an initial intake, takes some photographs, and then on October 2nd, the remains are taken to Ohio State University.
That sounds correct.
And then you testified that sometime in December, you went to Ohio State to look at and you met with Dr. Agnew and Dr. Harding. Do you remember that exact date?
I believe I have it written down if I'm able to look at.
Absolutely.
I believe it's early December, like I said. Was it on here?
Well, you tell me. I have a sticky note copy.
Yeah, if you don't mind me looking here, I have it written down on it.
Sure.
Thank you. I believe it was December 2nd. This is what my note says.
Okay. And because I don't see a date in the report.
I know that it's in here.
Okay.
Mhm.
That was a significant event, going to Ohio State to meet with the anthropologist, I presume.
Let me look at this. I don't know that it's not in here that we went, but. Yeah, it's not in our timeline. I mean, really, we had never been to the lab, and part of it was to go down and see the lab, and then at the same time, they were in the process of processing the body. There was no official report done yet. So it was kind of a tour and a preliminary look at what they were doing with Miss Noble's body. So, but you are correct, it's not in here.
There was a tour and a look at what they were doing with the body. And I noticed on direct, I wrote down that you said the hyoid was the main focus at the time. Do you remember that testimony on direct?
Yes.
And when you were asked about which fractures you saw, you indicated the hyoid bone, that you saw the fractures in that.
Yes.
And you were asked about the thyroid cartilage, and that's when you said, and I quote, the hyoid was the main focus at the time. Do you remember that testimony?
I do. And I don't remember whether at the time they pointed out the thyroid. I don't know if they hadn't been there yet, but at the time, that was the first time that the hyoid bone was clearly broken in 2 places. That's what I remember of the visit.
And I'm just going to go from December 2nd because that's your testimony today. So that was on December 2nd.
Mhm.
You would agree with me that at no point when you were asked on direct about what fractures you saw or didn't see, you didn't mention the left maxilla in your testimony on direct, correct?
Again, the whole body wasn't processed, and I don't recall that one either.
And so that is in December, your memory is early December. And then about 30 days later, specifically on January 11, 2021, Dr. Agnew issues her report. Do you remember that date?
That's the date on a report, yes.
Yes,
Mhm.
it is. And then after that, 11 days later, the Montgomery County Coroner's Office issues their report incorporating Dr. Agnew's report. Is that
That's
fair to
correct.
say?
Yes.
And the January 22nd report from the Montgomery County Coroner's Office indicates head and neck injuries as the, let me get the report. One moment. Thank you. Showing you what's been marked, the state's exhibit 152. They list in their report as the cause of death, multiple injuries to head and neck. And then in the comments, they're quoting and relying upon Dr. Agnew's report. You would agree with me?
Yes.
And in fact, again, on page 3 of their report, the entire page is just a cut and paste from Dr. Agnew's report.
Correct.
And then on March 9th of 2021, I'm sure that you're aware that your investigator, Charlie Carlson, attended a Zoom call with Dr. Smock.
Yes.
And,
I was not present on that call.
okay, but,
Yeah.
and then I know you testified to that you're kind of that,
Sure.
that you're at the top, and the work that others do below you, they certainly report up, right? And you're obviously in your capacity as an elected official that you're keeping apprised of events that are happening in the investigation in real time, right? So Charlie meets with Dr. Smock in March of 2021, and then Dr. Smock issues his report on May 27th of 2021. Does that date sound right to you?
Yes.
And that's the first time in that report, Dr. Smock's report, that we ever see the words manual strangulation with respect to this case.
On an official document?
Yes. Well, if we want to call his report an official document, but on any expert report, it's the first time you see the words manual and strangulation. That comes from Dr. Smock.
Yeah, it's not on Amanda's report, and it's not on the coroner's report, if that's, yes.
That's in May 27th of 2021. And then on September 16th of 2021, so May, June, July, August, you issue the death certificate.
That's when we officially issued the death certificate, correct?
That's the date on the death certificate.
Well, as I explained, it took almost 3 months to get to the point where we could issue the official death certificate. So if that had been in a funeral home, the date on it would probably be closer to June 1st. But you are correct, that's the date on the death certificate.
And I was just going to ask you, but I think you just answered it. It would have been closer to June 1st, which is still after Dr. Smock's opinion and report is delivered to the state of Ohio.
Yes, I mean, that was part of our evidence.
I want to mark an exhibit off topic, but it's what you and I talked about outside.
Sure.
Showing you what the mark is, defendant's exhibit KK. I just want to show it again to you. You recognize that as well, what we talked about in the hall? I'll show it up on the screen.
That's okay.
Your Honor, there's no objection from the state regarding this document.
Thank you. Thank you. Defendant's exhibit KK. It's a document, and I gave you the opportunity with the prosecutor there to review this prior to your testimony. This is a controlled substance examination. Would you agree with me on that?
Yes.
And it indicates on the report that one sealed plastic tube containing a peach liquid was submitted for testing.
Correct.
And then if we go to page, it's actually one of two, but it's technically the third page. That peach liquid, the results are what?
It says the specimen contains 6.3% alcohol by volume.
The specimen contains 6.3% alcohol by volume.
Correct.
And then I want to just make sure it says here is to just up here again to orient you. Sorry to go back to this, but I just want to be clear about this. It's received sealed specimen bottle containing liquid. Do you see that?
Yes.
Nothing further. Thank you.
One moment, please.
Oh, I'll keep this.
asking you about moderated osteopenia. Is that a natural process in women?
Over time, yes.
Anything abnormal about that from your review of Emily's medical record?
No, the other thing, I believe that she was actually on medication for a while, which tends to slow the process down. And she was on Boniva, which is a bone medication. From a review of the records.
Come on in.
So,
I think somebody knocked,
your
maybe.
experience, what Emily was, experiencing through the moderated.
Is Stu gonna go on Friday still to that depot?
Not this Friday, no. No, it got moved to the 8th. I'm sorry, he didn't tell you.
Also
Okay.
asking you about,
No, we're not.
This is all garbage.
therapy.
Yes, it is.
Was there anything?
Thank
in
you.
the
No, he didn't tell me. That's
therapy
why I was asking. So I can
Sorry,
know.
yeah, no, he didn't. We're doing it September
that
8th.
led you to conclude the manner of death was suicide?
He already checked his schedule.
Yeah, well, he's.
Well,
Hold on.
shit.
Actually, I'm gonna put up one of the visits from October 30th of 2019. This is getting towards the end where we know services were terminated, right?
Correct.
Just go ahead and report what Emily told the therapist then.
It says, client reported she was feeling good but tired. She stated she was sleeping better. Work has been going well and that 6 hours worked out well for her transition back to work. Client reported she was happy to make new connections at work as well as connect with old friends, coworkers. Will wear headphones/earbuds if she needs to block out distracting sounds and is easing back into her workload. She stated is maintaining her yoga and meditation practice and feeling more confident in her husband's ability to cope and grieve. Client shared about her other interests that bring her joy, peace, and balance, such as gardening and eating healthy.
And then again, November 4th of 2009. Whoops, here, I'll put that up there. November 4th, see that at the top?
Yes.
All right. And again, what did Emily report to the therapist then?
It says client reported she was feeling tired after working and worried about her husband. Client reported she is functioning well as evidenced by improved ability to sleep more restfully, manage emotions and reactions. Concentration has improved. Client stated she continues to use her coping skills and feels confident in her ability to heal herself through clean eating, clean water, yoga, meditation, nature, and connecting with others. Client reported she also feels ready to return to full-time.
Nothing further.
Yes, Your Honor, if I could just have a moment. You're trying to find it, but maybe you remember it because she stopped taking Boniva. Do you remember that being in the records?
I believe it was there, and then it kind of disappeared when she was at her family doctor. So there wasn't a record that she was continuously on. I think she was on vitamin D and calcium.
Then let me give a moment, Your Honor. If I could. We can't search term because it's a PDF. The records from showing you, the pages aren't numbered, but do you see here? They are, Your Honor, thank you. Just to orient here, the date of the visit was October 14th, 2013. Do you see that?
and removed medications at the bottom. What does it say there? Thank you. Nothing further.
All right, ladies and gentlemen, any questions for this witness? Please prepare them and follow the usual routine.
All right, guys. Sorry. Yeah, and I apologize for that. Yeah, that is a good question, Sky Queen. How many times can you move the skeleton before things start breaking? Yeah. So what broke, and how do we know what broke then? I mean, they can tell some of that, but they might not be able to tell all of it. And this was their star witness. This was the county coroner. In some counties, he'd be known as the medical examiner, but in Ohio, they are still coroners.
Cahill.
Well, that sucks. You guys don't even have juries. Oof, that's not fun at all. That's no good.
Dr. Hickman, I have a few questions for you, and they may bounce around a little bit, so not in any particular order here. Do you know, as part of your investigation, at the time of her disappearance, May 25th, was Emily Noble on any other medications?
I have her last family doctor note in here, which would probably be the most up to date. And our report, which should list medications.
If you haven't
if I
look to answer the question, feel free.
Okay, great, thank you.
And of course, follow-up question is, if there were, could you share what they are?
Sure. don't believe we've had any medications from the home. Her last family doctor note was dated October of 2019. So that would have been about 6 months prior. And at the time, I believe she was taking Klonopin, which is a sleep medication.
Klonopin will put you out.
And that was the only documented prescription medication. So essentially a sleeping pill.
Sleeping pill.
Correct.
Okay. Next question is, there was some testimony that she was taking counseling. Does taking medicine such as counseling improve bone density?
It'll stabilize it. So I think if this osteopenia is important, the one thing to understand is, so bone is kind of like, it's not solid. It's what we call matrix. And so over time, 16 is kind of the maximum peak bone density for women. It's typically, when we measure it, it's at their long bone. So hip bone, spine, so vertebra. And then over time, that matrix will kind of thin. And it's a different process depending on nutrition, smoking, those sorts of things. So there are medications like Boniva, which prevent the breakdown of bone. So it slows that process. Calcium is the building block for bone, and vitamin D is what helps put bone together. So vitamin D and calcium are what we call bone stabilizers. They do not make bone grow back, but it slows down the thinning of the bone, if you will, whereas the other medications like Boniva actually will slow down the bone loss.
Now, you testified about the osteopenia and its effect on bones.
Yes.
Does that condition impact the thickness of the bones in your face, nose, and cheek?
So that's a great question. And that's the other piece is when we study bone loss, it's typically what we call trabecular bone. So again, it's long bones, arms, legs, your vertebra, which form your spinal column. As far as I know in bone, and again, I'm not a bone expert, to my medical knowledge, the bones in your neck and face are not really trabecular bone. And so they typically, I don't believe, undergo the same process. And bone that is cartilage when it starts, like thyroid cartilage, that then turns into bone as you get older. Again, I don't believe in the report when they looked at the bone, it showed that that type of bone had shown that it was basically thinning.
Thank you. And final question is, we went through a report about the testing of the contents of the bottle with an ABV. The question is, would the contents of the bottle have been compromised after being left for so long before testing?
Yeah, I don't know that I can answer that.
Questions from the state?
No, yeah, thank you.
Defense?
If I show you what's been marked as Defendant's Exhibit LL, I believe it's the last entry in the Ohio health records. And this is in response to the testimony with respect to medication. Reason for visit is medication management. I'm sorry, it's page 1 of the entire group. It appears to be the last office visit documentation that you got from Ohio Health. Does that sound right?
Are you okay if I compare it to what I have in here?
Sure, and I'm also happy to approach.
Let me just see, because I have these over here, guys. So under the progress note, yours says October 21st. Is that correct? Or if you look at clinical notes,
Yep.
I'm sorry. Yeah.
Visit date is right there.
October 21st, yeah. So
Yep.
that's the last one that I have as well.
Okay, so I just want to go down here with respect to medication so that we have the complete picture. We've got the medication management reason for the visit is the difficulty falling asleep, depression, anxiety. And this is in October of 2021. And then I want to go here with respect to the medication. patient taking Klonopin at night along with melatonin and Benadryl at times. Do you see that?
Yes.
And I'm happy to.
So melatonin and Benadryl obviously are both over-the-counter medications. So
Right.
again, okay.
No, I understand that. I just want to be complete about the medications that she was taking,
Sure.
even if they were intermittently during that time period. And that's the last medical record that we, from a family perspective, that we have from her.
Correct.
Thank you, Your Honor. Nothing further.
You may sit down, sir. Thank you very much.
Thank you.
Ladies and gentlemen, we've reached the hour for our midday break, so I think we will do so. Let's take an hour and remember the court's admonition over the break. Have a good, relaxing time.
Okay, guys. I don't know what's wrong with my thing right now. I'm sorry about that. My camera on my laptop is shitting out on me. But I wanted to get to these real quick. I know they were done earlier. Law Nerd, once again, thank you for your super chat. But 10 Romanian Lou from Blocking Matthew. Thank you, Locknav. I appreciate your super chat and your support. Thank you very much. Yes, he got unblocked, and yeah, like I said, that was an accident. Matt, you had a question, though. As a defense attorney, do you change your strategy? Example, calling less witnesses when the prosecution's case seems to have gone badly for them? Yes. Yeah, I've had cases before where, like, I had a whole thing. I had witnesses ready to call, and we decided not to call them. Or you only call one or two. Kind of like Dr. Husel's case. They had a whole set of experts and witnesses they were going to call, but they ended up only calling the one. Why? Well, because their case was going so well. So it does happen that way at times. But yes, you have to be flexible and adapt. In case you guys are wondering where you want to find love, I guess you can go there. So, I've watched this, and I am not convinced at this point that anything. I know the doctor did his best, but it wasn't that good. At least to me, not very good. You want to make sex. Lots of Bobs and Vegana. Yes. Always Bobs and Vegana. Always, always. Somebody asked us earlier. They had wanted to comment about the painting in the background. So it's a painting of the women of justice, but if you look closely at it, I did a little bit of additional work to it. So I'm going to put up a poll now. Curious to see where you guys are thinking, especially after that. I mean, that was their dude. That was their key witness. I mean, that was. Come on. Freaking poll, let's go. Poll docs. All right, guys, I just put a poll up for everybody to take a look at. So yeah, that's. I wonder if they're going to rest at this point, or they're going to. I mean, they said they had 2 more witnesses to go. They said, and they've done them both. I think if you notice, Diane did not spend a ton of time on these 2, relatively speaking, compared to Dr. Spock. So, or Dr. Spock. So it's like, were they critical witnesses at the end of the day? Also, you have to notice she did not, when it came time to do the jury questions, neither of them really cared about the questions that were asked. So once again, I don't know if the jury's on the track of what they're thinking, how they're looking at this, or what they're going to do. It's because of that, I think the prosecution is in a bad spot. I just don't know what they think they're going to do or what's going to happen here. I mean, certainly I'm not holding out against hope. So, Matthew, and that is a correct thing to look at here. Yes, this does allow the state to, yes, that could prevent the state from bringing anybody up in rebuttal. They could do that. And that would be something they could do. And I think at this point, is it a bad idea? I don't know. I mean, she knows this better than anybody else right now, but I think she has to think the jury's not buying everything they said. So it's a good question. Aaron, I think you're asking kind of a similar question. The prosecution rests right now. Should the defense also rest and go straight to closing? I think they should. I mean, I don't know what more you think your experts are going to show than when you blew up Dr. Smock yesterday. So. So at Matthew saying, didn't they say they had an expert? Would it be bad or good for them to testify? You have to think about it this way. Your expert can crash and burn just like theirs could. Your expert might stand up there and be bulletproof and, when the prosecutor tries to shoot him down, he fights back. Sure. But you also might go down in flames, and if you go down in flames, you're screwed. You're toast. Sweet Tooth's asking, is Mathew testifying in his own defense? Not as of yet. I don't think that's ever been confirmed. So he always has the right under the Fifth Amendment, but it hasn't been stated yet, and I don't think he should. That'd be a very bad idea. D&D Princess. Yeah, I think the defense will at least want to have their experts say that he can cause these injuries to the neck. Yeah, you can do that, but I think there's already been enough introduction of that issue because then everything he talked about becomes fair game. So they might just leave it alone for now. Drake, mute your mic. I mean, okay. Law you just said women are property. Yeah. But that's it, guys. I mean, I think we're caught up for a second here. I have to take a phone call. I will be right back. All right, guys, I am back. Yeah, my laptop camera is all jacked up, so sorry, it's the best I can do. K Drake, have you noticed that Matt? K Drake saying, "Have you noticed Matt won't make eye contact with anyone except Diane?" Yeah, I mean that's probably the only person he really trusts right now, and also he was probably told to not go make eye contact with the jurors or other people. And I mean, think about it. If he made eye contact with you, you'd probably think he's crazy. So it's a good thing he doesn't. We can switch over to this guy and watch his cross if you want. Here, you know what? We'll try it. I think they come back at 1. I'll find this guy's thing. I'll see if we can listen to it. All right, so I found it. We'll switch over to this right now, and we'll see what happens here with this dumpster fire. On the part in the hearing where he starts talking for himself. Why is this not? All right, here we go, guys. Trevor Summers. Here we go.
Decision should not affect your consideration of this case. It's the standard, except that I am adding the word now. Any objection from the state? Any objection, Mr. Summers? All right, so that's the first thing I'm going to read to them, and then they will probably understand why the break was so long. We're going to go ahead and we're going to put the witness back on the stand. Ms. Mathewson, I'm going to go ahead and put you back on the stand, as we would have done if Mr. Marchese had continued representing Mr. Summers. And then once I've read that instruction, I'm going to turn to you and allow you to go to the podium and do the. Let's cross that bridge in just a moment. First.
We're going to skip ahead to when the jury comes out.
There are a shorter break today, so to make up some of that time, and yet before by an defendants in this that was introduced.
Fingers crossed it works now, Jeff.
Please.
This time I'll be publishing the McDonald's video first.
Let's just put the number on the record.
Oh, wait, I guess he's not up yet. Hold on, I got to get to the part where he starts talking. Once he does cross. All right, hold on. All right, I think it's his turn, actually.
Publish? Yes, Judge. All right. Mr. Summers, cross-examination.
All right, here we go, kids. Here we go.
Good morning, Ms. Matthews. I'd like to just,
Your voice is that microphone though. I don't know if it can be readjusted where it can amplify your voice.
is that better? Okay. Good morning, Ms. Matheson. I wanted to review the testimony that you gave here today. Excuse me. I'd like to just go through your testimony from the beginning. Starting with the evening of Friday, March 10th, 2017, your statement was that you went to Trevor's neighborhood to pick up the children, Arden, Bryn, and Grady that evening. Is that correct?
Yes.
And that was at approximately what time?
Dinner time.
Was it still light out?
Yes.
Okay. And do you know approximately how far the community center is from Mr. Summers' house?
Within the same community.
Okay. So you came to the same community 3 weeks after the alleged March incident?
Yes.
Okay. Prior to March 10th, 2017, that week, were you sick at all?
Yes.
Objection, Judge, relevance.
I'm going to allow a little bit of leeway. Let's see where it's going. What's the next question?
Let's go to the evening where I arrived. You've seen the state's evidence in the videos and the photographs as you've attested to them. Do you remember seeing a video of your neighbor's camera from their house, an evening video from 1418 Dew Bloom Road?
I was never shown that video.
Okay. Do you remember approximately what time I arrived here?
I was asleep.
Do you recall which window I came in?
I was asleep.
Do you, or could you tell us if there were any doors on your house other than the front door?
No exterior doors other than the front door, the door leading to the garage, but no other doors.
Okay. Do you remember what was in your backyard?
A swing set.
Do you remember how that swing set got there?
Objection, Judge, relevance.
Sustained.
Okay. Did your children use that swing set?
Yes.
Objection, Judge, relevance.
Sustained.
Did the children ever utilize the windows to go into the backyard?
Not that I'm aware of.
Okay. When you looked at the photos of the windows on the side of the house and on the back of the house, did you notice excess dirt in those? Would you like me to get the picture to refresh?
No.
Okay. Do you recall from any police reports or any of the evidence that you've seen how long I was at your house before you were awakened?
Judge, I'm going to object. She can only testify to what she is aware of, not what she read in a police report.
The witness can only testify to her own personal knowledge, not what she obtained from reading. So rephrase the question.
Okay. Do you know do you know how long I was at your house until you were woken?
I woke up at 3 a.m.
You woke up at 3 a.m. and you said that you were woken by water droplets.
Yes.
Okay. So that was the first moment you were woken up by water droplets.
Yes.
Okay. And you said it was dark in your room?
Yes.
How dark was it?
The only light was coming from my digital clock. Very dark.
Was that enough light to see a figure standing in a certain position in your room?
Yes.
And when you say that you were startled awake, do you know? I'm sorry, let me change that. You said then that your feet were grabbed.
Yes.
Is it one ankle, two ankles?
I don't recall.
Did you recall me saying anything about calm down, it's just me?
Yes.
Okay. Do you recall if you threw any other items?
No.
Do you recall how those items got neatly placed back on a table in a vanity?
No.
Do you recall other items that were on the end tables?
No.
Your Honor, may I publish some of the state's exhibits?
Absolutely.
Thank you. I'd like to use State Exhibit A, Set 1.
A set 1.
Let's start from here.
Actually, you need to push something to turn it to the camera. There's a button on there. I don't know, Deputy Estella, do you know what button that is to change it from the computer to the document camera? It's on the screen, I believe. Tina, do you know what you want?
hard.
We'll do that. It's above my pay grade.
Thank you.
If you want to,
It's me, Tom.
and focus, it's right there.
Okay. Let's start back with this picture here. I believe it was your testimony
Judge,
that,
we'll need to know for the record which photograph it is.
Yes, absolutely. Identified. It should be on the back.
yes, Your Honor. This is photograph Set 1, A10.
Thank you.
Can I publish?
Yes, you may.
Okay. I believe your testimony was that this screen was not there prior to my arrival.
Not that I'm aware of.
Okay. Do you believe that you put that screen there?
No.
Do you believe, so you don't know who put that screen
No.
there? Okay. This is picture Set 1, A14. May I publish?
You may.
Is that an accurate picture of the playground in the backyard?
Yes.
And did the children use that frequently?
Yes.
And you would agree that that playground and that window are directly behind the children's playroom?
Yes.
I'm at photo A21, Set 1. Am I published?
Yes.
Okay. And you said this is the living room?
Yes.
And on the evening that the children were there, do you recall where you, Brandon Grady, and Arden were sitting?
At what point?
On the evening of March 10th, when they were with you?
We were sleeping in the master bedroom, me, Bryn, and Grady.
Sorry, let me clarify for you. On the evening of March 10th, when the children were with you in the living room, Can you tell me where everyone was sitting?
I was in the middle on the closest couch. I was in the middle of Brendan Grady, and Arden was on the love seat.
Okay. Is that the same love seat that Arden went to sleep on that night?
I don't know. I was in bed asleep. I don't know which couch she slept on.
Okay. Photo 823, set one. May I publish?
Yes.
You see that one very well. Can you tell me what is on that desk against the wall?
A computer,
Anything else?
a sweater, papers.
Did that computer have internet service?
Yes.
Is there any kind of internet feed or cable feed on that wall?
I do. Not that I know.
Not that you know of?
No. It was Wi-Fi.
Photograph A22, set one. May I publish?
Yes.
In this photograph, do you see any cable or internet feed or router?
The router over in the left corner.
Okay. And do you know if you can hook a telephone to that router?
That's not where I hooked my telephone.
I'm not asking where. I'm just asking if you can.
You can.
Photograph A21, or I'm sorry, A25, set one. May I publish?
Yes.
Miss Mathewson, in this photograph is a picture of, is it the garage door?
Yes.
The front door?
Front door.
Is the key hook there?
Yes.
It's a hook, I guess, a placard that you let keys hang on?
Yes.
Do you know what key is still hanging on that hook?
I don't know.
You don't know? Okay, we'll see if we can find a better photograph of that. The walls look pretty clean and intact.
Yes.
Would you agree that in the previous photos that the walls also were clean? There's no dents, no scratches, no marks.
Yes.
Photograph A32, set one. May I publish?
Yes.
Mrs. Mathewson, is this a picture of your garage?
Yes.
Is this the condition it was in when you left the home that evening, when you went to bed that evening?
Yes.
And can you identify some of the things that are in the garage here?
Bins and boxes and things that I haven't put away in my home or storage.
Okay. Thank you. Photograph A35, set one. May I publish?
Yes.
And Mrs. Mathewson, you said that your testimony is this was a toolkit that you had kept, and this was in the same location as it was when you went to sleep that night?
As far as I'm aware, it was normally kept in that general area on the washer, or the dryer, or the shelf. But yeah, I believe it was there.
Okay. Thank you. Photograph A37, set one. May I publish?
Yes.
Ms. Mathewson, what is this a photograph of?
That's my kitchen.
This is your kitchen. And do you see anything out of order, out of place?
No.
Did you have any struggle in the kitchen?
No,
No. Did you go into the kitchen at all?
the very entrance of the kitchen to try to get to the phone that is normally right there, right where that tea thing is. It's normally hanging on the wall right in front of that.
Okay. Did you have any tea that night?
I don't recall.
Is the tea usually just sitting on the counter?
I would say normally no.
Thank you. Photograph A36, set 1, may I publish?
Yeah, and actually, Mr. Stearns, you don't have to ask to publish each one. Just identify which one you're publishing, and you can publish it right after you identify what it is.
Okay, thank you, Aaron. And Ms. Matheson, is this another picture of you into the kitchen?
Yes.
And those things sitting on the countertop there, are they in the same place that they were when you left that evening? When you went to sleep that evening?
I believe so.
Okay. They're not disorganized or thrown around or anything like that?
No.
No. Did you have any struggle near this location?
Near that location.
Thank you. Publishing A40, set 1.
That's upside down.
Ms. Matheson, can you tell us what this is a photograph of?
This is my hallway.
Okay. What is the first door on the right?
I don't live in this home anymore. I believe that's a closet.
Okay. What is at the end of the hallway?
On the end of the hallway, there's a mirror. The left side is the master bedroom, and on the right side is a small hallway.
Okay. And so, in your testimony, you said that you were brought down this hallway,
Yes.
and you said that was by your ankles,
Yes.
and at the same time you were kicking
Yes.
while you're being held by your ankles.
Yes.
Do you notice any claw marks on the walls or any lines on the carpet? Anything that would indicate that kind of a struggle?
No.
Publishing A44, set 1. Ms. Matheson, this is a photograph of the master bedroom, correct?
Yes.
Okay. As you can see, the tissue box is neatly placed on the end table. Would you agree?
Yes.
There are hangers on the bed. Do you know what those hangers were for?
I don't recall.
The pajamas on the bed, those are the pajamas you had on before you changed?
I can't tell from this picture.
It is a gray piece of fabric and a pink piece of fabric.
It could be.
Okay. Do you believe you would have gotten changed on that side of the bed?
Possibly.
Do you sleep on the right side of the bed?
I would normally sleep by where the tissues are.
Yes, on the right side of the bed?
Yes.
Okay. Do you also see two scarves on top of the hutch cabinet?
Yes.
Okay. And you see one scarf on the floor?
Yes.
And you see a belt to an outfit that you have?
Yes.
Okay. Thank you. Publishing A45, set 1. Mrs. Mathewson, can you tell me what the contents of that laundry basket are?
There's a pink sheet, there's some clothes, possibly, I can't really tell, maybe a towel.
Okay. Is that the pink sheet that you say you were wrapped in?
Yes.
So would you be able to explain why it's underneath the other clothes?
This is getting really clunky. This guy's kind of just aimlessly going.
Thank you.
Very irrelevant, I think. Elaine, thank you for the super chat.
A47 set one.
69.99 Canadian pesos. Thanks, Sean. Really enjoy watching and listening to you in the chat. Thank you. I appreciate your support.
Photograph inside your master bedroom.
Yes.
Do you see the variety of items in and around this piece of furniture?
Yes.
Do you see a large cord or a wire underneath of that?
Yes.
Did Mr. Summers or myself attempt to use that to inflict any harm upon you?
No.
Do you see any cords on top of that cabinet?
There's a variety of things on top of the cabinet, but no.
Do you see, is this normally how this piece of furniture looks? You have a variety of things sitting on top of it?
Not normally.
Okay. Can you tell me how these things got there or arranged this way?
No, they just happened to be there.
This was this way before you went to bed?
I can't recall.
Okay. Publishing A48 set one. Mrs. Matheson, this is the right side of the bed, correct?
Yes.
Okay. Do you see a variety of articles on the bedside table?
Yes.
Did you attempt to throw any of those items?
No.
No. Are they all kind of in order?
The lower shelves, no, did not touch any of the things on the lower shelf. The side table, yes, those were used throughout the March 11th. I used them to throw the box of tissues. So yes.
Okay. Is anything out of order on this table?
I mean, different than when I went to sleep.
It is different than what to sleep.
The top of the table is different than when I went to sleep.
What's different about the top of the table?
My water cup is not on the side table that I sleep with every single night. The box of tissues is not where it normally is. It's normally against the wall behind the clock.
That's it. Okay. Publishing A51 set one. Mrs. Matheson, is this a better angle for you to see the top of that dresser?
Yes.
Okay. Can you remember if this is the way things were before you went to sleep?
I don't recall.
Okay. Publishing A52 set one. Okay. Mrs. Matheson, this is a photograph of which bathroom?
The master bathroom.
And that blue cup is the one that you threw across the room?
Yes.
And that blue cup is now sitting nicely on vanity?
Yes.
Did you put it there?
I don't recall who put it there.
Did you use it while I was there with you?
I don't recall.
You don't recall? Okay. Publishing A53 set one. Mrs. Matheson, this is the vanity in that bathroom?
Yes.
The bathroom you use every day?
Yes.
Is there anything missing from this vanity?
I couldn't tell you what is missing.
Do you usually have cosmetic items, other cosmetic items?
Well, he's asking questions about items that you introduced into evidence, so I'll allow that question.
Yes.
Do you notice any of your cosmetics missing from this?
Yes.
Can you tell me which cosmetics were missing?
I cannot tell. I don't have the knowledge of what cosmetics I used 5.5 years ago.
How about your toothbrush?
My toothbrush is not there. Maybe off to the side, but my toothbrush is not there.
Okay. Publishing A56, step 1. Ms. Matheson is, can you tell me what this picture shows?
That is the master closet.
Okay. Can you identify anything in that photograph for us?
Identify a bunch of stuff on the floor, piles of clothes, random things. I can't tell you exactly what everything is.
Okay. Publishing A58, set 1. A little better close up.
Okay.
Can you tell me what else you see? Can you identify any other things in this photograph?
All I see are clothes and just random things.
Do you see any belts?
At this time, I can't see. Oh, I see some belts and good clothes.
Is this location okay?
Yes.
Do you see any scarves?
I don't see scarves in this picture.
Anything in this bag? A bunch of scarves?
Those look like nylons.
Nylons?
Yes, pantyhose.
We can zoom in a little bit.
I do not see scarves. I see socks and pantyhose.
And this one here?
Socks and pantyhose is what I see.
Thank you. Publishing A67, set 1. Mr. Matheson, what bedroom is this?
This is the kid's bedroom?
And you said this is how it looked before you went to sleep, correct?
Yes.
And the pink sheet that you saw in the laundry basket, is that the same, from the same set that is on that bed there?
I have 2 sets of pink sheets, one for the master and one for this bed. I don't know which one.
Okay, thank you. Publishing A73, set 1. Ms. Matheson, this is a photograph of which room?
The kids' playroom?
And does it look this way normally, or did it look this way before you went to sleep that night?
It looked that way when I went to sleep.
Okay, so there was a clear path then right in front of the window.
Yes.
Okay, thank you. Publishing A75, step 1. Ms. Matheson, if you look at that windowsill, do you see the staining on it, the dirt on it?
Okay. I see a windowsill, but I can't tell what is on that
Do
windowsill.
you see any discoloration here?
Sure, there's discoloration.
Could that be from the children going in and out of that window?
They were not permitted to go in and out of that window. If they went in and out of that window, they were told they had to go through the front door and around to the backyard.
Thank you. Publishing A84, is that one? Mrs. Matheson, this is a picture of the, I guess, little pail that sits outside your front door you used to place cigarette butts in. Do you see any recently smoked cigarette butts in there?
I can't answer that. I can't tell if there's recent cigarette butts. There's no way of me knowing that.
No? Do you see one on top of all the rest?
Yes.
Okay, thank you. Publishing A86, set 1. Mrs. Matheson, can you tell me what is on the sofa there?
That is my work laptop.
Okay. And did you use that at all between March 10th, or March 11th at your house?
No.
No? Did you use it on a regular basis prior to that?
Yes.
Okay. Who purchased that computer for you?
Objection, Judge Relevance.
Consultative relevance.
Publishing A93, set 1. Okay, Mrs. Matthews, this is the trash can in the kitchen, correct?
Yes.
And you see the items that are on the top?
Yes.
Okay, so a couple of water bottles, like a ball of string, and maybe some random trash. Is that correct?
Yes.
Okay. And do you recall how much string that might be?
I have no idea. There was a lot of string.
It's a lot of string, and then it was your testimony that that string fit in my pocket.
It was wrapped, but I saw it come from your pocket. Yes, it was wrapped.
All of that string came from my pocket.
Yes.
Okay, thank you. Publishing A95, set 1. Mrs. Matheson, is that the NyQuil bottle that you say was used?
Yes.
That weekend? Yes. And can you tell me how many doses you believe you took that weekend?
A few.
A few. Would you have attested to anything different in another matter?
I don't recall. I was in shock when I was found, but it was few.
A few. Would you like to refresh your memory? Do you need to refresh your memory?
I don't need to refresh my memory.
Okay. Can you recall about how many times you've testified about this NyQuil?
This is the first time that I'm testifying about the NyQuil.
You've never spoken about this in any other proceeding related to this case?
I spoke about it in another case.
Okay. Do you recall what you said about the NyQuil?
I don't recall what I said in another case about the NyQuil.
Okay. Do you think you were very specific in another case about the NyQuil?
I don't recall the details of the NyQuil in another case.
Do you believe you would have said 2 doses?
Objection, Judge, improper impeachment.
And you did just say earlier that you weren't feeling well that week.
Earlier in the week.
Correct. Thank you. Publishing A96, set 1, please. Ms. Matheson, you see some duct tape in that trash can?
Yes.
You say that was used for what purpose?
I said that the duct tape was placed on my mouth.
Okay. Did you have any marks after the duct tape was pulled off?
Not that I recall.
Do you know if when you were evaluated at the hospital, they were able to test around your mouth for any kind of adhesive or any damage from duct tape?
I was thoroughly tested. They had to. I can't recall.
Okay. Could that duct tape have been used for any other purpose that evening, that day, that in the past week?
That is, I have no idea.
Thank you. Publishing A100 set 1. Ms. Matheson, what is this electronic device on the chair?
Hold on, wait, one second, Mr. Stern. My exhibit list, and Ms. Johnson, you can help me, says set 1 is A1 through 104.
Correct.
So
This
check.
is 100.
Well, I thought you said 107.
I'm sorry, no, 100.
Okay, excellent. All right.
I'm sorry, Mrs. Matheson, what is that electronic device?
This is a tablet.
And your testimony was that it may or may not have been working?
I don't recall.
You don't
It
recall?
was the kid's tablet. They were complaining about it not reacting when they touched it.
Okay, but it's plugged in charging.
I was charging it to see what was going on with it.
Okay, thank you. I'm finished with this set. I'll return it to the clerk. Okay, Ms. Matheson, let's move forward in time a little bit. So you're woken up and you say that you were drugged into the living room. Do you remember approximately how long you were in the living room?
Approximately 3 hours.
Approximately 3 hours, okay. And in that time in the living room, have you described in any prior testimony as wrestling?
Yes.
Okay. Do you recall 3 hours? It's a lot of talking. Other than just your comments about going into some boats or offshore, do you recall what other things we were talking about for 3 hours?
There wasn't talking going on at this point. There was fighting, wrestling, me trying to get free and out of the house.
And did those photographs depict the kind of wrestling and fighting that you're talking about?
To me, they did.
They did?
Yes.
Okay. Do you recall our son Landon coming to the front door?
I recall knowing that Landon was there and him being in the vicinity of the front door.
Okay. Do you remember if you or I opened the door for him?
I don't recall.
How dark was it in that living room?
It was very dark.
Could you see my face?
As it got lighter, but at 3 a.m. I couldn't. I just knew it was you.
Okay. Well, I believe that you testified that the children left the home around 5:30 that morning. Is that correct?
Approximately.
Okay. So that brings it closer to 2.5 hours. The children, if they left at 5:30, do you believe that the sun was coming out at that point?
It was winter, not. That weekend was when daylight savings would have happened. We had not gone into the daylight savings yet, so I don't recall.
So you're just agreeing it was very dark in that living room?
Yes.
Okay. And but you don't remember all the things we were talking about. You thought we were fighting, wrestling, that kind of stuff for most of that time?
Yes.
And is that where you sustained some of the bruises,
Yes.
some of the scratches?
Yes.
Okay. So you think most of the injuries that were photographed happened in that living room?
Some happened in that living room. Some happened through other moments of the events.
Okay. It was your testimony that you saw scarves wrapped around my body in the living room,
Tied to your belt loops.
tied to my buttons, and they couldn't have come from your closet.
Those scarves were not at my new home.
Okay. So you didn't notice them at any other time until we were in a dark living room,
Yes,
and you could discern in that darkness the colors of peach, pink, and white.
I could not see the colors at that time.
It was your prior testimony that you noticed the colors. You stated the colors.
I know that they're those colors because you used them to tie me up after the struggle, so I know what colors they were.
Okay. Let me ask you, Ms. Matthews, do we ever use scarves intimately?
Objection, Judge?
Legal basis.
Your Honor, it goes to.
She can answer the question.
I do not recall ever using scarves intimately.
In 16 years of marriage, did we ever go beyond just regular intercourse?
Objection, Judge. Relevance?
Hold on, don't respond. I'm gonna allow it overruled.
Ms. Matthews, you may answer.
I was a teenager when I began dating you.
I'm sorry, can you answer the question?
I'm answering the question.
Wait, don't cut her off. But unless you intended to narrow the scope.
I just didn't want to get into the history that she's starting out with. I did want to just ask.
Do you have a
during our
specific?
marriage-
Do you have a more specific question?
I asked during our marriage. I didn't ask about her teenage years. She started out with her teenage years. I asked about our marriage. Did we do more than just regular intercourse?
Well, do you have a more specific question than? I mean, that's a broad more than. You have a specific question during the marriage?
Okay, I can be specific. Did we, during our marriage, use peripheral objects in our sexual activity?
More in the early marriage, prior to having 5 children.
Okay. Did we get more adventurous in our sexual habits?
Judge, I'm going to object.
And the legal basis is
Relevance.
sustained.
Did we ever use scarves or strings or anything to as part of our sexual encounters from time to time?
I don't recall a single instance. I don't recall any.
But you do recall us using a variety of quote unquote toys and things of that nature.
Judge, I'm going to object.
Sustained as to relevance.
Well, I'll move on. It was your testimony that we were in the living room when Arden came into the home.
Yes.
Is that correct? Is there any chance that you might be mistaken and we were in your bedroom when Arden came into the home?
The way I remember it is I was in the living room.
Do you recall possibly sitting on your bed when Arden came into the home?
Objection, Judge. Asked and answered.
Not this specific question, only if you know.
Oh, I don't. What was the question?
Do you remember if you were sitting on your bed when Arden came into the room?
The way I recall it is I was sitting in the living room.
Okay. And when Arden came in, did you say anything to Arden?
No.
Did you look at Arden?
I looked at her. She did not look at me.
Did you say anything to the 2 younger children?
No.
How long was Arden in the home?
A few moments.
A few moments, as in seconds, minutes?
Enough time to get the children and leave.
Did she take anything with her?
I have no idea if she took anything with her.
Did Arden leave peacefully?
Yes.
Do you believe that if there was some problem, Arden would have spoken up?
Objection, Judge. Speculation.
Sustained.
Okay. We'll go forward. After Arden left, was I on my telephone?
I have no idea.
Do you know if I was communicating with Arden while she drove to my house?
At the time, I had no idea she drove to your house.
Okay. While she was, right after she left, what did we do?
You tied me up.
Before she left? After she left?
After she left, you tied me up
Where?
in my bed.
In your bed. And you said this was with string. You said, sorry, Christmas lights. And you said a vacuum cleaner?
Yes.
So it was, how did I go get the Christmas lights?
It was already tied with the scarf and the string. Then you left and went and got the Christmas lights
So I left the room to go get Christmas lights.
while I was tied up.
And there were other items you saw in the room that probably would have been easier than going out to your garage to get Christmas
Objection,
lights.
Judge, speculation.
Sustained is to speculation.
Let me ask you this, Ms. Matheson. What is the time frame between when Arden left and
I just want to say Arden is an awful name for a kid. Awful name.
About 5:30, 6 o'clock, she left. The videos happened when I was first hog-tied, which would be approximately 11 o'clock. 6, I'm trying to do the math while I'm thinking. It's 5 hours.
5 hours? Okay. What did we talk about for 5 hours?
I didn't do much talking.
You guys talked about some
You
sexy time.
on and on about random nonsense, and it's incoherent nonsense, but you can just go on about it.
Okay. Do you remember specifically what incoherent nonsense I was talking about?
Chartering a boat, money in offshore accounts, going to the island, having a bodyguard to watch me, your parents' involvement, our children, what happened through the marriage. There's many, many, many topics that you could go on for hours about.
You remember speaking to me about any offshore accounts? Remember questioning me about offshore accounts?
You want to talk about the offshore accounts?
Did you question me about where they are?
There are 2 reasons why I would believe that you had offshore accounts. 2 reasons.
I'm just asking right now if you asked me where those offshore accounts were.
Judge, we're going to need to approach.
All right. We'll excuse the jury, gentlemen of the jury. Please do not discuss the case amongst yourselves or do any research related to the case. We'll take a very short break. All rise for the jury. In limine, that's why she's hesitant.
He's hesitant because he's opening up.
Yeah, he is. He absolutely is. She can answer.
Times federal agents have come and removed him from airplanes.
She can answer.
He believes that the feds were after him due to his money.
Yeah. He's opening the door. She can answer. But I appreciate her hesitancy, not knowing since there was a motion in limine. But if he asks for that information and that's the answer to it, that's called opening the door, which he clearly is doing if he wants to continue that line of questioning. Anything else? Did you want to be heard, Mr. Summers?
Yes, sir. I'm not asking about anything federal. I'm asking if she specifically asked me one question about having an offshore account.
So what exactly is your question to her?
If she asked me,
Did you ask me about the accounts?
I asked, did she ask me where I had offshore accounts? It has nothing to do with my
That's a specific leading question that calls for a yes or a no answer.
Yes.
So, but be very careful.
Yes.
I'm going to just answer that question, yes or no. But if you ask any other questions, they're not specifically questions that call for a yes or a no. They require you to say something in response to that question. It may have been the subject of motion limited. You absolutely may do it. Right?
Judge, the concern is if her answer is she did not ask specific questions about it, which then calls in question to the jury. Why didn't she question him more about it? She didn't question him more about it because she already knew all of these federal issues he has had for years and years and years. So It may seem,
So
it's.
he may still open the door with his leading question. If she says no, then on redirect, you're welcome
Yeah.
to ask redirect
So,
questions related
all right,
to
guys.
the answer she gave on the cross.
So we got to listen to him be awkward. We're going back to Moore. It's about game time. We're going back to Moore.
How does the state wish to proceed?
Thank you, Your Honor. At this time, the state of Ohio will rest subject to the admission of our exhibits.
All right. Ladies and
Let me
gentlemen,
know if you guys
normally,
can't hear.
at the conclusion of the state's presentation of evidence, the court takes a break and deals with some legal issues, such as going over the exhibits that will be admitted. We
Can
have
you guys hear
agreed
this?
with the parties that all motions and exhibits will be done at the end of the day, so we won't be taking your time up. We'll take care of those. We're going to reserve that opportunity for both parties, and we're going to proceed right now. Does the defense wish to call any witnesses? And
Call Dr. Heather Garvin.
all right.
Okay, good. Glad you guys can hear. Yeah, we'll go back to Summers at some point. Yeah, he's sinking himself as he talks, but yeah, here we go. This will be interesting. Bringing their own doctor up.
Raise your right hand, please. Do you
It's
swear
probably the
or
body
affirm
farm
the testimony
doctor.
about to give in this case to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Dr. Garvin, please introduce yourself to the jury.
I'm Dr. Heather Garvin.
And where do you work?
I am a full professor of anatomy at Des Moines University.
I want to go through the course of your work in this case. Did you provide me with a current CV?
I did.
And CV, kind of
It's a long resume, especially in academics.
showing you what I've marked as Defendant's Exhibit 00. And, oh, you know what? Thank you. Want to go through your employment, your affiliations, your background, a little bit about your qualifications. I know you just mentioned where you work, but tell the jurors what you do at Des Moines University.
So at Des Moines University, I teach anatomy to medical students, physical therapy students, physician assistant students. I also train master's students in the Masters of Anatomy program doing research. And through the university, I conduct forensic anthropology casework for the state of Iowa.
Are you currently a full professor?
I am.
Let's talk about the second section here, current affiliations and appointments. And actually, let me just go up to here too, with respect to your associate professor work. That was actually in forensic sciences.
My assistant professor.
Yes, your assistant professor. Let's go down to your current affiliations. If you could, 2020 to present, talk to the jurors about the American Board of Forensic Anthropology.
So the American Board of Forensic Anthropology is the only certifying body in the U.S. for forensic anthropology. It's accredited through the Forensic Specialties Accreditation Board. I became board certified in 2017. There's lots entailed with that, which I can get into in a minute. But in the 2020 that you're pointing to there, I was elected on the board of directors of the American Board of Forensic Anthropology.
Let's pause there.
Well educated.
You indicated that you are board certified as a forensic anthropologist.
Correct.
Tell the jurors what it requires to be board certified in forensic anthropology.
To be board certified in forensic anthropology, you first have to hold a PhD. Then you apply to actually sit for the examination. To apply to sit for the examination, you have to submit training logs, you have to submit letters of recommendations, you have to submit your CV, your degrees, as well as 3 case files representing the work that you have completed. And then the board of directors reviews those materials, and if they find you competent enough to sit for the exam, you can then sit for the exam. If not, they deny your application to sit for the exam.
And then tell the jurors what the exam entails.
The exam itself has a written and practical component. It's about an 8-hour exam covering all aspects of forensic anthropology.
And you indicated that you became board certified in 2017.
That is correct.
did you become board certified and pass the test on your first try?
I did.
I know that you indicated that you're now been elected to serve on the board of directors of the American Board of Forensic Anthropology. Do you hold or are you on any committees within the American Board?
Yeah, one of the roles of being on the board, you have to serve in a number of different committees. It's a nonprofit, so it's all just volunteer work. And so my role in there, I'm co-chair of the applications committee currently. I'm also chair of the exam development committee, and I serve on the medical legal outreach committee as well.
As part of your work on the applications committee, tell us what you do.
So the applications committee is responsible for reviewing those applications that are submitted to sit for the exam. Currently, as co-chair of that, I do not have a vote in that. I'm compiling information from the committee for votes yay or nay towards those applications. But prior to serving as the co-chair on that and as a board of director, I did review case reports for that purpose.
And the case reports are submitted as part of the application process to even take the board certification exam?
Correct.
Let's move now down to 2015. I'll scoot it up so the jury can see it. 2015 with respect to your editorial board, Journal of Forensic Sciences. Tell the jury what that affiliation or appointment entails.
So I was asked to serve on the editorial board for the Journal of Forensic Sciences. It's one of the major journals in the forensic sciences, particularly in the US here. And that's because usually as academics, we'll do guest reviews of publications. All publications are peer reviewed by others. I was doing enough of those and I was doing a thorough enough job that they asked me to serve on that board, which means I get a lot more reviews to do during the year.
Let's move to your education, if we can. I'll start from the bottom. We'll start at undergrad. Where did you go to undergraduate?
I went to undergrad in University of Florida.
While you were there, did you have any experience or exposure or opportunity to do any forensic anthropology lab work?
I did not do forensic anthropology lab work, but I volunteered as an undergraduate in the forensic anthropology lab there, but I was not conducting the work as an undergraduate.
You were a volunteer in the lab?
Correct.
And then where did you next go for your education?
So following my bachelor's, I went to Mercyhurst College in Erie, Pennsylvania for their master's program in biological and forensic anthropology.
What was your thesis there?
My thesis was on the ossification of laryngeal structures as an indicator of age.
And laryngeal structures, point to the jury where that area of the body is.
So those are the neck structures. It's your thyroid cartilage and your cricoid cartilage. And sometimes the hyoid is kind of included in that complex there.
And when someone says, I wrote my thesis on the ossification of the laryngeal structures as indicators of age, what does a thesis mean?
Thesis is a major research project you do for your master's. You have to design it, collect all the data, analyze it, and then you present it as kind of that capstone to your master's, and you have to defend it in order to get that master's degree.
And then after getting your master's degree, where did you get your PhD?
Following there, I went to Johns Hopkins School of Medicine for my PhD.
And graduated from there in 2012.
Correct.
Let's go now to, I'm going to cycle through if we can. Page 3. Let's talk about your teaching experience. Present teaching experience, talk through the jury with that.
So as I mentioned, presently working for Des Moines University, my main role there is teaching medical students. I teach them anatomy specifically. I also run a forensic osteology elective course there. And then I'm also running some master's thesis course with students doing research in skeletal variation.
And you've listed here on your resume the actual
This
course
is
names and
a
numbers.
real expert. Listen to all this. Dang.
Then we can go down here to the courses that your teaching experience as an assistant professor. If you could tell the jurors about that work from 2012 to 2017.
And so prior to starting at Des Moines University in 2017, I was in a tenure track assistant professor position at Mercyhurst College in the Department of Applied Forensic Sciences, where I was teaching graduate students and undergraduate students specifically in forensic anthropology and supervising casework.
We're going to now talk about some of your publications, if we can. Go to, and there's a significant number included in your resume, but I want to talk about just a few that might be related or applicable to this case. In 2020, if I could find, tell the jurors about the case studies in forensic anthropology in 2020.
So myself and a fellow board certified forensic anthropologist created an edited volume on the case studies in forensic anthropology to help in training students, graduate students, as well as learning more about what our colleagues are doing across the country. Because the more exposure you get to cases individually from different regions, the better off you are as a practitioner.
And publications in 2018 in the International Encyclopedia of Biological Anthropology. Tell the jurors about that publication, which I've marked right there.
Yeah, so that's an invited publication. And so me and my colleagues that are listed there, we actually created the forensic anthropology, I don't want to say chapter, but with an encyclopedia, the label and description of forensic anthropology within that volume.
Turning now to 2016, the utility of advanced imaging and forensic anthropology. Tell the jurors about that publication.
That publication is talking about how radiographs and CT scans and MRIs can be used in casework in forensic anthropology. It's published in the Academic Forensic Pathology Journal. That's the journal associated with the National Association of Medical Examiners in Maine.
And going to 2012, developments in forensic anthropology in 2012. Describe that, please.
Yeah, so that's a book chapter specifically on age at death estimation in a volume that's the Forensic Anthropology Companion. It's kind of a text that's geared at graduate students.
Going to 2010, in your listed publications, at the top there, it has limitations of cartilage of age of death. Explain that.
So this was an extension of my thesis work. With my thesis work, I focused solely on the laryngeal structures. I then also looked at cartilage ossification in the rib cage as well for age estimation.
I want to talk now about turning to. I know we talked about, there's a section in your resume for actually, let me go to 2008 in terms of public abstracts. I don't want to. Yes, right here. Looking for, give me just a second. This one right at the bottom here, with respect to the human hyoid and its relationship to the basic cranial, and I'll let you say the rest.
And mandibular morphology. Also part of my research during my master's when I was looking at the laryngeal structures, I did some studies on the hyoid bone itself. It's actually variable in its shape and size, and we don't truly understand why that is or what factors. So I was investigating whether the shape of the hyoid was somewhat related to the base of your skull shape.
And then similarly with respect to that area, in 2007, the ossification, again, on that same area. Tell the jurors about that work.
Yeah, so this was a presentation. So all published abstracts are national presentations that you give at Academy meetings each year. They publish the abstract. You either give a poster or a podium presentation. So this was just prior to the publication of my thesis work where I was presenting it at the Academy there.
I want to turn now to your forensic anthropological casework. Tell the jurors just generally about the casework that you do at Des Moines University.
So through Des Moines University, we have a contract with the state of Iowa where I conduct the forensic anthropology cases for the state of Iowa. So if there's anything that they think a forensic anthropologist could provide additional information for to help them in their investigations, they contact me.
And below the description of that work, you have listed 2022 to 2017. What type of information is listed after each of those years?
After each of those years, I have the total number of cases that I did that year. Our case numbers always include human and non-human cases. Some of our job is just saying that, no, this is a pig bone, I'm sorry. But so I have actually stated how many of those are non-human, how many of those were full anthropological analyses with a full report. There are times that the medical examiner wants just a verbal opinion, a verbal consult. So I've included consults on there or consults from colleagues, as well as any search, recoveries, external case reviews, and testifying.
And we'll get to testifying in a second, but just generally average number of case reviews per year.
For the case reviews?
Yes.
So as you can see, my casework has gone up since I first went to Des Moines University.
And so it starts at 3, and then the last couple of years you've been at 13 and 10 and 11. Does that look about right?
Correct, because usually case reviews are done by board certified individuals, and I just became board certified in 2017.
And then let's talk about your forensic anthropological casework earlier in your career from 2005 to 2017.
Yeah, so starting with the graduate program at Mercyhurst University is when I first really started participating in casework, doing analyses on skeletons, doing search, doing recoveries. So throughout that time, as far as human cases I was involved in, it's more than 75. That includes the time I was there as a graduate student. And then I was there for those 5 years teaching alongside with 2 other board certified forensic anthropologists.
And I'll just ask you while we're here, if you know, did you train, you just mentioned this, but did you train under board certified forensics anthropologists?
Correct. That's one of the reasons I went to Mercyhurst, that they had 2 board certified forensic anthropologists as faculty.
And if you know, does the Ohio State University have any board certified forensic anthropologists?
No.
Have they had a forensic board certified anthropologist in the last 10 or 15 years, if you know?
Definitely not since 2005, because when I was looking at schools for masters or PhDs, I specifically looked at OSU.
We see at the bottom of this page, just with respect to your other professional services, are those the committees that you talked about earlier under the board of directors?
Correct.
That you serve on? And then moving now to same section, if we could. I want to talk about your work as a guest reviewer that you've been doing since 2012. Talk to us about that work.
Yeah, so it's a little less reviewing for each journal than if you're on the editorial board. But the way academic journals work is someone will submit an article for publication. They send it out to 2 to 3 people in the field to review. You essentially volunteer your time to review those articles and decide whether they are acceptable for publication or not. And so this is a list of the various journals that have reached out that I've done these reviews. And then not including the editorial board for the Journal of Forensic Sciences.
Tell us about your co-chair work on the validation committee.
So my first year on the board of directors for the American Board of Forensic Anthropology, I was co-chair of the validation committee. So all questions that go into our question bank for our exam are rigorously validated by a number of people before they can even go in that question bank.
Further down, 2019, it's listed a book review of forensic anthropology. Tell us a little bit about that.
That is correct. The publishers for that book reached out to me and asked if I'd be willing to read through and do a review of that textbook.
Turning now, if we could, to 15, 16, and 17, the co-instructor work that you did. Tell us about that.
Yeah, so Mercyhurst University, they teach graduate and undergraduate students throughout the year, but every summer we have short courses where you might get, wannabe students, graduate students, law enforcement, other people that want additional training in forensic anthropology, either in the search or recovery or analysis of those remains. And so as faculty there, I was co-instructor for those courses.
And going down to 2013, to the 3-day course that you did there. Tell us about that.
Correct. Myself and my then colleague, Dr. Stephen Sims, went down and conducted a 3-day skeletal trauma course in Chile. Again, just going over what skeletal trauma is, our experience in it, the features of it.
You mentioned Stephen Sims. Who is he?
He was one of my advisors during my master's at Mercyhurst University, and then my colleague when I was teaching there.
And is he a board certified forensic anthropologist?
He is.
Going now to, we'll have to kind of, the page is split, but 2007, with the short courses at Mercyhurst College, and the list begins right here at the top of the page.
Yeah, so as a graduate student, you were expected to work in those short courses. You basically, your life was school and learning forensic anthropology and then teaching others forensic anthropology.
Then the next section of your resume goes into, I believe, lectures. Right about that?
They're invited talks.
Invited talks.
I give lectures every day as part of my job that are not invited talks.
Fair enough. Doing a trial is like an invited talk too. Invited talks. We'll just start right from the first one in 2022, Forensic Anthropology Introduction. Tell us about that.
So the Midwest Death Investigation course had contacted me and asked me to give a presentation there about forensic anthropology. Most of the audience members were medical examiners from Iowa or death investigators from Iowa.
And going down to 2019, invited lectures. I know we're still on. 2019, the role of forensic anthropology in medical legal investigations. Tell us about that.
Again, this is an invited lecture. Given my expertise in forensic anthropology, they reached out, the Iowa division of the International Association for Identification, and I gave that lecture there.
2018, with respect to invited lecture invitation that begins with forensic anthropology. What did you do there?
That was a talk at the Iowa Association of County Medical Examiners, again, explaining what forensic anthropology is, what we can contribute on the casework.
And somewhat related to this case, we'll go to the next page and talk about the invited lectures in 2014, 15, and 16.
Again, they're invited lectures. So 2014, 15, and 16, the one that says forensic taphonomy and bone trauma analysis. Through Mercyhurst, we would put on the Pennsylvania Coroner's Basic Education course yearly, where we go and teach coroners about forensic anthropology and our expertise. The other ones, again, they're invited lectures. teaching individuals about what forensic osteology is, or sometimes even the public, to make them more aware of what a forensic anthropologist is, what that career looks like, and what that role is.
And we'll end here with your academic memberships.
Yeah, so as an academic, you usually belong to one or two academic memberships. And so I belong to the American Association of Physical Anthropology. It's now American Association of Biological Anthropology. They've changed their name with the time, where I'm a full member there. And then the American Academy of Forensic Sciences, the anthropology section. I've been a part of that since 2004, and I'm a fellow within that organization.
Is there any difference between someone that says I'm a member and I'm a fellow?
So you have to be promoted from member to fellow, and that means you have to go to a certain number of meetings each year. And then I believe you had to submit a couple of research articles showing your involvement in the field, or case files showing again that your expertise in that field.
Seem to be a fair and accurate copy of your current CV.
Yes.
Few last questions with respect to your experience as a witness testifying. Have you ever testified in a courtroom before?
Yes.
And in those how many times?
5 times.
And in
This
those
will be the 6th. Sorry.
And in those instances, were you tendered or offered and qualified as a forensic anthropologist?
Yes.
Of those 5 cases prior to today, were they criminal cases?
Yes.
How many of those 5 times did you testify for the state?
For the prosecution, all of them.
Your Honor, this time I would tender this expert as a board certified forensic anthropologist.
No objection to the forensic anthropologist.
Please proceed.
Thank you. Dr. Garvin, I've left a report up on the that bar there for you. If you need to use it to refresh your recollection, just let us know. Could you flip through it though, so that I can mark it as an exhibit, and let me know if that appears to be a fair and accurate copy of the report that you rendered in this case?
It does.
I want to marking Dr. Garvin's report as Defendant's Exhibit TT. Just want to go through the report in all 15 of 15. Does that appear to be accurate?
Correct.
Because it is page numbers, I'll just refer to page numbers as we go, unless the report's in front of you. Just as a matter of background, how did you first get involved in this case?
So on September 3rd of 2021, I was contacted by Court Gatterdam and asked if I'd be willing to do a review of case materials as a forensic anthropologist.
And how, if at all, do you know Court Gatterdam as being part of the defense team?
At that time?
Yes.
None.
Okay. He's my co-counsel. That's what I mean.
Yes.
Do you know him as that?
Yes.
And so he reached out to you, and the scope of the request from Mr. Gatterdam, is that included in the first paragraph there in your report?
Yes.
And tell the jurors what you were asked to do.
So I was asked to review a number of reports and provide my opinions based on my forensic anthropology expertise. And so those reports are bulleted there. Do you want me to go through them?
Let me go. When you say bullets, there's a list right there of materials that you reviewed. Were those materials provided to you by Mr. Gatterdam or a member of the defense team?
Yes.
And you've listed those as they appear. Can you tell the jurors just what those are?
So the first bullet is a forensic anthropology report submitted by Dr. Vidoli at the University of Tennessee. The second is a forensic anthropology report submitted by Dr. Amanda Agnew and Ms. Harden of the Ohio State University, dated to the 11th of January, 2021. Then I have a Montgomery County, Ohio coroner report on the postmortem examination of Emily Noble. Then I have an addendum to the forensic anthropology report submitted by Dr. Angela Harden of the Ohio State, dated to the 10th of May, 2021, and a written review of case materials authored by Dr. Smock.
The last material that you reviewed, through the work in this case, you're familiar now with Dr. William Smock?
Yes.
If you know, is he a anthropologist?
No.
Is he, and then sort of the next question, also not a board certified or forensic anthropologist then?
No,
Is he a pathologist?
not to my knowledge.
Did you, and let me pause. When Mr. Gotterdam reached out to you and asked for you to do the work that's identified on your report, did he, in advance of you doing that work, tell you or guide you in any direction as to what the defense wanted you to say?
Well, it's introductory. I'll permit it to say yes or no.
No, and I don't recall, but I would imagine I might have even responded and said that I'm willing to do this. You don't know what you're going to get out of it, but.
Did you obviously do the analysis in this case and ultimately come to some findings and conclusions with respect to your work?
So the word analysis in this case is referring it to the actual review of these materials. It's not a case report as if I sat down with the skeleton and wrote out a forensic anthropology case report.
And so based on your review of the materials that you've listed here in bullet points, did you come to findings and conclusions in this case to a reasonable degree of medical or scientific certainty?
Yes.
And are those summarized in the initial paragraph in your report?
Yes. The bulleted points at the top are points of the review, kind of the major points of the review for the critiques or refuting points.
And if you could go through them, let's start with the first bullet point. Your finding in the first bullet point.
So it says perimortem fractures to the hyoid bone and ossified thyroid cartilage. Hanging cannot be ruled out as a possible mechanism to these fractures.
I want to pause there and talk about perimortem, if we could. Perimortem, define that period of time, if you can.
So perimortem, although generally means at or around the time of death, it means something different for forensic pathologists doing an autopsy and anthropologists. As anthropologists, we don't have the soft tissue to work with. And so all we can tell as far as a fracture occurring at or around the time of death is that it occurred in fresh or biomechanically fresh bone, meaning that it still has, it's still hydrated, still has this collagen and protein and elastic properties. So that can be, if it's a few days before, we may not see any signs of healing. It could be days after, weeks after, sometimes months after. I think it's even documented to be years after at times.
Antemortem. Could you define antemortem for us?
So anthropologically, we would determine that a defect is antemortem if it has gross or visual signs of healing to that bone.
And then going on the other end, postmortem damage.
So postmortem damage would have no signs of healing, obviously, and it would appear as if it happened in dry bone. So it's not happening in that more elastic bone. Sometimes that will be more jagged, more angular, and sometimes it'll be lighter in coloration because it wasn't exposed to the environment as long as the perimortem fractures.
Let me pause there. You've listed in your report on page 7 of 15 a number of citations. Do you recognize that?
Yes.
And before you came to testify today, did I approach you with a stack of the printed out copies of the listed citations that you've referenced in your report?
Yes.
And did you have an opportunity generally just to talk to me about the number of citations? And would it sound about right that there was 9?
I heard the question, but why don't you rephrase it?
Sure. The number of citations in your report.
I have 13 citations in my report.
And in one, I want to go back to the to your description of post-mortem damage, if we could. One moment. Oh, it's in there. Let me put it.
looking for the jagged, you might know where more it is. Well, I'll find
It'd just
it in
be
a
2
minute.
pages. I
Yes.
think.
I'll find it in a minute. So circling back to your report, I'll find that literature with respect to postmortem damage in a second. But the second finding, as noted in the second bullet point, is what?
No evidence of perimortem fractures to the craniofacial region.
Tell us what the craniofacial region means.
Craniofacial region means the bones of the face in this general area.
And while we're on sort of the anatomy, if you will, and I have your permission to ask you this, how tall are you?
I'm 5'4"3/4.
If you could show the jurors just generally where hyoid is and then the thyroid cartilage.
Yeah, so the easiest way to understand the anatomy is to explore your own anatomy, right? And so your Adam's apple here that you can feel, that's your thyroid cartilage, and you can feel it wraps around the side. Just below that is the cricoid cartilage. It's a ring-like cartilage just underneath that. And if you follow your Adam's apple up, and there you'll feel a little space, and then you feel another bone right on top of that, that's your hyoid bone. And you can feel the greater horns of your hyoid on the side. I just always warn people, don't squeeze too hard.
But so going back now, because there was this issue earlier showing you what's been marked as Exhibit BB for defense. I think this was one of the materials included in that were included in your citations. Do you recognize this?
Correct.
And where is this 2-page piece of literature from?
So those are 2 pages out of the textbook Forensic Anthropology, Current Methods and Practice by Christensen et al.
And with respect to this paragraph right here, summarize, if you could, what it says with respect to post-mortem fractures or damages you've talked about.
It says that fresh bone fractures or perimortem
There
fractures
aren't rules,
will
but you
lack
show it
evidence
to
of
eliminate
healing
bias
or
questions.
infectious response, and that they are often straighter, where dry bone, those post-mortem damage, tend to have a more jagged appearance.
Going back to your report, Defendant's Exhibit TT, the third finding, if you could talk about that.
Antemortem trauma to the nasal bones and maxilla.
Going back to the anatomy, if you could show the jury nasal bones, maxilla, the rest of that nasal structure.
So you have your nose, which the part that's projecting outward is cartilaginous, which is why it moves. If you push backward, you can feel where the nasal aperture, that bone ends, is a teardrop shape. You have a little bone projecting out here, your anterior nasal spine. Your actual nasal bones are the small ones up there that are pinched. And then on the side here, this is all your maxilla, and your maxilla actually includes this top part that has your teeth in it as well.
And then the opening of the nose is called what?
The nasal aperture.
In preparation for your testimony today, did you provide some pictures of nasal apertures?
Yes.
Marking these as Defendant's Exhibit PP. We'll show them on the screen.
Well, there's like an escrow agent. I'm like, so it's a mortgage document. And I'm like, can you just have your mom get on? Because I said, I don't want to play telephone here. Like, can you just...
Dr. Garvin, tell us what we're seeing here with these 3 images.
So I did a quick Google search, just nasal aperture human skull, to provide examples of what a nasal aperture really looks like. Most people have not seen it in their lives. And so you can see these are educational images where they're outlining where that nasal aperture is, where the anterior nasal spine is, that's just below it there. And one of the primary things that's illustrated here is the amount of variation there is in that nasal aperture and how that aperture can be irregular.
These 3 pictures, are these nasal apertures that have suffered trauma, or are these not?
This one down here might have some antemortem trauma. Can't really tell on that. But otherwise, no, because they're teaching specimens, so they wouldn't have a peri-mortem trauma teaching specimen.
And the differences, if you could just show us perhaps a few differences between this image and this image to illustrate your point with respect to these.
Yeah, so you had the nasal aperture here, and you can see, oh, I can't do it too thin. You can see that there's just, if you follow those borders up, there's irregularities along the way. Essentially what's happening is bone is kind of coming to a point where the cartilage then attaches to it and comes out. It's not joining with another bone, so you don't have a nice joint there per se. And then the nasal bones, you can see there's variation here. And even in the drawing for a textbook, you can see that they've even captured some of that variation in the drawing as well.
Well, it's an escrow thing. I'm like, so is this like so this is about a mortgage, isn't it? And he's like, well, I knew on the background.
Put additional images to respect to the nasal aperture.
Yes, well, one of the things we teach is human variation, right? We're variable. So I didn't want it to seem like I just picked 3. So these were 2 additional ones showing nasal apertures. Again, from common internet searches. And, even areas like this, you can see are irregular. It's a sharp margin, a little bit of irregularities there along that margin aren't any consequence to you.
And that second image will be part of defendant's exhibit PP, Paul. Thank you. Let's turn to back to your report, if we could. With respect to the 4th finding, begins with potential.
So I put there a potential area of slight postmortem damage to the left lateral nasal aperture.
Tell us why you would put potential in your report.
I put potential in my report because looking at the images, that certain area looks lighter in coloration, and when I compared it to scene photos, it looks as though a little piece might have chipped off. But I don't feel that I can say that definitively, so I put the word potential.
Now, let's work through your report if we can, and then we'll circle back with respect to the findings and conclusions. Are you familiar with Dr. Agnew's report?
I am.
And we'll start with, in her report, does she describe the processing, how she processed the bones in this case?
Yes, she gives a 5-step, which are each numbered process for processing the bones.
And are those 5 steps listed under the description of remains in your report?
They're not listed word for word. For example, when I say an undisclosed amount of time, that's because her report didn't say it yet. I paraphrased them there.
And so let's talk about the undisclosed amount of time with respect to the hydrating process. Can you describe what the hydrating process is?
I've actually never heard the term hydrating process before.
Thank you. Never hurts. I got a bunch of them from all the people I've got to skip bail, so
it sounds as though
I've got all 7 of them ready to go.
That material, it's a form of maceration. So maceration just means.
I got one.
Most of the time, as forensic anthropologists, when we're macerating,
yeah, I bet
a little bit of heated water. But in this case, they were in a tub with water, I think, to loosen that soft tissue to get it off.
Objection, Your Honor. Move to strike the last part of that answer. It calls for speculation. She indicated she's not familiar with the term or doesn't know what Ohio State did. She's really guessing at this point.
Response to that?
Is it indicated in Dr. Agnew's report the temperature of the water as part of the rehydrating process they used at Ohio State?
It's paraphrased there. The first time she does say room temperature, and then in that 4th step, she says warm water.
So let me clear this here. It's room temperature and warm water. Do you see those?
Correct.
And When you, after the number 2, why is rehydrating in quotes?
Why are we talking about number 2?
Because I had not heard of that as a process.
And rehydrating, is that a term that you're familiar with as a forensic anthropologist?
No.
And then with respect to the third part of the process, the manual removal of soft tissue, could you describe that?
That's a typical part of the process when we have remains, right? As forensic anthropologists, we'll look at the remains with the tissue to see anything there, but then we want to see the actual skeletal surfaces. So we need to get those materials off. So there are processes to loosen the soft tissue, but at some point you have to actually manually use tools to try to get some of that off.
And let's go to, and then where the fourth part of the process is what?
Soaking the elements in a warm water detergent solution. And again, the report didn't say the amount of time.
And why is that something that you noted in your report?
It could be weeks, it could be months. I don't know exactly how long those remains were sitting in water. And if you have remains sitting in water for a prolonged period of time, it can affect the integrity of the bone.
In your work as a board certified forensic pathologist,
I'm not a pathologist.
I'm sorry, anthropologist. How would you document, or would you document the time intervals when elements are being immersed in water?
I would at least mark down the start date and the end date.
Let's go to number 5. Tell the jurors what's the 5th part of the process that Dr. Agnew reported doing.
So she reported submerging the elements in a 1-to-1 ratio of water and 2% hydrogen peroxide for 24 hours.
What is your, based on your expertise, training, and experience, what are your observations about that part of the process?
You should not be using hydrogen peroxide in forensic cases.
Showing you what has been marked as defendant's MM. And before I do that, with respect to the 5th part of the process, there's Fenton 2003, Stedman 06. Tell us what those names and numbers mean.
So whenever you see in my report parentheses and the name and number, that's a citation. It's referring to an article.
Thank you, guys. I turned off mute. Thank you.
We do that in science a lot because anytime you're drawing conclusions, you don't want someone to just take your word on it. So you're providing that supporting evidence from the literature for that statement.
Showing you what has been marked as defendant's MM. Emailed materials.
No objection.
Showing you, let me zoom out so you can see the document. Dr. Garvin, do you recognize this?
Yes.
And tell the jurors, if you could, what is it?
So this is a document, something we would call a SWIG-ANTH document. SWIG-ANTH stands for the Scientific Working Group, in this case, the Subcommittee of Forensic Anthropology. This is a group that was put together originally kind of by the DoD and the FBI to create some written standards or best practices for the field.
If we can, and is this the most current version?
So the SWIG-ANTH documents, this is the most current version of the SWIG-ANTH documents. It's now been rolled over into another organization, OSAC and NIST, and the ASB as well. There's a lot of acronyms where they are redoing all of the standards, and some of them are completed, some of them aren't.
So let me go to page 2 of 3 with respect to unacceptable practices. 5.0. If you could tell us what 5.0 is, please, in terms of unacceptable practices.
It says use of chemicals that damage or destroy bone or DNA. For example, bleach, hydrogen peroxide, and formalin may be used in some situations, but the destructive consequences and personal health risks of the use of these chemicals must be recognized.
In this case, we talked about, well, were the best practices as indicated by defendant's exhibit MM used by Dr. Agnew in this case with respect to processing?
Objection, Your Honor. Then calls for speculation. She said she was not familiar with what Ohio State did.
She's not familiar with what?
With what Ohio State did. She said there's words in the report that she doesn't know what they mean. She hasn't followed up. She doesn't know what Ohio State did other than what she read in the report.
Rephrase your question as to
Sure.
this process, if you will.
Let me just go back to the description of the remains. You reviewed Dr. Agnew's report?
Correct.
And in the fifth, number 5, process, that part of your report, where did you get that information from?
From her report.
And it is described in your report under 5 as what?
I'm not following the question.
What does it say in your report after the number 5 in a
It says submerging the elements in a 1-to-1 ratio of water and 2% hydrogen peroxide for 24 hours.
Is the 24-hour period described in any way within Dr. Agnew's report?
It's described as written.
And then that takes me back to what I just showed you with respect to defendant's exhibit MM. Based on Dr. Agnew's report as to the 5th part of her processing of the remains, were the practices in compliance or not as listed in 5.0?
Hydrogen peroxide was used and there was no indication to the destructive properties of it in the report.
Tell us why hydrogen peroxide might be a destructive property.
It's a bleaching agent, so it'll turn the bones white, which makes them look nice, but we don't need them to look nice in a forensic case. And unless the remains are rinsed off very well afterwards, actually peroxide can continue to process those bones even afterwards.
And what might that do to the bones themselves?
So there's reports that using hydrogen peroxide will impact receiving DNA from the remains. Also exfoliation. So
Oh
bones
shit, the
kind of
peroxide ate the
flaking
bones.
away at muscle attachment sites.
That's not good.
Listen, going back to your report, you've listed there the Stedman article from 2006.
Oh, no.
Tell us how, if at all, the process used by Dr. Agnew, the 1-to-1, differs or same, similar, or otherwise to the Stedman article.
So the Stedman article actually used experimental procedures to look at different types of processing and their effects on DNA amplification. One of the methods they did experiment with was hydrogen peroxide. In the Stedman article, they did do that over a period of 30 days because it took that long for the tissue to come off just from soaking in the hydrogen peroxide. It was used at a 1 to 9.5 ratio with 3% hydrogen peroxide.
And if you recall the ratio that was used in this case?
It's a 1-to-1 ratio of water and 2% hydrogen peroxide.
And so if we compare the ratio in Stedman versus the ratio in this case, how do they compare?
It's approximately 10 times stronger.
10 times stronger in this case?
Correct.
Let's go now to your section with respect to, it's titled Absent Skeletal Elements. Tell the jurors if there was any skeletal elements that were absent based on the
10 times as strong. Wow.
And the photographs in this case.
Yeah, so going through the report, I was going and reviewing all aspects of the forensic anthropology report. And so one of the first aspects in the reports is somewhat of an inventory. What remains did you have available? What remains were missing? And I found a few discrepancies between what was written there, what was shown in pictures and photographs that I had that I reviewed, as well as an addendum report that showed up.
And that's a perfect way of going back to the first page. I know I asked you about the materials you reviewed. In this paragraph right here that says, following a preliminary review, what, if any, additional materials does it say that you reviewed as part of your work in this case?
Yeah, so once I read through the reports that were given to me, I requested additional photographs to conduct my review.
And how many photographs did you review, and where were those from?
From the defense, I received 9 folders containing 432 photographs of the scene, autopsy, and anthropology photographs.
Going back to the section with respect to absent skeletal elements, I don't think you listed for the jurors what was missing. Was anything missing?
So one thing to note was that I saw in the scene photographs that both sneakers were there and the feet were still inside the sneakers. And then there was a radiograph, which is an x-ray from the medical examiner that showed the left foot still in that sneaker. And I could see that the bones to the great toe, your big toe, were there in that radiograph, but they were listed as absent in the anthropology report and were not in the picture of the overall skeleton laid out.
And when you say the picture of the overall skeleton laid out, let me pull if I can. That was in Dr. Agnew's report, is that right?
Correct.
Showing you what's been marked as State's Exhibit 130. Page 2 of 10, is that the depiction that you've just testified about?
Correct.
Could you show the jurors, circle what you just described?
So this would be the left foot down here, and there's the left great toe. There's a metatarsal there, which is kind of the sole of your foot, but the actual digits that would be after that are absent.
And then otherwise absent, anything else noted in your report?
There were also inconsistencies with the dental, with the teeth present and the teeth that were recorded as being sent off for DNA.
Why would you, in your report, address inconsistencies in reporting?
Because it's about accuracy. I mean, the inventory is the first thing you do, what bones are there, yeah.
Showing you, while we're talking about inventory, what I'll mark as Defendant's Exhibit NN. This isn't a picture we've seen, so Dr. Garvin, do you recognize this picture?
I do.
And was this one of the 432 pictures that you reviewed in this case?
It was.
Tell us, and is it easier if I orient
Yes.
the picture this way?
Yes, thank you.
Yes, yes. Tell us, if you could, I'll zoom in, identify some of the things that you see in this photo.
So this photo, I go through them sequentially. So this was after the remains had arrived at the anthropology laboratory. They arrived and some elements were in different labeled plastic bags. And then this picture follows where there's a number of elements. So we have some hand elements, we have the mandible here. This is your first neck vertebra here, some feet elements as well. And zooming in, I noticed that this was the hyoid right here.
This picture, is this before processing or after processing? Where is this in that stage?
This is before processing.
As you reviewed this picture, you've just circled what you have identified as the hyoid bone. In this picture or in any other picture pre-processing, did you see the thyroid cartilage?
No.
Have you looked for the thyroid cartilage in that photo and every other photo that you reviewed in this case pre-processing?
Yes.
Is there a photo freestanding of the hyoid bone pre-processing?
Yes.
Is there a photo pre-processing of the thyroid cartilage?
No.
next page of a report, 3 of 15. I noticed there are places in your report where you seem to say things such as, I have no concerns or comments about this section. Why would you include that type of language in a report?
So that you know that I did at least look at that section, even though I don't have any comments for it.
Let's go to the next section with respect to, actually, we'll skip to age at death. Tell us the process that, based on your review of Dr. Agnew's report, that she used to determine the age at death of the remains.
So she looked at the pubic symphysis, which is one of the age indicators that we will use in forensic anthropology. It's where your pelvis kind of comes together in the front, and it goes through some predictable changes with age. And so she looked at that and applied the Brooks and Suchi 1990 method, where you kind of compare that to a number of phases and came up with a phase 4 for that. And so she gave a range based on that.
And does that range, if you know, include the true age of Emily Noble?
It does not include the age that's on the body labels.
Did she use more than one method to assess the age at death?
Based on a report, it only says that one method was used to come up with this age range, age interval, I should say.
And with respect to your work as a board certified forensic anthropologist, what is your practice with respect to determining age at death?
Well, especially when you have a full skeleton, right? You want to use all the tools that you can. So there's other areas you can look at for age estimation, like the sternal ribs, the auricular surface of the pelvis, cranial sutures. So when we're doing a case, we want to apply different methods and see where all of them come out. And then from that, you have your final estimate. And for each of those, there are methods that have the statistics that follow it. We would report for each of those a 2 standard deviation wide interval.
Was that done in this case?
No.
I want to go to, and I'll toggle back and forth. I'm showing you now Dr. Agnew's report with respect to ancestry. Same question about ancestry. Your practice, using one method or more than one method is your standard practice.
Objection, Your Honor. Relevance. Ancestry is not in this.
Well, it's in evidence, right? Her ancestry. So I think we can talk about ancestry. So I believe it has whatever relevance the jury finds it to be. I'll agree with that. Go ahead.
Just best practice, one method or more than one method in looking at the determination of ancestry.
More than one method, and specifically usually we'll do morphoscopic, so non-metric traits, which were scored in here, but also metric analyses.
And I'm showing you page 3 of 10 of Dr. Agnew's report, marked 130. Based on your review of her report, what method did she use?
She used the ASA method. It's optimized sum scores attributes. It's a method that was developed where you score a number of features, particularly of that nasal aperture region, that are known to kind of have higher frequencies in certain ancestries. And then based on the sum scores of those traits, you can estimate whether those morphologies are more consistent with a white or European ancestry individual or Black African-American ancestry individual.
Did she use more than one method or just the one?
One.
If based on your training experience and review of the literature, do you have any observations or thoughts on the use of the method that she did use with respect to ancestry?
Objection, Your Honor. Relevance.
Yeah, this was addressed previously, I believe, with the prior witness. So I think this is expert testimony, talking about expert testimony, a topic that's been made a part of the record already.
So given that the one method that was used here relies on features like nasal bone contour, I would have been cautious about using it if there's antemortem trauma there, or if there was any kind of trauma there.
that leads us to the next section that we'll talk about in your report, the trauma section. If you recall, how many pictures were in Dr. Agnew's report documenting facial trauma?
I don't recall. I didn't count them.
If I may approach, Your Honor. Or I'll just show you. Would it refresh your recollection to see the report?
Oh, in the report? I'm
Yes.
sorry. I thought you meant all the individual photographs.
No. Okay. Just in her report.
It would help still
Sure.
to. So there are 8 figures in her report.
And with respect to facial trauma, how many photographs are in her report with respect to the face?
There is 1 figure composed of 4 photographs.
Let's go through those 4 photographs now if we can. I'm showing you what's been marked as State's Exhibit 139. Do you recognize that as one of the 4 photographs?
Yes.
Tell the jurors about plastic deformation or deformation.
So plastic deformation, a lot of times, is an indicator for perimortem blunt force trauma. Essentially, when you have a load applied to the bone, right, the bone has a little bit of elastic properties to it. And so those elastic properties will allow slight deformation, slight strain, like 3%, some of the articles indicate. And if you were to stop applying that force, it would just go back to the way that it was. You wouldn't know any different until it reached to a certain point, a yield point. And at that time, you're getting bonds broken. And then once that pressure is relieved, it will not go back to the way it was. That's plastic deformation. If you were then to continue applying force, that's when you get failure for that fracture.
What, if anything, do you recall in her report that Dr. Agnew circled or noticed about this photograph?
In 1 figure, there was a blue circle encompassing the entire nasal aperture that the caption indicated was displaying plastic deformation.
And the nasal aperture, if you could encircle it for the jurors.
That's the nasal aperture.
Before I ask you some questions about this, at any point in time in this case, did you see the actual bones?
No.
Have there been cases where you've been asked to review photographs and the photographs were not sufficient for your review?
For my external reviews?
Yes. And in those instances, what have you done?
I indicated that in my external review that given what I had, I couldn't make a determination on this timing of the fracture.
The photographs that you were provided of the 432 photographs, were they of sufficient quality?
Objection, Your Honor, leading.
Rephrase your question.
Did you need to see the bones themselves to render the finding and conclusions in this case?
Any conclusions that are in my report, I felt confident in making based off the materials that I reviewed.
So let's go back to State's Exhibit 139. I know you've encircled the aperture, but I want to clear it out. Did you look at this image for deformation?
Not just this image, I would go through all the images.
Okay, let's talk about this specific one. Do you see any plastic deformation in this image?
Any of the deformation that I see to that nasal aperture is related to the antemortem trauma.
And tell the jurors where that is or would be.
So you can't really see the fracture lines in this image here, but there's antemortem trauma to the nasals here, and it comes down to the maxilla here. And so essentially this region is pushed in a little bit from that antemortem trauma. And up here, the nasals, because of those fractures and the way that it healed, some of the bones somewhat overlap one another.
would you expect to see plastic deformation if bone heals when it's malaligned? What might result?
I probably wouldn't use the term plastic deformation. I would say that it's displacement related to the healing and the fracture.
And where you've just, that area there, showing you what's been marked as State's Exhibit 140. Do you recognize that photo?
Yes.
Is that a better depiction of that area that I just circled?
It is a close-up, yes.
And tell the jurors what you're seeing in that photograph.
If I draw, can you erase mid-talk if I ask you to?
Sure can.
Okay. So what we're seeing is here, this is all left nasals, and this is all right nasal bones, and then you have maxilla on either side. And then what I'm seeing here is from the antemortem trauma, we have some displacement of those nasals that were fractured, and you can see that there's all these rounded edges where the bone has healed on top of itself in that area. And so all these rounded edges here are all evidence of antemortem trauma.
Can I clear?
Yes.
Do you see any perimortem trauma in
No.
this picture? You do not. Specifically, this area right here. Do you see any perimortem trauma there?
No.
And why or why not?
It looks like the nasal aperture. It looks like the rim of the nasal aperture right there. And in fact, I mean, if you're thinking about a fracture occurring, you'd have to have another part of the bone that fractured off of there. And this is already extending well into that nasal aperture.
Was this photo one of the 4 photos, State's Exhibit 140 in Dr. Agnew's report?
I believe so. I'd have to double check.
Showing you what has been marked as State's Exhibit 143. Tell me if you want me to reorient the photo as well.
That's fine.
Do you recognize this picture?
Yes.
And I can't see that. And what is it?
So this edge right here, right, is that nasal aperture on the left side of the maxilla.
So, and with that, I want to show you 140. Is that seen in this picture?
No.
Is it seen in 139?
Yes.
Just to orient ourselves and show the jurors where it is.
So it's it's this region right here. And so this, sorry.
Nope.
So the line I drew in the last one is consistent with the line I'm drawing right here.
So now I want to go back. First, before we get to that line, describe, here's a good fracture.
This destruction in the bone right here is another antemortem fracture. You do have some space and gap that's still here, but it's very clear that you have rounding of the edges up here. And if you were to slide it down a little bit, I mean, ooh, my arrow's in the way. There you go. You can really see how that's healing up in that place. So that's an antemortem fracture. And it in some of the images too, you can trace that antemortem fracture up and continuous with the nasal bone fractures.
Is it possible in one fracture to have antemortem and then perimortem?
No, in a single fracture, if there's signs of healing at all on that fracture, it's antemortem. If you had an antemortem fracture that was then refractured, there would be signs of that. You'd have disruption in the healed bone that was there.
I want to show you what's been marked as State's Exhibit 142. Do you recognize this photo?
Yes.
And generally, what is this depicting?
This is the left side of the face, showing this is the nasal aperture right there.
And with respect to antemortem trauma in this photograph, do you see any?
Yes. So this is the fracture that I was going to dot it. that I'm going to run alongside it. This is the fracture that we just noticed, went over in the slide previously. And you can see that fracture line continues up here. In some of the actual JPEG photographs, you can see it better that this fracture line then continues over on the nasals there. There's also another healed fracture that kind of comes in that way.
Want to go back to the State's Exhibit 143. Is that same line?
Yes.
What about, and so this is ante-mortem in your opinion?
Yes.
Talk to us about this edge.
That edge is the edge of the nasal aperture. Can you scroll it up a little bit,
of course,
please? You can see here that this edge is the same as that edge. That's just that edge to the opening there.
And so, an opinion with respect to this edge being perimortem, what would your opinion be as to that finding?
No, there's no evidence of perimortem trauma.
That's State's Exhibit 143. In this picture, 142, was there any post-mortem trauma noted in Dr. Agnew's report?
So we wouldn't refer to postmortem as trauma. We would use the word damage. No, there was not.
Let's talk about, why do you say post-mortem damage and not trauma?
Trauma infers that it was an injury. Something that happens post-mortem is not going to be an injury.
Did you notice through the course of your review of the photographs in this case that there was post-mortem damage as depicted in State's Exhibit 142?
In this case, the lacrimals are damaged. Usually we're not going to have a big hole there. There's a bone that covers right there.
And where does post-mortem damage, how does it happen?
There's lots of ways. When remains are exposed to the elements, there's animal scavenging, birds, rodents, anything that is like post-depositional. So even transport of remains, processing the remains, that would all be post-mortem damage.
And if you, in your work doing external case reviews, well, I guess case reports, would you include post-mortem damage if you saw it?
With a post-mortem damage to the lacrimal, we do see that fairly often because it is a fragile area there. If it wasn't in the report, it should be in the bench notes.
And what are bench notes?
Bench notes are the notes you take as you're analyzing the case that then you use to synthesize your report from.
Showing you what's been marked as State's Exhibit 131. Do you recognize this?
Yes.
And what is it?
This is the photograph after processing of the hyoid bone and its elements that were available.
And tell us about what's depicted on what would be my right side of the photograph, on this side.
Right, so the hyoid actually starts off as 3 separate pieces where you have the body of the hyoid, actually more than 3, but 3 that you can see here. The body of the hyoid, a greater horn here, and a greater horn here. There are lesser horns that are tiny that would actually fuse on there too. With age, some individuals' hyoids do fuse the greater horns to the body there. Not everyone's, but many do with age. And so that's the hyoid there. This is the fragment of the left greater horn, and we don't have the fragment for the right.
Do you know, based on your review of the materials in the photographs, where this greater horn is?
No.
Anything noteworthy with respect to the fracture that appears here and here?
I mean, the fractures are occurring in the greater horns.
And this is, I'm trying to find a picture pre-processing. Thank you. It is marked, but I'm not sure the number.
When they say processing, it makes it sound like they're making her into a sandwich.
That peroxide and the effect it can have on bone. Showing you, do you recognize this photograph?
Yes, that's an autopsy photograph of the hyoid, the major component of that hyoid.
And is this photograph, if you know, before or after the processing done at Ohio State University?
Pre-processing.
And this is after processing?
Correct.
This was a slide that was shown yesterday, States Exhibit 138. Tell us what we're seeing here.
These are the two stereomicroscopic photographs that I had to review of the superior horns of the thyroid cartilage.
When you said stereoscopic pictures, what does that mean?
So a stereoscopic microscope, we can look through with two eyes. It'll be low magnification. We're not looking for cells. We're just trying to get a better look at margins. And when we're using a stereoscopic microscope, most of them or many of them will have a camera built in so that we can take photographs of what we're seeing to document that.
And the greater horns, are they present in this photograph?
The superior horns of the thyroid, yes.
We talked about it earlier, but to come full circle, this photograph is before or after processing?
After processing.
And it is, again, a picture of the thyroid cartilage?
It's a picture of those superior aspects of the thyroid cartilage.
When we talked earlier about not having a photograph of the horns or the thyroid cartilage before being processed, why is that important?
What I teach my students is you want to document. I'll take hundreds of photographs. And what I'll do, especially if a case were to come in that there was any suspicion of hyoid or thyroid fractures, I would look for those. I would document those prior to processing so that I could show that any kind of defects were there before I did anything to the remains.
And I know you defined peri-mortem days, weeks, months earlier, but based on the photographs that you reviewed, and particularly States Exhibit 138, can you rule out the possibility that either of those fractures occurred during removing of the body from the scene?
Objection, Your Honor. Who we approach? Sure.
Missy, that is a great point. We don't know who did it, and that's the issue. Yeah, this is just crazy what they're reviewing here. I mean, this is just awful. I'm going to go through some of these real quick. So when it comes to disclosing their pay, like you disclose your compensation just to show that you're honest and what's going on there. Has she given her opinion on phrenology yet? No. This is very big. She's only testified for the prosecution previously. This is her first defense case. That shows a lot of impartiality on her part. that she does primarily prosecution cases. Who skipped bail? Don't worry about that. I'm glad you guys were all concerned about me. Thank you again, Leonard.
138. It's entitled, this was a slide with Dr. Agnew, perimortem trauma. Let me lead with, do you see and did you find perimortem trauma on the thyroid cartilage?
So with the thyroid cartilage, I didn't see anything that was inconsistent with anthropologically perimortem fractures of the thyroid cartilage.
Tell me what you mean by anything that's inconsistent.
There is nothing to suggest, based on the photograph that I'm viewing, that these fractures cannot be perimortem. You see on the one side, there is some fraying suggesting that the bone was relatively fresh when that occurred. Also, the ossified thyroid cartilage, it's not a normal bone. It's not, because it starts off as cartilage. So what's happening is as you get older, that cartilage starts to calcify and turn to bone just as part of the degenerative process. So it's not the same bony thickness or texture. And so you might get fractures that are slightly different in that structure.
Showing you what's been marked as States Exhibit 37 and 36. And I put them side by side for a reason. Do you recognize those?
Yes.
And what are those?
Those, again, are the superior horns of the thyroid cartilage.
That we see in this picture 138.
Correct.
And describe the fractures that are seen there.
The fracture over here on this side, again, you can see the bone has been pulled apart. You have what's delamination or bone tearing occurring, which would indicate some elasticity to that region. Over here, I don't see any signs of healing. It looks different. You don't have that fraying there, but again, because the thyroid cartilage ossifies a little bit differently, I don't have anything to say that that's not perimortem.
From an anthropological perspective, if it's said that these fractures are perimortem, is it possible to say this one happened 4 weeks ago and this one happened 5 weeks ago?
No.
It's not. The perimortem, we just know, is days, weeks, or months, or you said even up to a year.
Yes.
And I'm showing you what's been marked as States Exhibit 41. I know I asked you about this image and whether you saw perimortem fracture there. I hadn't shown you this image, which is the same, is it not? That's depicting the same area?
Yes, the arrows are depicting the same area.
Do you have the same finding and conclusion with respect to not seeing perimortem trauma in this image when you also compare it to that image?
Yes, I didn't make any of my conclusions off of a single image. I would look through all images available.
So circling back, I could. Well, let me go now to the last page of your report so that you can talk through what we're seeing there. Page 15 of your report. Let me clear and zoom in. These are 15 of 15 of your report. Does that sound right?
Correct.
And tell the jurors what these images, they seem to be A, B, C, D, E, and F are depicting. And let me try and get to a place where they're clear.
So if you recall, part of my review that I was asked to do included Dr. Smock's report. And so some of my findings are refuting some statements that were made within his report. In his report, I noted that he had a drawing from an anatomical textbook of the hyoid and thyroid process and really emphasized how far apart they were from a drawing. And so I went to the literature to find CT scans, which are actual depictions of actual individuals' hyoid and thyroid cartilages.
Before I ask you about what we're seeing in these pictures, showing you what's been marked as Exhibit 130 by the state, you mentioned that there was a drawing included in Dr. Smock's report. Do you recognize this?
That's the one I'm referring to.
And tell the jurors what you mean by it seemed to show.
Well, not just that it showed a large space. He was emphasizing in the written part of his text that it's a large space. That space is going to vary individual by individual. A lot of anatomical texts are drawn to emphasize the individual parts for medical students. And even as you're sitting there and swallowing, you'll get movement of that thyroid cartilage and the hyoid bone.
So going back to so it was in response to this drawing that you included these images in your report.
Yes, because I felt it was misleading.
And take us through, let me pull this off. See if that gets clear for the jurors. Okay, take us through the A image. This image right here. What is that showing?
So this entire image within the box is the figure and the caption from this article, Becker et al. 2014. And so their caption reads, Figure 1, normal ossification patterns of the laryngeal cartilages and hyoid bone in a 65-year-old male with complete ossification of thyroid and cricoid cartilages A through C, and then a 41-year-old male with incomplete ossification D through F. So one individual is the top, one individual is the bottom. A and D are axial images, so say CT scans. They're difficult to interpret, but the reason I included them was for the actual 3D renderings of those cartilages that you can see in B, C, E, and F.
Tell us where in B, C, E, and F you're seeing the hyoid bone.
So this is the hyoid bone here, 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 and here. So these are two different individuals.
Yes. Now, what about the question? Well, but Dr. Garvin, those images
thank you
don't
so
belong
much.
to a
You're the man.
100-pound woman.
That's true. We will never know exactly how a decedent's hyoid bone and thyroid bone sat in themselves when we don't have the soft tissue connecting them anymore.
Tell us where the thyroid cartilage is in each of those two individuals.
So the laminated thyroid cartilage are here, and then the horns go up here.
Now the horns that you just talked about, could you, it almost appears as if they are, are the hyoid and the thyroid cartilage connected by the horns?
There is no joint there. There's no connection right there. Other than through, there's the thyroid hyoid ligament, which is connective tissue that attaches the hyoid bone to that thyroid cartilage.
Is there anything in between the hyoid and the thyroid cartilage?
Yes, that's that thyrohyoid ligament I just mentioned.
I want to talk more about your findings with respect to Dr. Smock's report. And I know we went through it in the beginning, but tell the jurors with respect to the findings that he made regarding the 4 fractures could never be from a hanging. What is your opinion with respect to that conclusion?
There are no thyroid hyoid fracture patterns that are specific to manual strangulation versus hanging. It is possible to get them. They're very similar mechanisms in creating that compression there. So you cannot say that it cannot happen with hanging.
And tell the jurors what you base that opinion on.
Well, I had my individual knowledge. I have my knowledge of my peers as well. But I don't like to just rely on what I know or what I think I know. So I go to the literature and I research and I see what the literature says and whether it supports that conclusion or not.
Showing you what's been marked in your report with respect to your conclusion that those fractures could be from a hanging. Did you cite literature?
Yes. And can I be clear? I'm not saying it was a hanging. All I'm saying is that fracture pattern, you cannot say it's inconsistent. You cannot say you get that fracture. You cannot say you can't get that fracture pattern from a hanging.
And I was going to ask you that question, right? You're just saying it can't be ruled out. Is that a better way to say it?
Correct.
Marking this as defendant's QQ. This has been provided in materials. Dr. Garvin, do you recognize this publication?
Yes.
And what is it?
So Zadapkova et al. Is a 2018 article in the Forensic Science International. They did a very thorough review of a lot of the literature out there on laryngohyoid fractures in hanging. I think they have 204 citations in there, so it's very thorough, as well as their own study looking at fractures in that situation.
And tell the jurors why you include this as publication that supports your findings with respect to Dr. Smock's opinions.
So while a lot of the literature out there refers to combined hyoid and thyroid fractures, it doesn't actually specify whether they're unilateral or bilateral. But this article did. This article specifically referenced bilateral hyoid and bilateral thyroid cartilages.
What is the ultimate conclusion within the article?
While it was a small percentage, 3.4%, it did occur.
And when you say it did occur, what do you mean by that?
In 3.4% of their study sample, they found bilateral hyoid combined with bilateral thyroid fractures in hanging.
Would you say in response to, well, tell the jurors, does that article specifically study women that are 100 pounds in weight?
No.
And is there a study that you found with the same or similar findings that only studies women that are 100 pounds in weight?
No.
I'll ask you the other question. And if you search for one, is there any literature, publication, anything to support that a 100-pound woman with those 4 fractures, so the 2 bilateral flat fractures on the hyoid and then on the thyroid cartilage, was manually strangled?
The literature, this is actually a hot topic in the literature as far as number of fractures with hanging. There are dozens of articles that do contradict one another. I did go through a lot of the literature. I looked for manual strangulation articles as well. I did not find any that specified a 4 fracture pattern. The only unique signature that is suggested in the literature for manual strangulation is fracture of the cricoid cartilage.
Could you explain that last part?
For something.
Your Honor, can we approach?
Hi, Mr. Martin. This is Kathy calling from Lyndhurst Municipal.
Fuck. Fuck a duck with a rum truck. Guys, so here's the thing you need to understand about the issue regarding a directed verdict or motion for acquittal. The judge has to view all the evidence in light of the prosecutor and the non-moving party. So he's going to have to look at it in their favor. So this here is actually correct, Matthew. He has to view everything in light most favorable to him. And could a jury reasonably, convict based upon this evidence? And he's probably going to let the jury decide, and then he can always throw out the jury's verdict if they convict him and he doesn't believe so. I don't think he's going to do that. I don't think there's going to be a directed verdict. There should be, but that won't happen. Yeah, Heather, I'm sorry. I was kind of like just spacing out. I'm alive. Yeah, she's right. He's right on the burden though, and they haven't proved anything different. There's nothing here. This is it is as far as you put in the jury's hands, and now it's not really on. And Jim, you brought up a great point. It's not on the defense to prove she committed suicide, but it's up to the state to prove the husband killed her and placed the body there. You're correct. But if they can show an alternative, that is helpful because now they're not just walking up to the jury saying you can't believe them. If you could present a credible alternative, you always try to, because now you're not just asking them to buy your story. You're asking them to see here's a legitimate answer. I do like the prosecutor sitting there chopping on her pen. Lucknav, and if I mispronounce your name, please let me know. Let me know how you pronounce it so I do it right. I know there were some concerns that how this get past a grand jury. In Ohio, a grand jury is 9 people. You need 7 of them to agree to issue an indictment. When it comes to a grand jury, it is just the prosecutor, and then he brings in the police officers, and he probably brought in the coroner, and they told the story of Matheau Moore killing his wife. And the grand jury said, okay, cool, that makes sense to us, so they indicted him. It does not take much, and in America, we have the phrase, you can indict a ham sandwich, because it's very easy to get an indictment. It is not hard at all. Not hard at all. This is going back to CG asked a question during the summers when he was cross-examining his wife. Do I think the rules should be changed to prevent situations like this where the defendant's, doing it just to harass and make fun of the victim? It doesn't seem like an effective use of the legal system. And it isn't necessarily is, but remember, he has a right to confront his accuser, and that is a constitutionally protected right. It doesn't matter that he's a dick. It doesn't matter that he's terrorizing someone. He has the right to confront his witnesses. And he wasn't being, he was being very oafish about it, but overall, that wasn't too bad. At least the parts we saw so far. A nickname, don't worry, all good then. Oh, Jim, I 100% agree with you. There would have to be some evidence that the accused actually did something. Just prove she was murdered doesn't prove by who. You're right, 100% without a doubt. But the state believes they can show it, and they're going to show it by his actions, the fact he used her in the past tense. They're going to try to use that. It's very circumstantial, but they are trying the best they can there. And I mean, I think one of the biggest things is they don't establish where he got the cord from. Nothing in their house is missing a cord. He didn't order a cord on Amazon. So. No, I did not hear that last night. I switched off after a while. That's it, though. I disagree with him about making the warrant. Everything on that warrant should be exposed. Screw hiding anything. Is the cord something new? Well, it's just there's no indication the cord. We don't know where the cord came from. We don't know whose it is. There's no evidence that it's theirs. So. We don't know where it came from, and we don't know who owned it, and there's nothing tying it to Moore. So, and it's not like they, it's a male double-headed USB cord, and there's no way they're missing that. That's been okay today. Hope you're having a good day, Harris.
After discussion, ladies and gentlemen, I'm going to strike the answer to the last question. We're going to start with another question.
I don't think that should have been stricken.
As part of the court order, you were allowed to listen to the testimony of other experts. Were you able to listen to the testimony of either Dr. Agnew in full or and in part? And the same question about Dr. Smock.
In part for both, most of Agnew's and a part of Smock's.
And during the time of their testimony, what if anything, were you doing that might have prevented you from listening to the full thing?
Traveling out here.
With respect to a statement that Dr. Smock made under oath when he testified that there is absolutely no literature supporting that a 100-pound woman could have the 4 fractures and from a hanging. What, if any, opinion do you have with respect to that statement?
Well, it's obvious that there is at least one article, if not more, indicating that this fracture pattern can occur with hanging. While it may not specifically have a 100-pound, 52-year-old woman, there's lots of things regarding the scenario. And I mean, there's ligatures, there's health, there's bone density, there's a lot of different factors that go in. I would not be comfortable saying that this could not happen, given that it does.
Showing you what's been marked as Defendant's Exhibit II. You just mentioned that there's literature. Do you recognize this?
Yes.
And if you could, what is this?
So this is an article by Betts and Eisenmenger. I'm probably butchering that. Apologies to the author. In the American Journal of Forensic Medicine and Pathology that was published in 1996.
And are you familiar generally or specifically with this article's, the study that was done and the conclusions that were reached?
Yes.
And what was the data set, if you will, that was looked at in this study?
As the abstract mentions right here, it's a total of 109 cases of suicidal or accidental hanging evaluated looking at the hyoid bone, thyroid cartilage for fractures.
And what, if any, conclusions are in that publication with respect to individuals that had those 4 fractures or the bilateral fractures?
So of the individuals that displayed fractures, 7 individuals or 10% of those individuals had bilateral hyoid and bilateral thyroid fractures.
Going to page 3 of that article, are you familiar with page 3 of that publication and the chart that is on top of page 3?
Yes.
And how, if at all, does that chart relate to the finding that 10% of the 109 people had the bilateral fractures and also died of a hanging?
So the only sample in this study is hanging, suicidal and accidental. But what they're doing in this table is they're breaking it down by age cohort, just because age has been shown to be a significant factor when it comes to these fractures occurring. So they're showing the age number is the number of individuals they had in their sample at those age ranges, presented positive results, and then the actual number of individuals that had 1, 2, 3, or 4 fractures per those age groups.
You mentioned that age can be an important factor. Why is that?
So the numerous articles have showed a correlation between age and fracturing of the laryngohyoid elements. Part of that is probably due to fusion of the hyoid bone, those greater horns to the body. Part of that's probably also the ossification of that thyroid cartilage.
After hearing the portions of Dr. Smock's testimony that you did, and also hearing the portions of Dr. Agnew's testimony that you did, I want to go back to Defendant's Exhibit TT with respect to the findings that you made in this case that are summarized here in the first paragraph. The first finding, again, with respect to perimortem fractures, is that still your finding a conclusion based on a reasonable degree of medical certainty in this case?
Yes.
Second one, with respect to no evidence of perimortem trauma to the cranial facial region. Does that remain based on not just your review of the materials and the photographs, but also listening to the testimony of both of those individuals?
Correct.
Have you also done additional research into these areas while this case has been pending?
Yes.
Just describe generally, how much time would you say that you've been looking to find any literature? And I joke because I've come to know you and how much you work.
I like to be extremely thorough in my work. I want to make sure that any conclusions that I'm drawing are correct, just not only based on my knowledge, but the knowledge that is out there in the fields and in science. If I had to put it a number, I'm embarrassed to put a number into. I'd have to say at least 50 hours.
And have you discussed your findings and conclusions in this case just generally with your peers?
I have asked my peers.
I didn't ask what your peers said.
The answer is yes or no, because you had the discussion.
Yes.
You
Yeah,
have.
that's the question.
And why, without saying what those conversations were, why would you do that?
Because some of those individuals work in medical examiners' offices, and I want to confirm that everything that I know and everything that I'm seeing, that there's not evidence against that.
So I'll go now to the third finding with respect to the antemortem trauma to the nasal bone and the left maxilla. Does that remain your finding in this case to a reasonable degree of medical and scientific certainty?
Yes.
And then lastly, with respect to the fourth finding, the potential area of slight postmortem damage to the left lateral nasal aperture. Does that remain your finding in this case to a reasonable degree of medical and scientific certainty?
Yes, we did not show that or discuss that, but yes.
Yeah, we talked about the aperture though.
But we did not talk about the potential postmortem damage.
Oh, the postmortem. I'm sorry. You know what?
Sorry.
Let's do that now. Let me get out the picture of the nasal aperture. Showing you what's been marked as State's Exhibit 41. Tell me if this picture can be used to illustrate your fourth finding.
It's not the best one.
Let me get to the other one. 1 second.
Is it possible to use a figure from my report?
It is, yes.
That might be
Which
easier.
page?
Page 14 of 15.
showing you page 14 of 15 of your report. Tell us what we're seeing there.
So in this figure, I'm documenting what I stated as potential postmortem damage. And so again, I had 432 photographs. Some of them were from the scene. And so from the scene photographs, I zoomed in really close to look at that nasal aperture to see what was there prior to anything happening. And you notice on the left side of the maxilla is the area in question here. Well, can you delete that arrow? I'm sorry. The nasal aperture, that rim around that hole, looks fairly continuous right there. That green arrow is pointing to where that antemortem fracture is on the left maxilla. This was another view over here from the scene. And again, you can see it's fairly continuous right here. Okay, we don't have a large gap there. And then this was a photograph from Autopsy, at which point I noticed where that green arrow is down here at the bottom, that there's a small area of white on that fracture margin, on that nasal margin there. Color differentiation is one of the things we would use to look for postmortem damage, because if something happened more recently, it's not going to be stained from the decompositional processes and the environment. So that seemed questionable, which is why I went back to the original scene photos. You can also see that it's not as continuous. There's an angle there. Again, based on the photos, I didn't feel 100% saying that this is postmortem damage, which is why I put it as potential.
Could you circle the discoloration that you just talked about, just so the jurors know? And
it's a little washed out.
Nothing further.
Absolutely, yes.
Ladies and gentlemen, our afternoon break. Remember the court's admonition. See you back at the usual time.
Yeah, so I mean, once again, this is not this is just an awful. I mean, this is the best they got. I'm very disappointed. Once again, I did bring it up, though. There are issues where if you think you have a case, and even though you think it's bad, you still go for it. So in this case, they are, or at least they're trying. Oh, there you go. Wait, what? Oh, the camera's working. Okay, well, that's good. It's working now. So yeah, this is not a good case. This is really falling apart. I think they're having a lot of problems, but it sounds like they're going to keep hanging in there. They will not quit. All right, Matt, you take care. You have a nice night. Thanks, Matt. I appreciate it. Take care. Thank you for all your help. Chaucer is asking what I keep asking myself is whether I could convict him simply because it was his wife. And that's a very good point. Based upon everything you see here, are you willing to put a man in prison for the rest of his life? And I don't think you can. Missy, or Miss Cappy P is saying, did they show the cord in court? The gauge would make a big difference to see what it went to. It looked like a normal USB cable, so just like a typical one. Luke Pearson's asking, how bad did the coroner do that a directed verdict is the correct result? He didn't do bad. It's just, you have to run with what you got, and there isn't a lot there. So I don't think a directed verdict is going to be the outcome here. As much as we'd like it or want it to be, that's not going to happen here. If it does, I'm very surprised. If it does happen, it would be after the jury has a chance. Justin Smith is asking, so how long did he have to sit in the cell while they looked for the nothing they have? Well, they pretty much found it all right away, but yeah, he's been sitting in jail for a long, long time. Long time. Also COVID doesn't help because COVID kind of delayed everything. So, yeah, even on top of that, even longer. Ethan saying the prosecution in this whole trial excludes small PP energy, especially that one dude with the beard and the comb over. Yeah, it does. Also, Ethan, I don't know if you heard me say it, but for Monday, thank you for your super chat. I appreciate it. Chaucer says, well, the prosecutor has no PP, so coming up on a year in jail, yeah. Aaron Gogol, COVID was a great excuse to deny everyone the right to a speedy trial. You have no idea. I mean, a lot of things have happened that, courts got to put it on pause, basically. There are some courts that are just now getting back into the swing of things that I'm aware of. Yes, it is ridiculous what happened in the name of COVID. Ethan, everything was a mess. Ethan says, I meant to ask if it went through because the literal second the stream ended. Yeah, but you can still comment as long as I haven't completely closed everything out and just shut off broadcasting. I think people still comment afterwards. So I think you're able to for a little while at least. But yeah, that was just timing wise. Going back through here, Chaucer, you brought this up. It seems like the whole trial is a whole lot of nothing with a light seasoning of inference of guilt. Pretty much. You're very correct. And Jim Satala, this type of stuff shouldn't happen in America. They have really strained the meaning of probable cause. Well, no, they meant probable cause, because remember, probable cause is like 25, 30%. Like, is it possible or probable this happened? Okay. But I don't think they're really able to get higher than that. I would argue they're not even at a preponderance of the evidence, like a 50% standard. So, yeah, it's not a good case. But for whatever reason, the prosecutor wanted to go forward on it. So, his bail was initially $2.5 million. What was his bail set to, was asked. We can check again right now. There's bail's at currently. Okay. Matheau Moore. Let's see what his bond was. Because I have a feeling it's not going to matter coming up soon when the jury acquits him. Oh, I forgot to check the poll now. We've had 73 votes. Guilty 12%, not guilty 43%, undecided 25%. Where are the toes? 18%. A lot of people are concerned about the toes. I think that's a good thing. And then, yeah. So there's a lot going in his favor. If you guys are thinking it, certainly some of the jury are as well. Yes, his bond was set at $2.5 million last June. So yeah, that has not changed. There's still $2.5 million. That seems high. Is it typical? Well, it's I mean, it's getting to the point where that's almost unreasonable because he can't make it. And is he really a threat to the community? No. I mean, the allegation is he killed his wife. It's not that he's like a serial killer or a spree shooter or anything like that. So no, I don't think it was necessary to do that, but they did it anyway, and they said it, and I think that was improper. Luke Pearson saying, I'd be using that toe to make a point about police sloppiness. I'd be using that. The fact they don't have pictures of how the cords were sitting on this lady's face. They don't have how things were presented on her neck, how they found it. We cut it down. Yeah. Wait, he wasn't, Luke is asking, actually, Luke says, because some of the jurors are already asking about, police sloppiness is a big deal. People don't like seeing the cops get sloppy. And Luke Pearson's saying, wait, was he jailed pre-indictment? Yeah, I think he was arrested and then they indicted him because he got charged with the murder initially. So, yeah. Oh, hold on here. What did you say, Matt? So, Ethan's saying, if he gets acquitted, I hope he steps out of the courthouse and puts on a necklace of toes. Jeez. Yeah. 2.5 million is a lot of cheese from Bifrons. It is. So the only other option is to get a bondsman for $250,000. And is that going to work? I mean, you got to find $250,000. You're just willing to poof, never get back again. So that's rough. Chaucer, that's a good point. Is already you're in jail enough for the scant of evidence? Yeah, I would argue. Yeah, we're already to the point of how is this even fair? And it's not. It's definitely not. So. Let's see if we can find his end date for the jail. I know some of you guys are looking or curious. Let's see, Moore. Moo. Matheau Moore was 6/17. So it was quite a while actually before they had him arrested. They found the body in September of 2020, and then they didn't arrest him until June. So right after that, he got arrested at the time of the indictment. So. Okay, so Locknav is asking if the jury finds him guilty, can the judge sentence him to 1 year, also time already served, or is it a minimum sentence? No, he's been charged with murder. So if they convict him of murder, that is a minimum 15 years to life in prison. So any sentence he gets a minimum 15 years by state law. If he got sentenced to less, his sentence would be reversed and he would have to get resentenced in accordance with law. So the mandatory minimum is 15 years. And at that point, the parole board determines if you're eligible for parole after 15 years, but not before. You have to serve 15 years. It's mandatory. So if he gets convicted, it's not good. Luke saying $250K probably was all his money, so it was either Bond or Diane. He made the correct decision. Yeah, seems like he has. Chaucer's asking, I just need something to tie him to the body or the scene, anything. Well, I mean, I was about to say no pun intended, but that works good with the printer cable. 7-Eleven's asking, is it true alcoholism is a viable murder defense? No. I mean, having a drug addiction, being an alcoholic, those aren't viable defenses. They're the only real viable defense to murder is self-defense. Nothing else really counts. The only other thing would be like mistaken identity. Some other guy did it. So you guys are asking some really good questions here. I think this is a really good one. Yeah. Sorry, I forgot to put this up. Yeah, no, it's a minimum 15 years to life in Ohio. And certainly you could be in there for life if the parole board determines so. Justin says if they could even prove she was murdered, they would have a case, but they don't even have that. Well, if they prove she was murdered, they still have to prove who did it. And they can't prove he did it. There's nothing tying him to it. So even proving the murder is only half the battle. D&D Princess says that's the thing. I'm not even convinced she was murdered. But even if the jury thinks she was murdered, they haven't shown anything connecting him. Yeah, that was kind of like my dovetail off that. You got to show he did it. I mean, without that, you've got nothing because, okay, great, she was murdered by who? And you have nothing there. No, Luke. So it's not mandatory life. It is a mandatory minimum of 15 years with an indefinite life sentence. So if you get convicted of murder in Ohio, you serve 15 years, then you're up for parole. And then you have your parole hearings every couple of years. And the parole board, just like in Shawshank, determines if they release you or not. The parole board has the authority to deny your release. So theoretically, if they never approve it, you die in prison. So it's a minimum of 15 years with the possibility of a life sentence as an indefinite sentence. I hope that makes sense. Did she move for a directed verdict? You does not get done in front of the jury. That's all done off the record. So we'll see when they come back what's going to happen. So sorry guys, checking something else here. Oh, it sounds like we're coming back. I hear noises. Let's see what's happening.
Thank you. Have a seat. Have a seat.
CG, you're asking what checks do we have in place to discourage overzealous prosecutors from taking these crimes in?
You're welcome. Good afternoon.
Voting them out.
I'm not trying to put words in your mouth. If I ask you a question, you're not sure what I mean, please stop me. I want to make sure that we're asking clear questions and getting clear answers. Fair enough?
Understood.
All right. So I want to start with you termed it when defense counsel asked you if you did an analysis in this case, you sort of stopped. Is that fair?
Well, I analyzed the reports.
When the word analysis was used, you said, well, hold on, it was really a case review. Is that correct?
Correct, because I wanted to specify.
And so you, in this case, did not do when you had listed on your resume as full forensic analyses, forensic anthropological analyses. This is not one of those.
Correct.
This will go under the case review part of your resume.
Correct.
And so as a result, you never looked at the bones yourself in this case, correct?
Correct.
And so what you did is reviewed the other reports that you talked about, correct?
Correct.
And you reviewed the photographs that were provided, correct?
Correct.
But you yourself did not do an analysis of the bones.
Correct.
And so your report then, in part, is a criticism of some of the ways that Dr. Agnew wrote her report, right?
Not just the ways, but the conclusions based on the photographs.
And we'll get to the conclusions, but I want to talk first. You talked about criticizing the way that, for example, the age range was written, correct?
Correct.
Now, we're here talking about injuries to the neck and injuries to the face. We're going to talk about those two topics. But would you agree with me that an age range of this skeleton has nothing to do with those two things, right?
It does not have to do with the trauma, correct?
And so whether or not she used one standard deviation or two standard deviations, that doesn't affect in any way your conclusions about the types of trauma that we're seeing in the skeleton, correct?
Correct.
Same thing with regard to toes being missing. Whether or not they documented what toes were where, that has nothing to do with your conclusions about the trauma with regard to the neck and the face, correct?
Correct.
Same thing with regard to the discrepancy in what teeth were present. Whether or not one molar went here, one molar was in the dirt, one molar went for DNA, that again has no impact whatsoever on your opinions on the trauma to the neck and face, correct?
Correct.
Same thing with regard to the lack of a pre-processing photo of the thyroid. Because even without that, you concluded that there was perimortem trauma to the greater horns of the thyroid, correct?
Correct. There's anthropologically perimortem trauma.
Same with regard to the potential area of postmortem. I'm going to call it eye socket because I don't have a clue what the word was you used. The postmortem eye socket damage.
The lacrimal, correct.
Lacrimal. Whack-a-mole. Put it down as that. The eye socket damage. That again has nothing to do with your ability to conclude about the damage to the neck and to the face.
Correct.
So fair to say that a large portion of your report disputing some of the ways that Ohio State documented things really has nothing to do with the reasons why we're here today, right?
Well, the reason why I'm here is because I was asked to review these reports and I was asked to review them in whole. So that's what I did.
That's fair. Let me ask it a different way. What's important for the jury to determine is what injuries are present in the neck and face. Would you agree with that?
I don't know that I can say.
Jury determines credibility, which these things all go to.
You can go ahead and answer your question.
I mean, you go ask the question.
I'm sorry. She'll answer the question.
The most important detail out of the anthropological analysis is the damage or lack of damage to the neck and face. Would you agree with that?
I hesitate because I'm not familiar with the entire case. And so I don't know what other aspects of the case there are and whether some of the things would be relevant in my report.
You would agree with me that you wrote a 4 bullet point summary of your important findings, right?
Correct.
You would agree with me, number of teeth not matching up, is it in the 4 bullet points of the summary that's important?
Correct.
Same question with regard to where the toes are, right? Not in the summary.
Correct.
So when you wrote your report, you knew that the important parts that we're talking about are injury or lack of injury to the neck and face, correct?
Correct. Those had the highest implications or impacts.
All right. And those other things that you talked about, your criticisms of Ohio State's report or potentially their processes, don't impact your opinion with regard to the trauma to the neck and face, correct?
Correct.
All right. So let's focus on the things that are important. You would agree with me that accuracy is important, right?
Correct.
That words matter, correct?
Correct.
I want to talk first in this bullet point, number 2. You wrote in your summary, bullet point number 2, that there is no evidence of perimortem fractures to the craniofacial region. Is that what you wrote?
Correct.
No evidence is the phrase.
Correct.
I'll show you the bottom. We go to the top of page 2. I'm going to start with the materials and through maxilla. Can you read that sentence for us?
The materials I reviewed support the perimortem fractures to the laryngeal structures, hyoid and thyroid, but I did not observe evidence of definitive perimortem trauma to the nasals or left maxilla.
Evidence of definitive perimortem trauma, right?
Correct.
Top of page 4 of your report. Second sentence there, starting with reviewing. What's that say?
Reviewing the case photographs, I do not observe any definitive perimortem trauma to either nasals or maxillae, discussed further below.
Again, no evidence of definitive perimortem trauma, right?
Correct.
With regard to the bottom of page 6, when you are summarizing your findings, you'd agree with me again, you find no definitive evidence of perimortem trauma, right?
Correct.
So your opinion, the text of your opinion talks about whether or not there's definitive evidence of it, right?
Correct.
Not that there is a possibility of that evidence, right?
I didn't state anywhere that there is questionable fractures.
You would agree with me that the only place in your report in which you put no evidence, as in no evidence whatsoever, is in the summary on the first page, right?
Sure.
Everywhere else, there's that modifier. It hedges a little bit to say no definitive evidence, right?
Sure.
Now, you would agree with me that a two-dimensional picture does not capture all of the features that you can see on an actual bone, right?
I hesitate because I'm not sure what's meant by all the features.
Is looking at a picture the same thing as looking at a bone?
A picture is two-dimensional, a bone is three-dimensional.
Can you take a picture, digital or otherwise, turn it, look at it at a different angle, look at it under different lights?
I mean, you could look at it at different angles and lights,
But that doesn't change what's on the picture, right?
unless you have bad lighting.
Right.
Yeah,
That doesn't change what you can see on the bone in that picture, right?
correct.
If you had an actual bone and you couldn't see something as well, you could turn it, put a different light source on it, look at it a different way, and maybe you'll be able to see something that's not captured in that two-dimensional photo, right?
Correct.
So you would agree with me that a person who looks at the actual bone, who has the opportunity to do that, is in a better position to make a judgment about what's on that bone than someone who just looks at pictures, right?
It is ideal to be able to look at the remains.
So that person is in a better position than someone who's just looking at a picture, right?
It depends on that person.
I understand. I'm not talking about the quality of the person, the quality of review. I'm saying two situations. Either you are looking at pictures or you are looking at the actual bones. Which is better?
I would prefer the actual bones.
Because that's the best practice in your profession, correct?
Correct, when possible.
And so in this case, you did a case review looking at the photographs that were taken of the bones, correct?
Correct.
And in looking at those photographs, you believed that the photographs did not definitively support the conclusions of the person who looked at the bones, right?
Correct.
And yet, despite that, you did not ask if you could see the bones. Correct?
Correct.
You never made any effort to attempt to examine the actual source material that you're talking about today, the bones themselves.
Not, I would disagree with that statement.
Source material is a part of your objection, right? You looked at photographs.
No, that's
of the
not part
source
of my
material.
objection.
All right.
I did at some point agree to go look at the remains about 2 weeks ago.
Oh, okay, that's perfect. That's good. So you authored your report September 21st of 2021.
Correct.
So you got engaged to participate in this case on behalf, to write a report on behalf of the defense on September 3rd, right?
Correct.
And between September 3rd and September 21st, you reviewed photographs, correct?
Correct.
You determined that you believe, based on what you saw in the photographs, didn't match the conclusions with regard to the nose of Dr. Agnew, right?
Correct.
And yet you made no effort before authoring your report to see if you could look at the bones themselves, right?
Correct.
And so you also testified on direct that there were things in the report about the process. I think rehydration was the word that you'd never heard of before, right?
Correct. I had not heard of it as a process, as a term.
So surely then you picked up the phone and called and said, "What is this?"
To who?
The person who wrote the report?
I don't believe that would be appropriate.
Send an email to say, "What is the process that was going on here?"
When defense has asked me to review reports of an individual, no.
So if there's a report that's unclear to you, you just write a report that says this is unclear. You don't make any effort to try to clear it up.
Whoever requested the report would have the report that says, I cannot make this determination from there. And it is their decision then to decide whether to send me the bones so that I can make that decision if they're available.
You said you were able to listen to a portion of Dr. Agnew's testimony, correct?
Correct.
Did you hear Dr. Agnew testify about the procedures and processes they used to deflesh the bones?
I honestly can't recall.
Okay, so you have no idea if what she testified to fixes some of the concerns that you raised in your report.
I based my concerns off of her report.
I understand. And so what your conclusion was that the written report wasn't clear.
No.
It didn't have a time frame on it. So it wasn't clear how long the time frame was, right?
Correct.
So that part wasn't clear. You didn't hear the testimony I don't know, maybe it was only yesterday. You didn't hear the testimony yesterday, the day before, about how long any of those processes actually took place.
I don't recall.
Okay. Now, even after you authored your report in September of 2021, you still never asked anything about seeing the bones until you said 2 weeks ago.
Correct, and I still didn't ask.
Okay. I want to talk about trauma mechanisms. Generally speaking, in forensic anthropology, you're able to classify trauma mechanisms into a couple different categories. Is that right?
Correct. We will talk about the type of trauma.
And so you'll talk about a high velocity projectile type of trauma, right?
Correct.
Gunshot.
Correct.
You'll talk about sharp force trauma, correct?
Correct.
Knife, something with a sharp edge, that type of thing, right?
Correct.
You talk about thermal trauma, right?
Yes, or thermal modification. Yes.
Yeah, oh, thank you. Thermal modification, and that's burning, right?
Correct.
And then you have the category of blunt force trauma. Is that right?
Correct.
And so, generally speaking, when you are looking at a trauma mechanism, what you can do is classify that trauma into one of those four things, right?
As far as the trauma type, yes.
Okay. And so you would agree with me that the only thing that's at issue in this case is blunt force trauma.
Correct.
And so there wasn't any signs of gunshots or stab wounds or anything else. We're talking about blunt force trauma. Right?
Correct.
But you don't stop at classifying this as blunt force trauma. You go on to opine about a certain type of blunt force trauma, correct?
I interpreted the trauma.
And so that being hanging, correct?
No.
You said that you can't rule out hanging as the trauma mechanism in this case, correct?
That you cannot rule it out. Correct.
Okay. So I want to make sure that we understand each other. This is blunt force trauma to the neck.
Correct.
This is perimortem trauma to the hyoid bone, correct?
Anthropologically, correct.
Bilaterally, both sides.
Correct.
This is perimortem trauma to the thyroid cartilage, correct?
Anthropologically, correct.
Now, you testified on direct examination that you didn't see anything to rule out perimortem trauma to the thyroid cartilage, right?
Correct.
But that's not actually what your report says, is it?
The fact that I did not see anything to rule out, I didn't see any evidence that it was post-mortem or ante-mortem, went into my conclusion that it is anthropologically perimortem.
Okay, that's why I'm really sure we understand each other. So with regard to the hanging, your testimony is simply you can't rule out hanging as a mechanism.
Correct, as a direct refute in the reports.
With regard to the perimortem trauma to the thyroid cartilage, your testimony, your opinion is not just that you can't rule it out, but that it is in fact perimortem trauma, correct?
Correct, I would classify it as anthropologically perimortem.
Okay. So despite any of your other criticisms of the manner in which Ohio State did or did not do certain things, you reached the exact same conclusion with regard to the trauma in the neck.
Yes.
Okay. Now, those neck structures, I'm going to talk about them. First, the hyoid. That is I think it's been described as a free-floating bone. Is that a fair characterization?
Correct.
The only bone in the human body that's not attached to another bone?
Correct.
It's just kind of sitting in there underneath your jaw.
Yep.
Okay. It is not connected to the greater horns of the thyroid cartilage, correct?
It depends on what you mean by connected.
Thank you. The bone itself on the hyoid is not connected to the bone of the thyroid cartilage.
There is no joint articulation there, correct?
And so I think he testified on direct that there's a ligament in between those two structures in the neck.
Correct.
So there is a distance between those two structures.
Typically, yes, correct.
Not typically, always. They are not combined. The bones are not resting on each other, correct?
There is not an articulation there, but I would never use the term always because there's human variation and someone's might.
And so you picked out a couple of CT scan photos, right?
Correct.
Those CT scan photos, do you have any idea the positioning of those individuals at the time that those CT scans were taken?
No.
So whether somebody was laying with their head back or whether they were leaning forward, you have no idea what the position of their neck was at the time those CT scans were taken?
No.
You included them in your report because you believed that the anatomical drawing might be misleading, right?
Correct.
Fair to say that those CT scans might be misleading in the other direction, showing them closer together than they would be if I was standing here with my neck just like this.
I guess by misleading, I meant that it's a drawing. It's not actual people.
Right. Just like the anatomical drawing of a skull that you used as part of your slide.
Correct. The one picture, yes.
One of those was an anatomical drawing.
Yes.
Okay. So sometimes anatomical drawings are okay, sometimes they're misleading.
I don't understand. I would like the question clarified.
You believe that Dr. Spock's use of an anatomical drawing was misleading, but your use of an anatomical drawing was not misleading.
I put it alongside 4 photographs.
That was your opinion. Is that what you're saying? Is that those two situations are not the same?
Correct.
Okay. Now, you would agree with me that the fracture that occurred to the thyroid cartilage is not at the tip, correct?
It's at the base of the greater horn.
The base of the greater horn.
Sorry, the superior horn.
Superior meaning top.
Correct. Of the thyroid cartilage, correct.
Okay. So not only is there a distance between the hyoid and the top of the thyroid cartilage, right?
Correct.
We also have to account for the distance between the hyoid and the distance down that thyroid cartilage to the place where the break is, right?
I don't know what you mean by have to account for, but if you're saying, is there a space? Yes.
Okay. And so anything that would have caused injury to both of those two structures at the same time would have to account for the distance between those two structures, right?
What do you mean by account for?
As in, if I have a thin cord that isn't even as wide as the distance down the superior horn of the thyroid cartilage, that thin cord couldn't have fractured the hyoid and the thyroid cartilage at the same time. Does that make sense? Counting for that distance.
Okay, so can you ask the question again then? Sorry.
So there is a distance between the hyoid and the thyroid cartilage itself.
Yes.
There is a further distance from the tip of the thyroid cartilage until the place in which it is fractured.
Correct.
And so if you are looking at something to suggest that it would have fractured both the hyoid and the thyroid cartilage at the same time, that object or item or whatever must account for the distance between those two fractures.
No, it doesn't have to be the distance of those fractures.
If the ligature is too small to be touching both of those structures at the same time, then it cannot be the cause of both injuries simultaneously.
I disagree.
I want to talk about hanging. You have indicated that hanging cannot be ruled out as a possible mechanism to these fractures, right?
Correct.
You are indicating that, let me just ask it this way. Is that because a hanging somewhere in the universe of hangings has caused the 4 fractures?
Partly, yes.
It is not that the factors present in this hanging, alleged hanging, show that it can't be ruled.
Every case is unique.
Let's talk about that. You, in your study, in your report, excuse me, case review report.
Did you guys see that? Even
Talk
Moore's
about
starting to relax.
hanging on the bottom
The
of page
defense is going to be
5,
feeling
top
really
of
good
page
right
6,
now.
right?
This is falling apart.
I talk about the review of the literature regarding hanging. Correct.
And in your review of the literature, I don't remember what you marked that as.
We just need to keep going through it, and it's just, I mean, this is not good for him. This is falling apart.
Defense exhibit QQ.
Oh, I thought he stopped. I thought he was trying to figure it out. Yeah, he can't get there. He's trying real hard, though.
I hand you exhibit QQ.
That would be a fair question to ask, Ethan. The answer would be possible. Sure.
I'm going to show you another copy of Defense Exhibit QQ. This is the study that you cited, correct?
Correct.
And this is, if we just refer to this as the Zadapkova study, is that a good way to refer to it?
Correct.
Okay. Now, the Zadapkova study was a study of 178 autopsies of suicidal hangings over a 3-year period, correct?
Correct.
And so they were doing their own autopsies and looking themselves at what injuries they were able to observe, correct?
Correct.
They also conducted a review of other literature regarding hangings and fractures, correct?
Correct.
And there's a large portion of this article that discusses what that other literature says.
Correct.
And in this study, the authors noted certain things that were statistically significant in determining whether or not there would be fractures, correct?
Correct.
And one of those things that they talked about being statistically significant is weight, correct?
I believe in the study, weight was not, but weight when corrected for age was.
After age correction,
Especially if he's got thin
chi-square
bones.
test for 4-pole pivot tables
Very
confirmed a
thin bones.
significant association between the weights of the victims and the incidence of laryngomyxoid fractures, correct?
Correct.
So weight was one of the factors that is statistically significant in whether or not you're going to see fractures.
Corrected for age on their study.
Corrected
yes.
for age.
We don't know,
Additionally,
Ethan.
The location of the knot is statistically significant for whether or not you're going to see fractures, correct?
In their study, correct.
And where was the knot in this case?
I don't know.
So you don't know whether there was a knot or if there was one, where it was.
I could not see the knot clearly or I could not see a knot clearly in the photos.
You would agree with me, though, that's statistically significant in determining whether or not there's going to be fractures.
Yes, it is one of the contributing factors.
And we'll show that again here on 3.6. The chi-square test identified a significant relationship between the location of the knot on the neck and the occurrence of laryngohyoid fractures, right?
Correct.
So weight adjusted by age, location of the knot, two things that are statistically significant in figuring out whether there's going to be fractures.
In the study, correct.
The authors also discussed that hanging is not the only cause of laryngohyoid fractures, right?
Yes.
In fact, in their study, they noted strangulations, particularly throttling and homicidal ligature strangulation, are the most common cause of laryngohyoid fractures, correct?
Can you point on there exactly where?
Oh, sure, I'm sorry. Right there.
Correct.
So, and throttling is a physical, an assaultive strangulation, not a suicidal strangulation, right?
Correct.
And so, that act
There might have not have been a knot, Jim. It might have just been tied,
the
like
most
looped
common
around.
cause of laryngohyoid fractures, correct?
Correct.
Now, their review of the other literature is presented
The little
in
Richard.
tables like this, right?
Correct.
And these tables indicate the number of people involved or cases involved in a study, right?
This table indicates all the other studies that they reviewed as part of their paper.
And so in this column here, that wasn't a very good circle. There's an N, that's the number of cases that were looked at in those studies, correct?
Correct.
We then go over and we have an IH, that means an isolated hyoid fracture, correct?
Correct.
We then go over the next one and there's IT, and that's an isolated thyroid fracture, correct?
Correct.
Then we have a column for H and T, that means they had hyoid and thyroid fractures, correct?
Correct.
And then we have a column for H and or T, so just meaning there's at least one to either one of those structures, correct?
Correct.
Nowhere in this table do they talk about the quadruple fracture pattern, correct?
Correct.
And so all this H and T column says is that there were fractures to each structure, but it does not indicate if those fractures were bilateral, as in on both sides.
Correct. It doesn't specify.
So none of these studies in this table specifically talk about quadruple fracture patterns. You have no way to tell what's in it.
Correct.
Table 6, and this goes on again for both, goes into the top of the next page too. This table suffers from the exact same problem as table 5 that we just talked about, right?
Correct. The difference is this one is retrospective studies.
Right, so this is looking back at past cases rather than doing autopsies and looking at what's there.
Correct.
And so, once again, though, in this set of literature, it does not specify in any place if we're dealing with a quadruple fracture pattern.
It doesn't specify that they're bilateral hyoid and thyroid fractures.
And so, just so we understand each other, if I say a quadruple pattern, that's what I mean. 2 fractures of the hyoid, 2 fractures of the thyroid.
Understood.
So it doesn't specify if any of those cases
Correct.
are in there. Okay. So in the Zadapova study, they did actually break out when there was this quadruple fracture pattern. Is that correct?
Correct.
And I'll show you that. So you're on table 2. Yep, still the same as it. Yes, sir. So here, the authors of this study have broken down isolated fractures, right greater horn, left greater horn, superior horns, all the way down until you get to the bottom here. Correct?
Correct.
And that's bilateral greater horn, so BSH, both superior horns of the thyroid cartilage, and BGH, both greater horns of the hyoid bone.
Correct.
And so what they found in this study is 6 instances out of 129 hangings that they studied.
It was out of 178, actually.
I'm sorry, 178 total, thank you, out of 129 that had fractures of any kind.
Correct.
So 178 cases, 6 instances of that quadruple fracture pattern, right?
Correct.
And that was 3.4% of the cases in their study.
Correct.
And it's upon this piece of literature that you cited in your report to say that this same fracture pattern observed in Ms. Noble's case can occur in a suicidal hanging, right?
Correct.
But you didn't just rely on what was written in the study, did you? In order to reach that conclusion?
No.
You actually emailed the author of the study, correct?
I did.
And you asked the author of the study to tell you how many of those were incomplete hangings.
That is correct.
And that's because you thought it would be important to know the difference between whether the quadruple fracture pattern was in a complete hanging or an incomplete hanging, right?
That was because of Dr. Smock's reliance on the partial hanging. So I wanted supporting evidence to refute that.
And so you thought that you wanted to know how many of those were incomplete hangings, right?
Correct.
I hand you what's the March States of 166. You can put that over. Do you recognize that document?
Yes.
Generally speaking, can you tell the jury what it is?
It is my email correspondence to the author and their reply.
And is that a true and accurate copy of the entire correspondence that you have with the author of the study?
Yes.
At this time, I ask to publish these at 166.
No objection.
Your email to one of the authors appears at the bottom of the first page, is that right?
Correct.
With the signature line continuing on to the second page?
Correct.
And you asked how many of the cases in that study that had the bilateral fracture of the hyoid and bilateral fracture of the thyroid cartilage asked if they were incomplete hangings, correct?
Correct.
And you received a response, correct?
Correct.
And due to that response, you wrote in your report, although it is not stated in the article, email correspondence with the authors revealed that 50% of those quadruple fractures were in cases of incomplete hanging, right?
Correct.
But that wasn't all that one of the authors of this study told you about those cases, was it?
No.
In fact, he indicated that 3 of the 6 cases were incomplete hangings, which is you put in your report, correct?
Correct.
But he also told you that they were all males, correct?
Correct.
And he also told you that 2 of them were a bit overweight, correct?
Correct.
And then included their weight as being 110 kilograms, right?
Correct.
And you'd agree with me that 110 kilograms is 242 pounds.
I'll take your word for it.
It's not 110 pounds.
Correct.
We're talking about quite a significant bigger weight than that. When we're talking kilograms and pounds.
Correct.
And so, you know from reading the Zadokova study that age-adjusted weight is a statistically significant factor in whether or not there's going to be fractures, right?
Correct, in that study.
And yet, when you wrote your summary, your case review report, you only indicated that 3 out of the 6 were incomplete hangings, right?
Correct.
You didn't note anything in your report that the author of the study told you specifically that 2 of those 3 were overweight, right?
Correct.
The author of the study didn't just stop there, though. He included the entire data set from your study, correct?
They did.
Gave you a spreadsheet that laid out their cases and their findings.
Correct.
I'm going to hand you Western Margin States Exhibit 167. Take a moment to flip it over. Do you recognize that?
It appears to be a subset of that data, including only the individuals with the bilateral hyoid and bilateral thyroid fractures.
And in the study, there were 6 such cases,
Correct.
and that is reflective of those 6 cases.
Correct.
Now, this time, asked to publish Exhibit 167. The authors of this study from the Czech Republic, is that right?
Correct.
So fair to say some of the headings here are not in English.
Correct.
I'll walk through some of the things that are on this data set. Let's start with first column, sex, M. That indicates that all 6 of the individuals that had the quadruple fracture pattern were male, correct?
Correct.
The next line is age, or excuse me, not line, column.
Correct.
Is age. Those are the ages of these individuals who had the quadruple fracture pattern.
Correct.
Next is their weight in kilograms. Is that correct?
Correct.
And so
If I may, that exhibit, where's that?
All right, guys. I was trying to look up this issue. I was just trying to look this up. I don't know exactly what they're looking at. So, sorry. I should have brought you in on it. I was curious to see what they were talking about, but it sounds like they're going to have a move on.
I'm going back to CC 167. That column under a word that begins with H, that was their weight in kilograms, correct?
Correct.
And so let's keep going. We'll come back in a minute. Next is TIP, TYP, and then there's a couple of different numbers underneath that. See that?
Correct.
Do you know what those mean?
They refer to the knot position in the ligature.
And so you'd agree with me that 3 is a right lateral knot.
I have to refer back to see what number is what.
And we'll do that together here. I'd put it up here for you.
That would be great.
This is on the second page of the exhibit. Under the heading 2.
So yes, 3 is a right lateral hanging.
What's 3 is right lateral.
Correct.
And 4 is left lateral.
Correct.
So 3 and 4 are going to be on the sides.
Correct.
1 and 2 is posterior and anterior. So those are going to be front and back.
1 is posterior, 2 is anterior. Correct.
Okay. And then while we're here, before we go back to the spreadsheet, A is going to be complete hangings, complete suspension, right?
Correct.
And B is going to be incomplete suspension, correct?
Correct.
So let's look at these again. The first one, case number 49, a male, 37 years of age, 242 pounds approximately, right?
Okay.
Right lateral knot, incomplete hanging.
Correct.
That individual is dissimilar from Emily Noble, correct?
Doesn't match the demographics. Yes.
Dissimilar because it's a male, not a female, right?
Correct.
Dissimilar because it's someone who weighs 242 pounds instead of 95 pounds, right?
Okay. Yes.
Dissimilar because there is a knot in the right lateral position, correct?
Since I could not view the knot with all the hair and stuff, I can't say yes or no.
Okay. So you can't say, we'll make this easier so we don't have to do it every time. You can't say on any of these whether or not the position of the knot is the same or similar to what Emily Noble had.
Correct.
Okay. So this individual is dissimilar, at least due to weight, by more than double her weight, correct?
You said this individual or
So this
these
individual,
individuals? This. Okay. Yes.
the first one, 49.
Yes.
Okay. Let's talk about 52. Again, we've got a male, correct?
Correct.
We've got somebody who weighs 242 pounds, correct?
Correct.
And we have someone who is a complete hang, correct?
Correct.
So again, this individual is dissimilar from Emily Noble by weight, correct?
Correct. Sorry.
Again,
that was the question.
More than almost 2.5 times her weight, correct?
Correct.
And a complete hanging, correct?
Correct.
The next individual, number 60. Here we have an individual who weighs 138 pounds.
I can't do kilograms to pounds on top of my head, so I will take your word on that.
Okay. And we have a complete hanging, correct?
Correct.
So again, we have an individual who weighs 30 to 40 pounds more than Emily Noble, correct?
Correct.
And the position of the hanging being complete is dissimilar, correct?
Correct.
Next line, number 84. Here we have, again, another male, correct?
Correct.
Again, somebody who's noted as weighing 242 pounds, correct?
Correct.
And an individual who is indicated to be an incomplete hanging, correct?
Correct.
So far we've talked about 2 incomplete hangings, right?
Correct.
49 and 84, correct?
Correct.
Both of those being individuals who were noted to weigh more than 240 pounds, correct?
Correct.
Again, number 84, dissimilar from Emily Noble in those characteristics, correct?
Correct.
Then we have number 98. We've got a male again, correct?
Correct.
This time 198 pounds
Sounds right.
and a complete hanging, correct?
Correct.
So again, we're dealing with someone who is dissimilar because of weight, correct?
Correct.
And dissimilar because of the type of hanging, correct?
Correct.
Setting aside that there may also be dissimilarities with regard to the knot, right?
Correct.
And then we have 130. Another male,
Correct.
171 pounds,
Again, I'll take your word for that.
and an incomplete hanging, correct?
Correct.
Again, we're talking about an individual who weighs 70 or 80 pounds more than Emily Noble, correct?
I don't know that I knew Emily Noble's weight.
Okay.
Is it in Dr. Smock's report, her weight?
I'm sure it's in some of the materials you review, but if you don't recall it off the top of your head, that's fine.
I don't recall seeing her weight.
Okay. Just as a means of simple math, 171 pounds is 70 more pounds than 100.
Correct.
Okay. Now, ma'am, those factors that we talked about in your own study are statistically significant to whether or not we're going to see fractures, right?
It's not my own study.
I'm sorry, the study that
In
you-
this study?
The study that you
Correct.
cited.
Correct.
The one you chose because you believed it supported your conclusion, right?
In their data, they also review a number of articles that some show weight is significant, some show weight is not significant.
That wasn't my question.
Okay.
My question is, you picked that study because you believed it supported your position that hanging could not be ruled out in this case.
Correct, based on the fracture pattern. Correct.
And you would agree with me that that fracture pattern was only present in 3.4% of the cases that they reviewed themselves, that they performed their own autopsies, right?
Correct.
And that of those 6 cases, all of them are dissimilar from Emily Noble, right?
Correct.
Also in that study, I'm going to turn to page 80 as it's labeled in the top right. Now I'm turning your attention to a sentence I've placed in red brackets. Can you see that?
Yes.
And so again, in the Zadapkova study, they said, in reviewing other literature, in a retrospective study comprising 632 fully autopsied cases of hanging, Tugalev et al. Failed to identify laryngeal and hyoid fractures in individuals lighter than 50 kilograms, right?
Yes.
50 kilograms being roughly 110 pounds.
Yes.
So in the Zadapkova study, they cite to another study that said there were no fractures in individuals under 110 pounds.
Correct.
I hand you what's marked as Exhibit 168. Take off look at. I know I've only just handed that to you, so I'm not going to ask you a ton of questions. And if you want some time to review it, please let me know. But does that appear to be the Tugolev study that was referenced in the Zadapkova study?
Correct.
So I'm going to put up what's marked in the top left as page 1502 in that particular study. Are you able to see that?
Yes.
And because I've got a different copy of it, can you confirm that what I've handed you is Exhibit 168 is the same thing that's up on the yoke?
Yes.
And you would agree with me that Table 3 talks about the distribution of fractures by weight, correct?
Correct.
And that this isn't talking about quadruple fracture or fracture of both structures. It's talking about any fractures whatsoever, right?
Correct.
And so in this study, you cited Zadapkova to support your conclusion. Zadapkova cites this study in their study, correct?
Correct.
And this study says in individuals under 110 pounds, there wasn't a single fracture of any kind.
In their study, correct.
Not a one.
Correct.
And when you email one of the authors of the Zadapkova study, they pointed out to you that two of the incomplete hangings were overweight.
Yes, they said, interestingly, they were all males and that two of them were overweight.
And you know that age-adjusted weight is a statistically significant factor in whether or not you're going to find fractures.
In that one study, correct.
And you didn't include anything about the weight of those individuals when you wrote your report, correct?
No.
Let me ask this one. The Zadapkova study, it only separated the types of hangings by complete or incomplete.
Correct.
Is that fair? Are you aware of literature that addresses differences within the subset of incomplete hangings?
What do you mean by subset?
So we have all hangings.
Yes.
We have complete hangings, which means no part of the person is touching the ground. They're
Correct.
completely suspended. Then we have incomplete hangings, where something is touching the ground.
Correct.
Are you aware of any studies that discuss the differences in types of incomplete hanging? Not as incomplete versus complete, but within this subset of what is an incomplete hanging.
Not that I recall.
I'm handing you what's the march states at 169.
You can go on whenever you want.
I just want to make sure you have a chance to look at it. I know I don't want to hand you something you've never seen and start asking questions immediately. Have you had a chance to at least look at the summary of what the study's about?
Correct.
And would you agree with me that it is entitled The Pathology of Hanging Deaths in Western Australia?
Correct.
And what I want to, this study was about a prospective study of 233 fatalities due to hanging in Western Australia. Is that what it reflects in the summary? And would you agree with me that on table 1 on the second page of that exhibit is a table sorting out different types of incomplete hanging?
Correct.
As to publish that second page of stays at 169 of the jury? Doctor, I want to, again, here talk about table 1. That's labeled as correlation of injuries to the neck structures with the type of suspension. Is that the heading of that table?
Yes.
And you would agree with me that that table breaks down not only incomplete and complete, but breaks out those subsets of incomplete hanging that we're talking about, right?
Correct.
You would agree with me that the first row there is talking about individuals who were in a standing position, correct?
Correct.
And in a standing position, they indicated 26 instances of fractured thyroid cartilage, right?
Correct.
10 instances of a fractured hyoid bone, right?
Correct.
And 3 instances of both, correct?
Correct.
Again, unfortunately, it doesn't tell us whether it's bilateral to both structures, so that we have 4, but we know we at least have some fracture to each one of those 2 structures.
Correct.
Going on to the next row of kneeling, they had 23 instances of kneeling in this study, correct?
Correct.
They noted 5 instances of a fractured thyroid cartilage, correct?
Correct.
And no instances of a hyoid bone fracture, correct?
Correct.
And consequently, no instances of both a hyoid and a thyroid fracture, correct?
Correct.
And as a matter of fact, the only incomplete hanging that showed any fracture of the hyoid bone was in individuals that were standing, correct?
No.
Of incomplete hangings.
Incorrect.
Of incomplete hangings.
Incorrect. There's a column, the third column says both, and there's a 1 under sitting for both.
That's true. And I'm not entirely sure why. That doesn't make sense when there's not a one in hyoid bone.
I would imagine that the first column is thyroid cartilage only, hyoid bone only, and then both, so that the data is not doubled
Gotcha.
up in them.
So one instance in somebody who was not standing with a hyoid fracture.
Correct.
But again,
yes.
not with regard to anyone who was in a kneeling position.
Correct.
Doctor, I'm handing you, I believe you're showing us on direct. What's the mark exhibit II?
Correct.
Defense exhibit II. Do you recognize that document?
Yes, it's the Betson Eisenmenger article.
You would agree with me that what you were shown was table 1.
Correct.
And table 1 discusses fractures by age, correct?
Correct.
Would it surprise you to learn that this same document was shown to Dr. Smock when he testified?
No,
Did you happen to hear that
I
testimony?
did not.
Dr. Smock indicated that this study is meaningless when compared to Emily Noble.
When compared to what? I'm sorry.
When compared to Emily Noble's situation, the situation why we're here, right? You would agree with me that this table does not say a single thing about the weight of those individuals.
Correct.
You would agree with me that this table doesn't say a single thing about whether it was a complete or incomplete hanging, correct?
Correct.
You would agree with me that this table doesn't say a single thing about whether there was a knot or was not a knot and where the knot was.
Correct.
So this table that only talks about age ignores those other factors that you've agreed are statistically significant for whether you're going to see fractures, right?
I agree that that article you presented had a statistically significant.
The article that you cited in support of your position said it was statistically significant, correct?
Correct. One of the articles I cited. Correct.
I didn't choose this article, you chose it.
Correct.
And you believed, based on your reading of that article, that it supported your position.
That the bilateral hyoid and fracture and thyroid fractures can occur in an incomplete hanging. Correct.
And so that's what I really want to make sure the jury understands. What that sentence that you just said means is just that theoretically those 4 fractures can occur from a hanging, right?
Correct.
That statement does not mean that those fractures occurred to Emily Noble because of a hanging, right?
I'm just saying it can't be ruled out. Correct.
Well, you're saying it can't be ruled out because, in general, a 200-pound man could have had that fracture pattern from a hanging, right?
Along with my knowledge, yes.
And there's not a single thing that you've been able to point to that talks about that fracture pattern occurring in a 100-pound female, right?
Correct.
And in fact, the study you chose to cite in your report cites another study that says there's no fractures of any kind under 110 pounds, right?
Correct.
Have one moment. I guess I'll ask this last question just because it was asked of Dr. Smock, but are you being compensated for your time to be here?
Yes.
Were you compensated originally for your review of the case?
Yes.
Compensated for your travel to Ohio?
It was, my travel was covered. I didn't pay for it. So, yeah.
And what's the rate at which you're being compensated hourly for this?
For testimony and trial is $300 an hour while I'm testifying.
Thank you. I have no further questions.
Yes, Your Honor, thank you. I have those exhibits, please.
I put a couple of them up there.
Pathology, yes. I want to. And then if you could do the email, please. I'll just start where it was left off, showing you what's been States Exhibit 169. That article is 1996. Do you see that?
Correct.
And I'll call it the Z study that you cite in your report is dated what?
2018.
Tell us how technology has evolved from 1996 to 2018 in terms of what researchers and people in science like yourself can see and now know. What's changed from 96 to 2018?
Well, one of the things that the Zedapkova et al. Article brings up in their long table of all the reviews of studies is that they ordered them by percentage of fractures to the hyoid and thyroid card for lowest to greatest. And they indicate in there how the top half with the lowest amount of fractures occurring in the hangings were the older articles, and the bottom half was the newer articles. Because procedures have changed, we have better imaging, we have CT scans, doing more detailed dissections of those structures, and are doing more prospective studies, so studies that are actually designed to look for these things.
And between the study in 18, obviously 2018, we have my math is 22 years separate those two articles. Now I want to go back to Defendant's Exhibit QQ because so much of it was asked about weight. Would you agree with me that page 80 of that same study?
Can you remind me what study this one is?
Oh,
okay.
How do I say it?
Zadapkova?
Zadapkova.
That's how I have pronounced it.
You were asked about, let me scooch this up. This sentence right here with respect to 50 kilograms. Do you remember being asked about that sentence?
Yes.
I just want to go, though, right down to the highlighted part in that same paragraph. In contrast, what does that sentence say?
It says, in contrast, Luke et al. Demonstrated that laryngohyoid fractures were independent of height and weight in a prospective study of 61 hanging cases.
Is there seemingly disagreement in the field as to what is and isn't important considerations and research of this sort?
Absolutely. The Zadapkova article starts off by indicating they're doing this large review because it is so contradictory in the literature. You can see everything from laryngohyoid fractures happening in hangings from 0% to 100%, depending on the article that you look at.
And I know you've been asked about one of the articles within the Zadapkova article. If you recall, how many articles were reviewed by that 2018 study?
I would need to look at the article.
If I could approach, Your Honor. Showing the witness what's been marked as Defendant's Exhibit QQ.
Guys, I've been on so long. Take care of something that's come up. I guess my big concern is she going to overwhelm the jury with all this information and kind of run them off? It's kind of something I'm thinking about. Donald Trust and Believe.
I feel like the quickest way is looking at the two tables where they summarize them, where the table 6 lists 54 studies and table 5 lists 28. So 54 plus 28.
82. So you were asked on cross-examination about one of the studies contained therein, and there's 81 other studies that are encompassed in the 2018 Zadokova study.
You just said 82 and then 81.
Because I'm taking out the one that the stage staff. I want to shift gears to a question you were asked about. Dr. Smock said that this study, marked as II, Defendant's Exhibit II, was quote unquote meaningless. You recognize this study?
Yes.
And it is published in the American Journal of Forensic Medicine and Pathology.
Correct.
Would you ever tell the jury, make the statement as a forensic anthropologist who's board certified, that any study published in the American Journal of Forensic Medicine and Pathology is quote unquote meaningless?
Regardless of what journal was published in, I don't think I would use the term meaningless.
I want to just, for sake of completion, the exhibit you were shown is to the emails. Why did you reach out to the author of the study?
Because I was finding it difficult to find an article that specified the exact 4 fractures and had the incomplete hanging that was referenced in Dr. Smock's report.
And this email correspondence that you were given, it was attached to, if I may approach, Your Honor, a significant amount of data with respect to the...
Yes, they sent me their whole data file from their study.
If I can mark that as Defendant's Exhibit RR, the author actually sent you all of the data of the study, did he not?
Correct.
And does this appear to be a true and accurate copy of the data that was attached?
Yes, it prints weird because it's an Excel file.
This is the last page is marked. Thank you. This email correspondence is done on what date?
September 20th, 2021.
And what date is your report issued?
September 21st, 2021.
So before your report is issued, you are reaching out to authors of articles to get additional information.
Correct.
Let's talk about, let's talk about Dr. Smock's report. Do you recall at all any mention even of Emily's weight in Dr. Smock's report?
I do not recall.
Do you recall any mention of his findings with respect to the bilateral fractures being consistent with manual strangulation being based on her weight?
No.
Do you recall any of his findings and conclusions in his report being based on anything to do with Emily's weight?
I would want to reread. I don't recall. I don't believe so, but...
And tell me this then, with respect to Dr. Smock's, and I had this report if you'd like to refresh. Do you recall at all if he even cited one reference, one citation, one article, any literature to support what he wrote in Exhibit 148?
He did not.
Not one.
Not one.
Just another point about incomplete versus complete and weight. When I'm here on incomplete, my weight is supported by the ground. When I'm kneeling, is my weight supported by the ground?
Correct. It's going through your vertebral column and through your knees at that point.
And when I'm hanging in a complete suicide and the ligature is holding me up, there's nothing supporting my weight?
The definition of a complete hanging would be full suspension.
And the weight of a person's skull, just variably, what can a skull weigh?
Generally reported to be 10 to 12, well, with the soft tissue and everything,
Yes.
10 to 12 pounds on average.
And if I'm 100 pounds, what might my skull weigh versus a 260-pound male?
I don't know that answer.
Okay. And so generally the weight of a skull is 10 to 12?
Correct.
You were
It's
asked
the skull with all the soft tissue, the head.
the head, 10 to 12 pounds. And if you recall, how was the head positioned in the photographs in this case?
I believe it's down and it's off to one of the sides
And it's
at the time of recovery.
You were asked about the word definitive.
Correct.
As you use definitive in your line of work, tell the jurors what it means.
So I do that frequently in my reports to say that there is no definitive evidence of trauma, right? Any kind of perimortem evidence should be definitive if you're going to report it as perimortem evidence.
And so it is the use of definitive inconsistent with your conclusion that there is no evidence of perimortem trauma on the nasal area?
No.
It is not.
No.
And explain to the jurors, you kept saying anthropologically post perimortem trauma. What does that mean versus when you were asked just perimortem trauma?
I like to qualify that it's anthropologically because I'm an anthropologist. And again, that time period where the bone will retain its fresh components is a much longer perimortem period than what's normally referred to by forensic pathologists with the soft tissue.
And that period, perimortem for forensic anthropologists is what?
It is when the bone continues to retain its fresh biomechanical properties.
You were asked the questions about the ligature, that it has to be as large as the distance between the hyoid and the thyroid cartilage. And you disagreed and you weren't asked why. Could you explain to the jurors why you disagreed with that statement?
Well, you have the hyoid and the thyroid cartilage, and you have a ligament attaching them. You also have suprahyoid muscles and infrahyoid muscles. And with that hyoid bone being right there, if you were to press on the horns of the hyoid bone up here, you can create a fracture down there. You don't always get the fracture right where the force is being applied to.
And also, just so we're understanding distance, for a woman that would be 5 feet tall, if you could show with your fingers what might be the distance, and I understand every person is different, but just generally what might be the difference between the hyoid and the thyroid cartilage.
I don't think I'd be comfortable doing that. Just too
Okay.
much individual variation.
Okay, and obviously the variation, we have the size of the neck of individuals varies as well as the separation of those two areas.
Correct.
You were asked a lot of questions about the knot and studies that talked about the knot. Were there any pictures in all of what you reviewed that actually showed the underneath when the ligature was still around her neck?
No.
The pictures, were there any pictures, they're all taken on, of her remains, were they just all taken on one day, that being September 16th?
Objection, Your Honor.
I'll rephrase the question. Of all the photographs you saw from either the scene or the coroner's office, were you ever able to get a shot, or was there a photo that you saw that actually showed the ligature under her neck?
No.
One moment. You were asked conclusion with respect that the bilateral fractures, right, that given the bilateral fractures, so the hyoid and the thyroid, that a hanging could not be excluded.
Correct.
After all of the cross-examination, hearing testimony, all of the work that you've done in this case, which is in your report, your review, and even your own research, has your opinion in any way changed?
No.
Nothing further.
Ooh. Okay. That was just, just lit her up. Yeah, I was
Dr. Let's talk about Defendant Exhibit II for a moment. I guess I'll apologize to the authors of the study. Clearly, what I'm talking about, this article being meaningless.
I'm sorry, I don't know which article.
I'm sorry, let me give it back. That's a Defense Exhibit II, the one you were asked about, Dr. Smock calling it meaningless. You would agree with me that our role in this courtroom is for the jury to be able to determine the facts of what happened to Emily Noble, right?
Correct.
And that none of us in this courtroom care about a hypothetical discussion of whether or not any possible hanging can cause a quadruple fracture, right?
Incorrect.
What we're here about is whether this individual's injuries were caused by a hanging, right?
Correct, or in my case, could be caused by.
And so in Defense Exhibit II, it contains none of the factors beyond just saying age and fracture pattern, correct?
Correct.
And so it ignores the statistically significant factors that may differentiate those cases from Emily Noble.
Some studies find those factors significant, some studies don't.
Right.
So I'm not comfortable saying overall.
And would you mind telling the jury what year that study's from?
1996.
I hope the technology hasn't changed too much for that one, for Defense Exhibit II to still be used by defense. Now, you testified that you've spent 50 hours reviewing materials, that kind of thing, right?
Yes.
If you had found a single instance in any of the literature of a 100-pound female incomplete hanging with that quadruple fracture pattern, you most certainly would have brought it to court with you, right?
Yes, I didn't know the weight, but yes.
The fact of the matter is that literature doesn't exist that you've been able to locate, right?
That I have been able to locate, correct.
And so what you did is write your report based on a study that has individuals that are not similarly situated to Emily Noble, right?
And the knowledge that there is not a specific fracture pattern to indicate that something has to be manual strangulation.
Are you familiar with the phrase garbage in, garbage out?
Yes.
No further questions.
Any questions jury may have for this witness?
That wasn't very.
Write him now or forever hold your peace.
I mean, was anybody moved by that? That didn't really get anything going for me. No, guys, I was worried about Diane talking about all the issues that were going on. I liked how she ended with still, we don't know where this was on her neck. Correct. So, boom, done. they had to be careful. I mean, their cross. I mean, that was recross. Remember, it was not direct. It was not cross. It was recross. So Diane kind of went back and rebuttoned up all the things he pointed out, and even though he didn't really do too much earlier, they weren't left with much. So we'll see what happens. No, guys, but yeah, I'm sorry. I was working as I was listening to this afternoon. Yeah, this is very much like the Husel trial in that the defense actually got an expert in that field, whereas, like with the Husel trial, they actually got an anesthesiologist, not other doctors. In this case, they got the anthropologist and the pathologist with the focus on anthropology. So I think this is going to become, this was they had a better expert by far. By far. Because she comes across as a real expert. Well, I don't know. I'd have to defer. Not Dr. Smocks thinking, oh, well, that's irrelevant and being all high and mighty. That was a very Dunning-Kruger thing, I think, for him to do. And even though he might be right, he came across as very conceited. The intelligence gap between the expert and the prosecutor is painful. Well, this is a well-prepared and well-poised expert. And, I mean, she knows how to do the dance. Even the jury sees it that way. I think these questions will reveal what the jury's thinking right now coming up. Yes, LogNav. You cannot use your opponent's messaging. As much as we're going to touch on the 2016 election, Hillary's thing was love trumps hate. You can't use your opponent's name in your own slogan. It doesn't work that way because now your people see your opponent's name everywhere because you're using it everywhere. You don't use the other side's thing. You can't hijack it. You can hijack it if they fuck up really bad, but they haven't fucked up. But using it right now in the middle of this, that was really, and I think that was an ineffective thing. That was a bad idea, actually. I mean, it comes across as smarmy, in my opinion. So I thought that was really bad. The 7-Eleven cheese. Yes, Harlan, they actually did. Send me an email and I will send you copies of it because I got everything from the Ohio Supreme Court directly. I can actually give those to you if you'd like. So shoot me an email. Better expert for the defense by far. By far. You're asking who had the better expert? Yeah, by far. Yeah, at this point, I'm thinking the therapist notes did not get admitted either. But that's okay. It doesn't sound like they need them at all. Yeah, Chaucer says, I'm guessing the therapist notes did not get admitted. I tend to agree at this point. And CG says, Anthony Bourdain was filming a new season of a show when he hanged himself. Yeah, you hanged yourself. You're not hung. Hung is for the other thing. You get hanged. He hanged himself. Chaucer also said Chaucer then says, so we have limited data, which is insufficient to draw a conclusion that is impossible for a woman less than 110 pounds to have these fractures. Yeah, that's kind of where we are. We have insufficient data and research, and just you can't outrule it. So yeah, if you can't rule it out, it's always possible. And yeah, that is a great summation of that. There's
From the jury, I will ask the question.
oh, here we go. Here we go.
Why did you not review the bones in person?
I had, when I was contacted by the defense with these materials, I had assumed that the bones had been returned to the family and were interred or cremated at that time. It wasn't made aware to me until about 2 weeks ago, that the remains were still available.
Okay. Did you have an opportunity to review Emily's medical history to see if she had any antemortem defects to her face or neck prior to the day she went missing?
I did get to review her medical history looking for fracture patterns. From the medical history, it noted the ankle fractures and then a fracture to the elbow, but that's all I saw within the records that were sent to me.
You emailed the author of one of the learned treatises and for more information. Why did you choose not to do that with Dr. Agnew regarding her findings of work?
It would seem inappropriate when counsel is asking you to review materials for a report to then go to that person that you're reviewing the report and ask them for more information about that. You don't correspond with them. That would be something that would have to go through the counsel.
That's a good answer.
And we've talked about many learned treatises about hangings. Include cases of incomplete hangings where the individual remained in the hanging position for an extended period of time, such as months.
Some of the studies noted that they actually excluded cases that were out for prolonged periods so that there's not any confounding factors, and others did not specify.
Are the bones of a slightly built woman more fragile than a very sturdy man?
That is difficult to answer. There's a lot of things that's going to go into whether your bones will fracture more than somebody else's. You could have a man and woman of the same size, but one has osteoporosis, or one has some metabolic disease, or even activity. The more you do, your bones actually get thicker in response to the force, or even your activity differences. So you really can't say just because of body size that bones would be more fragile or not.
Is it possible that someone who started in a kneeling position over a significant period of time could end up sitting in terms of hanging?
I hesitate. I'm not sure if I should be answering this from a forensic anthropological sense of things. But anytime you have decomposition, that soft tissue that is originally there is going to disappear. So you're going to get a change in position with the decomposition that's occurring.
In a study where 3.4% suffered 4 fractures, were any of these cases identified or tested for bone mass density loss?
That was not in the study.
Is the integrity of bones degraded if submerged in hydrogen peroxide/water solution for up to 24 hours?
There aren't studies that tested the exact 1-to-1 ratio with 2% hydrogen peroxide for 24 hours as was used in this case. But multiple studies suggest that hydrogen peroxide, because of its destructive nature, should not be used in forensic cases. It's used when curating bones, because if you're building a collection, you want less greasy and whiter remains. But in forensics, we try to do the minimal possible to be able to analyze the bones.
Would use of hydrogen peroxide solution potentially cause fractures in the neck?
I would say it would not cause fractures. It can change the bone density, but it wouldn't create. It's not applying a load or a force to create a fracture.
Could you or anyone see signs of plastic deformation on the nose and photos of Emily from May 24th. Photos of her on May 24th.
So as a forensic anthropologist, I wouldn't be looking at making diagnoses off of her face. I don't know if I can speak to my observation in Smock's study as just a critical analytical person.
Go ahead and answer the question.
Okay. In the one image that is within Dr. Smock's report, to me, it does look like there's deviation to the nose, but I don't have anything else to say to that.
Are you able to tell?
That's not good.
An antemortem nasal fracture occurred?
So you can't say specifically. Healing is going to vary. It's going to vary person to person, and it's going to vary on severity. It's going to vary on your health, and it's going to vary on your age. A lot of the studies looking at bone healing deal with infant abuse cases. And so we know as far as infant abuse cases, first of all, infants heal a lot faster than adults. And that healing process, the first time that you'd see gross macroscopic laying down of new bone would be at least 4 days, usually more like a week or 10 days. And that bone that's laid down is a woven bone. It's haphazard. Your body wants to stabilize that. So it just throws the bone down quickly, along with some cartilage, and then it goes back and remodels it to make it nice and smooth like the rest of the bone. The nasal and the images are all nice and smooth, and they're stable. They're on top of one another there. So I would say at least a couple weeks, but you really can't put an end range on that.
Changing gears again, what is age-adjusted weight?
So age-adjusted weight would mean that statistically they took out the influence of age first and then looked at weight of that individual.
And why is that necessary to know in an evaluation?
So the authors did not find that weight alone was a significant factor. They did find that age was a significant factor. So if they take into account age, you know, a 62-year-old person of this and a 62-year-old person of that, would weight matter? And they did find in that one study a statistically significant difference.
Does the Z study, which you were reviewing, exhibit QQ, include the thickness of the ligature in the data?
They don't in the data, but they do reference ligature thickness in parts of their review, indicating that rigid and narrower ligatures tended to cause more trauma.
Could the use of hydrogen peroxide on bones make peri-mortem damage appear to be post-mortem?
Could it create peri-mortem to look like post-mortem? Not that direction, but the other direction, right? Because post-mortem, you're looking at the color changes. And so if you bleach the bones, all of a sudden then those color changes are gone and you don't have that information. But I can't think of a way where it would make a peri-mortem fracture look post-mortem.
Those bones could have bleached away evidence. Ooh, that's not good. Not good for the state. Hopefully Diane seizes on that.
Nothing further.
Questions? Thank you very much.
Thank you.
You are excused. All right, ladies and gentlemen, I believe we're going to conclude for the evening. I will share with you that, as I indicated earlier, there are some legal matters that counsel and the court need to deal with, which traditionally does not require your attention. So we're going to take care of it while you leave. And it may carry over into tomorrow as well. So we're going to start tomorrow at 9:30. I would probably ask that you try to get in by 9:15. If you want to get here at your usual time, that's entirely up to you. I just want to let you know when we're starting. We'll probably start around 9:30 just to confirm that we get all our business done before, and then we conclude the presentation of evidence, which I believe is going to happen tomorrow. So remember the court's admonition, as always, Enjoy yourself. Take it easy. Don't think about the case. Get a good night's rest. We'll see you tomorrow.
It's not that the questions were not good; her answers were devastating. That trying to determine if things were occurred pre-death made to look post-death. She's like, you could tell, but bleaching out the bones would make that hard to tell. So that was very, very bad. I'm curious to see what they're going to talk about now. Hopefully we find out a good prediction from Diane when she's done. I'm thinking she'll be done tomorrow by lunch. I can't imagine it goes much longer.
The presence of the jury, all parties, including the defendant, are present. Stand up or sit down, whatever you'd like to do. It's up to you. I've been keeping some notes on exhibits. I'm not going to say I'm totally complete here, but I'm sure you probably have as well. How would you like to proceed? You want to just go through each exhibit as the numbers come up and letters come up and address whether you want to admit them?
I hope to God he doesn't.
I can go through the numbers and the letters as I have them, and hopefully they correspond with yours, if you'd like me to do that.
Yeah, and then honestly, I mean, I think that before I can formally say one way or the other on some of these, I might need to look at the exhibits again, because we've had a lot of things where, you know,
That's fair.
mark for identification or maybe not put the whole thing in, like there's a lot of that that I think we're gonna need to-
I totally appreciate what you're saying, Mark. So I'm with you on that one. I mean, we'll do whatever we need to do to go through these, and I do appreciate it'll take some time. So
Your Honor, I'd like to, I mean, I think the fact that we move forward, and I know where the court is, I would like to make my Rule 29 motion.
all right,
I mean, I understand that the court,
I know you want to get it on the record, so rather than have to keep you leashed up, go ahead.
pause and not respond to the least shut comment.
Fair enough. Oh, you've been anxious to get this on the
Well,
record.
because
That's my
Judge,
comment.
it's actually not, this isn't about me just preserving the record. I mean, I understand Rule 29, viewing that evidence in the light most favorable to the state. I think even there, it's still, we're looking at the elements of the offense, and one of the elements of the offense is intent. I just think the record is completely replete with that. I do.
I'm sorry, on what?
On the issue of mens rea, of intent.
Mm-hmm. Yep, there's no intent.
I mean, we have text messages that, by the testimony of the witnesses, never even say, I hate you, I want you dead. The worst is, if you want to divorce me, divorce me. And that's in December of 2019. I mean, we have testimony, certainly testimony as to what Matt Moore said. There's no confession. We have testimony which is corroborated by cell phone data that Emily was last seen on May 25th leaving for a walk. But I don't, even all the facts of the case, Your Honor, it's still looking in a light most favorable to the state. Where is the mens rea? And with respect to motive, I understand that they don't have to prove motive. I also understand that the absence of motive, how it can be used by a jury. So that's a separate argument. Where is the intent to kill? Where? And if they are going to stand up and say, Your Honor, the intent to kill is based on Dr. Smock's this finding that this is a manual strangulation, there is zero evidence connecting any manual strangulation to that. Zero. On its best day, there's zero.
Very true.
Forensics, eyewitnesses, cell, text messages, there's nothing. So I don't make the Rule 29 because I want to preserve my client's record for appeal. I in fact think we should never get to appeal because of the lack of the strength of the evidence in this case. But
Talking some shit.
The intent, that you still have to look at each and every element at a Rule 29. Where is the intent to kill? And the felonious assault is cause or attempt to cause serious physical harm, as this court well knows, and I just say it to say it. Where is the cause or intent to cause? Where is it? Where if, let's just say that there's sufficient
Get it, girl.
evidence of a manual strangulation based on Dr. Smock testimony alone. Oh, okay. Where is any evidence connecting this man to a manual strangulation?
literally saw videos of him. There's nothing on him. No eyewitness, no forensics, no trace, nothing. I usually actually make my Rule 29 more long and complicated, but I think with respect to the mens rea, there's nothing there. And in the absence of anything, it doesn't even get over the hurdle of when viewing the evidence in a light most favorable to the state.
Thank you, Your Honor. As the court is aware, this is charged as a murder case. It's not charged as an aggravated murder case with prior calculation and design, which is what defense counsel is requesting basically in her argument regarding intent. But Your Honor, you have to go through and think about what every single witness told you. But you have to take what they told you in the context and the inconsistencies with what the defendant told officers in his interviews, and he is the last person to see Emily alive. And that should weigh heavily. And we know that because of his statements. And when you talk about intent, Your Honor, the law and even the jury instructions say
Don't we also have evidence that Mr. Kramer saw it? Or-
Yes, but by the defendant's own statements, Your Honor, it says that they were in bed by some timeline. So,
I think they're in bed, and then the next day, the following day, Mr. Kramer saw it.
but he also retracted that on the stand.
I appreciate that as well.
Okay. So when you're looking at the timeline and you're looking at the inconsistencies, and you have to also look at Dr. Smock's testimony regarding this being a staged scene, Your Honor. That is the state's argument, that is what occurred.
I'll tell you what, I think is for purposes of the motion, you have satisfied your burden for the purposes of homicide. What I'm really looking for is the evidence that you are relying upon to say this individual is the one who committed that homicide. So please focus on that. I mean, I'm not telling you what to say, but I don't need you to argue the homicide because I'm with you on that one. Is for the purposes of this motion.
Yeah, she got murdered. Okay, fine. Prove who did it.
Well, the men's actus, mens rea, the ID.
Ooh, he's mulling it over. He is mulling it over.
Your Honor, you have to recall the text message the defendant sent.
This isn't closing yet, no.
That provides motive sent 2 weeks before, or is it 2 weeks? May 5th? May 7th. So not even 2 weeks before his marriage. He tells his friend in a secret app, my marriage is over. That is his motive for killing his wife, Your Honor.
Okay, so we got motive.
All right. And that goes to his intent. Their marriage is over. Now, when you're talking about the purposeful intent, or the defendant and his intent to kill, you have to go from that date of the text message and then move forward. All right. They go out for her birthday. They come back, and you have to remember the defendant's own statements, Your Honor.
He's not buying those.
Immediately afterwards, he calls and says to her sister, the day, May 25th in the evening, she's gone. He tells law enforcement, I loved her. He is using past tense. He is telling her sister that she is gone.
When was that?
May 25th.
Okay.
She's gone. May 27th, I loved her. No one else, Your Honor, would have the incentive or the motive to stage a suicide. A suicide, by the way, he describes to law enforcement while being interviewed. She would go down somewhere. That's exactly where she was. He's the only person who knew that because he did it.
I'm sorry. He's the only person who knew what now?
That where her body was
Getting
at
desperate.
because he put it there.
Getting desperate.
Okay, what did he say? I apologize. He said what now? That
That if she was suicidal, she would go down into the woods. Would go down somewhere.
and who's that said spoken to?
Sorry.
Law enforcement
Okay.
on May 27th.
So he told law enforcement she would go down to the woods where she was ultimately found.
because he put her there. Your Honor, his other actions immediately when she goes missing and afterwards indicate that he knows she's not coming home. And don't forget the manipulation of the crime scene, or the house, I should say, the day she went missing. He is moving cords while law enforcement is there. Magically, a flashlight arrives. And of course, Your Honor, he's manipulating and controlling what law enforcement does from the very first interaction. He doesn't even call 911. All right, so they arrive to the scene.
I thought he called 911.
Well, strike that. You're correct, Your Honor. He calls 911 after Emily's friend tells him to do so on the evening of May 25th. Law enforcement arrives to the scene. He's immediately controlling what they do. Well, I've done this and I've done that. He starts to give a timeline that is not supported by the forensics from the phones. We went into the bedroom. We fell asleep. 5 seconds later on the body cam, we see the bed is made. And then he continues to talk about what happens that evening when they get home. You know, he gets up, he goes to pee, he goes to the other room. And then, Your Honor, he comes back and in his other statements, he starts to change his story. It's those consistencies, those material inconsistencies, I should say, that call into question not only what he's telling law enforcement, but it circumstantially shows that not only did he have the intent to kill, he had the opportunity because they came home. There is a 4-hour block on his phone where nothing happens. Nothing. And then we know he is up for hours after that, and there is no movement. Nothing on Emily's phone after 9-something. Your Honor, this is a circumstantial case.
I'm with you on that one.
All right? But the court has heard testimony from
Oh, he's still not buying it.
witnesses who have provided the opportunity, who have provided the intent, their marriage is over, and even the defendant himself providing statements, how he controls the scene, manipulates the house.
How does he control the scene? Explain that a little bit more for me.
Because when law enforcement arrives, he starts to tell them, you know, everything that he's done. And so by controlling and telling them, well, I've looked in the attic, you know, we don't need to look here. I've looked here. And then Hollis goes out to talk to another officer. And then when Hollis comes back to the garage, the scene has changed.
Oh, when you say scene, you're referring to the home.
The garage, yes. Yep.
Okay, go ahead. Thank you.
He's moving the cord. He moves the cooler. There's magically a flashlight there now.
What is the significance of that move? Circumstantial. I mean, direct evidence is the cord and the container were moved. What is the circumstantial conclusion of that, other than the fact that it was moved?
We immediately lies to law enforcement. Whoops, excuse me, I need a little bit more water.
Okay.
He immediately lies to law enforcement. He's like, I didn't touch it.
Is
But
that
he
lie
did.
significant?
Yes.
Other than the fact that it was just a lie that he moved it.
He's looking for a cord, Your Honor. There is a USB cord wound around his wife's neck. And then there's an orange cord that he's manipulating and lying to law enforcement about moving. He is setting up a staged suicide from the moment law enforcement gets there. I don't know. I didn't touch it. We know he touched it. Maybe she did.
She's flailing.
All of those simple actions of staging the suicide from the moment law
Well,
enforcement
listen,
gets there.
how does the orange cord have to do with this? And I say this, how does that connect to the state suicide?
No, Your Honor, I think it's one-on-one here. I just want to say something, if I may, about the staging of suicide.
Well,
She's
I'll give you
flailing.
an opportunity to respond. I'll give you an opportunity to respond. Let me let the state finish.
Just so it's one attorney argument.
You take all the time you need.
This is a motion to dismiss, and the state is responding why the case should not be dismissed. This is not closing arguments. It's called a Rule 29 motion for acquittal. Diana's going for the kill shot. And the judge is having them explain intent, and they can't establish it right now. They're also having an issue of establishing the fact that he did it, and they can't tie him to it. So there's an identity issue and the intent.
Your Honor, if he's
The intent to
going
cause harm.
Stage a suicide, he needs a cord. It is significant that he moves a cord that he could have used to stage a suicide.
Your position is he used a USB cord.
To stage a suicide, yes.
That's already, are you saying that the stage had already occurred? The act had already occurred when Officer Hollis was there?
We have alleged between May 24th and May 25th, Your Honor. So when Officer Hollis arrives, yes.
Okay, so the cord was already gone. The USB cord was gone already. Okay, so I go back, what's the significance of moving the, I mean, I appreciate the fact you say that he lied. Okay, I understand that. Well, how does that move it forward? I mean, other than the fact that he lied to a police officer, I accept that.
Because he moved the cord while
Okay.
getting a cord for the stage suicide.
Oh, you mean when it was originally in a position?
Yes.
So you're suggesting the cord came from that location?
Yes.
And he had to move the orange cord in the container of the water they got the previous day in order to access the cord, is that?
We're asking, we're just saying he moved a cord that he could have used in a stage suicide and then decided to use a USB cord that is the size of fitting in your pocket. So moving a cord and choosing a different one because he needs one to stage a suicide.
Well, your position is he took a cord, I presume from the house, in order to stage the suicide?
Yes.
That's your position?
Yes, and the cord, Detective Grubbs, I believe, testified, fits into phones that were found at that house.
I did hear that testimony. Okay, but I confess, I'm just not following the orange cord situation. Oh, and I have another question for you too, and I apologize for breaking your train of thought here, but you said there were 4 hours on the phone and nothing happened. What were those hours?
9:45 and 1 in the morning, roughly.
That would be on the 24th? Approximately 9:45 to 1.
To 1:11 a.m.
Okay.
Which makes sense. It's at night.
It's our theory that the staged suicide was occurring.
During those hours?
Yes, he is on the phone then from 1:11 until, I mean, does he ever get off the phone? He doesn't get off the phone.
How do you reconcile that? And I appreciate Mr. Kramer came into the courtroom here to withdraw a statement, but flyers were even put out saying she was last seen at 9 a.m. based upon his statement. How do you reconcile that? I mean, we're just going to ignore that he saw her at 9 and accept, your position is, accept the fact he was in error, he didn't see her. I assume that to be your position, right?
So, Your Honor, for purposes of the Rule 29, assuming the facts and the light most favorable.
That is a lot to fucking assume.
John Kramer came in here and said he could not say for sure he saw her that morning.
Okay.
So assuming that fact and most favorable to the light, that means he saw Emily. His testimony was the May 20, I'm getting my dates confused, 24 at about 8, between 8 and 8:30. Because in the garage was his testimony. That's his testimony. The defendant's statements talk about them being in the home. We know the functioning on Emily's phone ceases at 7:30 or 8.
On the 24th.
I don't want to misquote that because we can pull it up as report.
Okay, good ballpark.
Yes. So immediately after her phone stops, when she is with the defendant, there is no other activity saying that she was using the phone or the phone was being used ever again until he picks it up and starts using it. And that's by his own statements. During that 4-hour period, there's nothing on his phone. Provides the opportunity, Your Honor, to commit strangulation, which the doctor testified to takes 152 seconds. It is a crime. It is a purposeful crime by its very actions. What happens after that is the staged suicide.
Okay, is that it?
Do you want me to continue?
It's up to you. I'm listening.
Ooh,
you were
he's
pausing. I wasn't sure if you were finished or not. It's up to you.
Okay. Can I have one moment, please? Your Honor?
Absolutely,
I didn't feel
absolutely.
like we were going to jump right into this after going at this since 1 o'clock. I need water. Ma'am. All right. Continue.
I'll tell you what. Why don't we do this? Let's kind of take a break for you to get water, for me to use the restroom. And maybe you could also spend a little time, because I have to make my decision without waiting, but I may think about it overnight because we're going to start up again tomorrow. But I would like to go over the exhibits, so if there's admitted exhibits, I can take a look at those in making my decision. So if you'd like to spend some time talking about what exhibits you can agree to, that might help that a little bit. So I want to get that accomplished tonight as well, regardless of what the court's decision is on the motion.
No, I understand that, but Your Honor, I know I've been, there's a few other things I'd like to say with respect to Rule 29. Are you asking us to not make those arguments? And I can be
We
less
will
than
do that
60
tonight.
seconds.
We'll do this tonight, absolutely.
Okay.
I'm just going to take a break for the moment.
Okay. All right.
Okay, and if you can let me know, let the staff know when you're ready for me to come back in, but if you want to spend a little time talking about the exhibits, that might help too. Because once I hear all your arguments, I'm going to digest, not make a decision tonight here on the record. I will tomorrow on the record. But I'd like to still get the exhibits done so I can take a look at admitted exhibits as well. So I'd like to get that addressed as well. So we'll just take a break. Let me know when you're ready, okay?
Ooh,
and you can continue on.
Ooh.
With the state argument.
Ooh, kill him. Ooh, kill him. Fuck, he might do it. Ethan's asking, how am I feeling about the motion? They've got problems. And it's true. They have problems with the intent because the intent is you have to cause or intend to cause the death of another. Well, how do they show that he intended to cause that? They have nothing to show he intended to cause because they can't tie him to doing it. Now, if they could tie him to killing her or doing something to kill her, to strangling her, and they could prove he actually did it, then there'd be some foreseeability. If you strangle someone, you are intending to kill them. Then there's the issue of they actually have nothing tying him to that crime scene in the body. That is another problem they have. And as you can hear, the prosecutors scrambling. They don't know what to do. This isn't, a lot of times these Rule 29 motions are perfunctory. You say your piece and the judge overrules you. The judge very much said, please explain to me why I shouldn't toss this. You know, this has not clearly been established yet, so identify it. Now, the judge did say it's clear that he's like, I will agree with you. There's enough evidence to show that she was murdered. And I think the judge is being generous there because there is that other part lacking. Or a jury could, at least reasonable jurors could determine she was murdered versus suicide. That's where this give and take is right now. This is not good for them. The judge has basically called them out. Sweet Tooth Fairy saying, my husband is cleaning our garage right now. Should I be afraid? Yes. Carrie May says, my boyfriend just moved his phone charging cord to a new plug. Should I call 911? Probably not a bad idea. And Bren, yes, your comment and ... I think I agree. But that's even said, Diane's still not done with her own argument, so she still has more to say. For this is weird though, taking a break in the middle. But also keep in mind the judge has to look at all the exhibits, everything that's been presented to him to make his ruling. And we're into like however a couple hundred many of them for the prosecution, and then for the defense, we're up probably almost 60, 70 on their own. So that's a lot for him to look at. So we should, the judge may wait till tomorrow because there's just so much crap to look at. That said, though, Ethan, what you're asking, where do I think this is going to go? If he lets the case survive, it's going to be by the thinnest of margins. Thinnest of margins. Donald, you Trust and Believe asked this earlier. How many degrees of murder manslaughter are there in Ohio? Okay. So you have murder, you have aggravated murder, which is first-degree murder. You have, in this case, which he got charged with, a murder, which is basically second-degree murder. Then you have felony murder, which is what's 290302B, B murder. Those are the primary murders in Ohio. There's also, and actually we'll bring it up. You guys can see it. So, actually, here, I'll bring it up right meow. Share screen. Here we go. So these are the types of murder you can have in Ohio. You can have aggravated murder. That's the top one. Then there's murder, which is like second and third degree murder. Then you have voluntary manslaughter, involuntary manslaughter, reckless homicide, negligent homicide. Then you have aggravated vehicular homicide, and obviously you're doing that while in a vehicle. But vehicular homicide is generally reserved for, ag vehic homicide is generally reserved for like DUIs. Or like, let's say you're texting and you did it. And then if you keep going through some of this stuff, you end up with like felonious assault, and that's where that's the third count of this indictment. So these are the types of murder you can have in Ohio. There's 1, 2, 3, 4, 5, 6, 7. And then this one here is basically like actually 2, so it's 8. So there's those kinds of murders. And as I said before, he's facing a minimum sentence of 15 years, a minimum mandatory sentence of 15 years, up to life in prison. And then the 15, once it's over, the parole board determines whether or not you go home. So CG's asking, if the judge tosses the case, does he go home now? Yes. This is a motion for acquittal. So if the judge determines you're not guilty, there's not enough evidence, it's done. Stop the fight. That Matheau Moore walks free, right meow. He could very well do that tonight. He could very well walk free tonight or tomorrow morning. But yes, the prosecutor, they're trying hard. They're trying mighty hard. I think in her defense, it's the end of the day. This is kind of like she wasn't ready for it. But yes, she was not 100% ready to deal with this. Ethan, I'm fed up with my wife. I'm going to go clean out the cords. Jeez. Jim Satala's asking, did Double Jeopardy already attach? Yes. The moment they started picking a jury, and then the jury is now impaneled, when you start that whole process, Jeopardy attaches. So yeah, he can't, unless there's a hung jury, he can't be retried. If the judge acquits him, that's it. It's done. JC said, I just got back considering a motion to dismiss. Very, very seriously considering it. I know the other cases, everybody's like, oh my God, they're going to like Kim Potter. They're going to dismiss it, or they're going to dismiss Kyle's. Nope. That's it. If the judge dismisses the case based upon this motion, could the state appeal? There's a lot of argument about that. Could the state actually appeal that? And I would argue they can't. Theoretically, they could try, but no, they should be unable to. Now, the argument they may make is that this was dismissed by the court and not dismissed by a jury, and it wasn't part of a bench trial. So it's entirely, it could happen, but I don't see the courts allowing it. They would just probably tell them, kick rocks and get out of here. The prosecutor knows just thinking about tossing it. Yeah, you could see in her emotion. She's like, you need to listen to me, man. Bro, I'm trying to tell you what's up. And, it's clear she's trying to sell and he's not buying, and it's a hard sell. You can see his reaction. She's on the back foot. Usually as a defense attorney, you're on the back foot in Rule 29 motion. But right now, he's basically said, like, I ain't buying your shit. You need to convince me. So, yeah. Let's see, who else got some questions here? Yes, in Ohio, the murder is a minimum of 15 years, potentially for life. But that's not that bad. I mean, in Texas, you could face anywhere from 5 years to 99 years. In Georgia, there's this like like the McMichaels guys. The one guy got 30 life. The other people got life without parole. Like a lot of states, their murder penalties are very harsh. Ohio's isn't that bad comparatively speaking. CG saying she was pleading with him. Basically, yeah. David Davison said the prosecution had to know this case was dog water before they brought it. How are they surprised by this? They're not surprised by this. I think they understood, and I said this earlier. Do they think the case is shaky? Yeah. Do they think they could still get the conviction? Sure. But it's just, they're just being passionate. The other side's being passionate too. So that's also, it's getting dark, so I'm trying to get a little more light here. Can you guys hear me well, by the way? Hopefully I'm still coming through well. Okay. Yes. Sorry, guys. Yes, the motion to acquit and the directed verdict at this point is called a Rule 29 because under the Ohio Rules of Criminal Procedure, that's Rule 29. In fact, we'll bring that up real quick. Since we got the time. So Ohio has a rule of criminal procedure. It has rules of criminal procedure, and you can talk about them, and it governs everything. Everything is governed by it. All the stuff you want to do in a trial, misdemeanor or felony. Yeah, sorry guys. I'm sorry, JC and by Franz. I just saw this. So. Murder's your will to live. So, okay, good. Everybody's saying loud and clear, perfect. All right, so we're going to skip over to this now. Stop screen, share, Chrome, Ohio Rules of Criminal Procedure. All right, so these are the rules of criminal procedure, and they govern how you handle cases and criminal matters in the state of Ohio. So as you can see, it's very straightforward. The scope of the rules, definitions, a complaint, how warrants are filed. Rule 6 talks about how a grand jury is handled. Number 7 is how you do an indictment or an information. But we got to scroll all the way down to Rule 29, the motion for acquittal. And the motion for acquittal is very straightforward. The court on the motion of a defendant or on its own motion after evidence on either side is closed, shall order the entry of a judgment of acquittal of one or more offenses charged in the indictment, information, or complaint if the evidence is insufficient to sustain a conviction of such offense or offenses. So the court can also do it himself. If the defense doesn't bring it up, the court can say, you know what, on my own, I don't think you guys have met your burden. The court may not reserve a ruling on a motion for judgment of acquittal made at the close of the state's case. And that is correct. So as soon as the state's case was over, Diane made a Rule 29 motion. The judge has to rule on it right then and there. Okay? The time where he can hold on to it is here, the reservation of a decision of motion under Rule 29B. If the motion's made after the close of all evidence, meaning the state has rested its case and the defense has rested its case, meaning all evidence has been presented. Then he can say, I'm going to reserve my decision upon the jury verdict. Okay? So the court may reserve the motion, submit the case to the jury, and decide the motion either before the jury returns a verdict or after it returns a verdict of guilty, or after it is discharged without having returned a verdict. So what that means is Judge Walver could sit on this, let the jury go through closing arguments, go through jury instructions, let the jury start deliberating. Partway through the day, let's say tomorrow afternoon, at lunch, the jury starts deliberating. And let's say 1 o'clock rolls around, the judge has thought about it. He can bring everybody in the courtroom and say, it's done, you're dismissed. I'm doing not guilty. Now, is that ever going to happen? I'm not aware of it happening. It's got to have happened somewhere because it's in a rule. He can also let the jury return a verdict, and let's say he thinks it's not guilty, and if the jury comes back and they say not guilty, then he's fine. If the jury comes back and says guilty, and he thinks it's not guilty, he can say, okay, cool, I'm overruling the jury's verdict, not guilty. Now, it doesn't go the other way. If they acquit him, he cannot convict. It's a one-way street, in case somebody asked. Or if they get discharged with having returned a verdict. So let's say there's a hung jury. The jury just can't come to a conclusion. Okay, well, he could say, well, I have come to a conclusion. And yes, the jury didn't come to one, but you know what? I'm acquitting this guy, and it's done. So he can do it a couple different ways. I'm sorry if that was a lot all at once, but yeah. Long Crimes chat is spinning. Well, hey, that's why you actually need an attorney here to kind of, they're very pro-prosecution over there. I noticed that. They are very pro-prosecution. So, Rule 34 solves this. No, it does not. Rule 34 does not solve this 7-11. Oh, Long Crime, I bet, thinks he's still guilty. Oh, I guarantee it. I guarantee you there's a lot of reeing going on over there. The ree and scree has to be massive. Hold on, let's go check real quick what's going on. Oh, God, they're claiming that he killed his son. Oh, my gosh. Oh, I guess I'll troll a little bit. Yeah, these guys are, oh my God, they are losing their mind. It's so sad. That's what Brent's saying. That's wild. You mean the Rule 29 motion? That's actually very standard in most states. You're allowed to ask for a directed verdict. Now, I don't know in other states if they allow the judge to do it on their own sua sponte like that, but some states may allow it. Ethan, you're asking, why is Long Crimes chat always pro-prosecution? Do they just assume only guilty people get charged? I mean, most people, to start with, are pro-prosecution. Most people walking down the street assume the police only catch bad guys, and that if you're on trial and you're sitting there in a seat, you are a bad guy and you deserve to be there. So that's actually not that rare of a thing. Guys, I'll also point out real quick, if you got questions, get them in now, because after this is over, I got to get home. It's about a half-hour drive for me. And I don't want to get home, get some things done, so I'm not going to be on. As soon as they adjourn for the night, we're going to be done, okay? Yes, JC. Yes, CG, they were reading very hard during Rittenhouse. All kinds of Oh, Lochnav or Lochnav, quoting somebody from Long Crime. I'm starting to think that the jury must also think it is very unfair the state had such terrible representation, and they may decide to do it as justice to convict this killer. Ooh. Well, I will tell you, Melissa Schieffel is actually a very good attorney. She's a very good prosecutor. Just happens not to be a good day for her. And the thing is, when you're a prosecutor and you don't have a good day, a case implodes. It's just not a good case. But the Delaware County Prosecutor's Office is pretty good. They've had some pretty good cases, high-profile stuff in the past. There's people in Bifront saying there's people in the long crime chat claiming they live in the neighborhood. See them walking down the street like, what up? What up, Matt? Hi. You guys want to see my cord collection? JC says they're going to be so angry. There's going to be so many angry Facebook posts tonight. Oh, yeah. Oh, sorry, clicked on the wrong stuff. Yeah, no, Brent. I that's what I mean. Yeah, they are very adamant he's guilty. Yeah. Yeah. So I just did. I dropped my comment in there, but I don't think they even mentioned anything. Yeah, holy cow. These guys are being ridiculous. It is funny to watch. It's just like cope. It's like Copenhagen. To quote the great song, country song. Ethan says, are they coming back from work prosecutor tears tonight or saving them for tomorrow? Oh, no. It's getting done tonight. The judge may decide to wait till tomorrow to handle the decision, but the arguments are being presented tonight. He's not going to give them the night to go through and do research or something to buttress. No. To quote the great Alec Baldwin, Rule 29 is fuck or walk time. It is fuck or walk time. I don't know why I have these on yet. They aren't back. But yes, this is going to happen tonight. Launder and Clip said do it. I just subbed so I can troll in a bit. Okay. I cannot encourage you guys to troll. That's not right. That's against YouTube's rules. That's also not cool. You do what you want to do, but I will never encourage you guys to do that. They were apoplectic. Carrie May saying they were apoplectic when Curtis Reeves was acquitted. Well, I don't have to tell you because, once he started showing that there were hands thrown, not guilty. Sorry, guys. Speaking of water, I don't have water, so I don't know. I feel Melissa's pain. I don't have water myself. This whole thing, and I mean, they went through, they talked about the other stuff they had, the text messages. None of those were critical. Nothing here. Yes, not legal advice, Susan. Yes. Chaucer says, Chaucerian says, I think long crime is full of wine moms who just want to see someone burn. Certainly, a lot of people are, though. Like I said, a lot of people are pro-prosecution. I mean, think about all the police shows you see on TV, Law and Order, all those things get people all fired up. So, is this coming? Why is this? What the hell happened to my camera? That was weird. But all those shows have tons of views all the time. Why? Because people like chasing after the bad guys. People think it's great. You're hunting the bad dudes down. So that's how those shows keep existing. Shizzle saying the state has absolutely no case at all. It's circumstantial. Well, hey, a circumstantial case, circumstantial evidence can be used to convict someone. They don't even have circumstantial. They have like some inferential issues, inference issues. So it's even worse. Yeah, people have been put on death row for purely circumstantial evidence, and you can be convicted on circumstantial evidence because it's still evidence. You know, I go running down the street with a sack full of money covered in the dye from the bank, and I got a gun in my hand. There's a good circumstantial evidence I robbed the bank. So, yes, JC saying they have trust. JC says the evidence they have is trust me, bro. Very true. Oh, hold on, guys, 1 second. Sorry. The police were checking out in the parking lot, so I think they're figuring out who's a new cop trying to figure out my car. Yes, but their evidence is trust me, bro. Yeah, that part was pathetic. Carrie Mae talking about when they had the prosecutor question the lead detective, googling about Eddie Gallagher. I know we talked about this yesterday. Eddie Gallagher was a former Navy SEAL who was accused of murdering an insurgent, stabbing him. He's wounded, and he stabbed the guy with a knife as he was laying there waiting medical attention. So they were claiming, oh, he was looking up murders, but the murders he looked up were completely irrelevant to what he did. So, yes. Yes, that was pretty pathetic. And then that's when Diane Menashe does her job of saying, well, what was Eddie Gallagher about? Oh, he's a Navy SEAL who possibly committed a war crime. Not what happened here. Sweet Tooth Fairy says they're coming after you. They always are. Everybody's coming. Everybody wants a shot at the title. Everyone wants a shot at the title. I don't care who you are. You know, Joe Biden, Joe Neerman, Nick Rekieta, Kim Jong-un, Idi Amin, if he was still alive. They'd all want shots at the title, and I get that. That's how it goes. It's lonely on the top. JC says, LOL, okay, Portnoy. Oh, come on. Portnoy's a tool. His pizza reviews are funny, but yeah, he's being a little bitch. So, yeah, right now we are in the middle of it. Yeah, no, they're still kibutzing about all the evidence. Still kibutzing about seeing all the evidence. Oh my gosh, sorry, I'm just reading along here. Oh my god. Now, if I was Diane, I think she can object to this whole issue of the break here, but I don't know if that really is going to amount to anything because the judge is going to say, look, you guys have to get the evidence in order anyway. So, oh my gosh. Everyone knows the rules. That's what oh, the numbers been saying the prosecutor's working harder on her arguments. Well, yeah, she could be sitting there doing something. She might be organizing because her assistant is up there getting all the evidence sorted out. Lochnav saying another quote from Law and Crime is, if I lived in this county in Ohio, Dr. Agnew would be forbidden from touching me. My hubby would be in prison no matter how I die. I don't know if I got the context of that one, so. But yes, overall they're crazy. Well, I gotta. So Carrie's saying it's also pathetic how the prosecution keeps trying to ignore and minimize. Oh, why did I go back to myself on the screen? Minimize the fact that Emily's first husband committed suicide before she met Mathew. Yeah, and then there was the issue about the son committing suicide too. Yeah, it's very, very, very. Yeah. Yeah, it's there's so much to this that's just just not good. Jim Satala is saying, I would put the odds of directed verdict at like 70%, which is huge. Even 30-40% would be a massive thing because, yes, you're right. These are usually a pro forma thing, and they're only successful 5% of the time. Very, very true. In fact, about last month, trial I had, we won. It was a bench trial. It was only a misdemeanor case, but it involved assault. The judge, on his own said, you haven't met this burden, so I think actually the most you can be charged with is a lower level offense. So, at the end of the Rule 29, we kept playing, but it was on a lesser charge. So, yeah, it generally, even 5% is generous. It's usually like no percent. You usually get crushed when you do it. So, I can at least tell you that much. So. Okay, sorry guys. Trying to catch up on some things in Discord I was passing through. Yeah, they're 5% of the time is very high. HM, you know. If you take into account all trials, including bench trials, around 5% in state courts, it's mainly a misdemeanors. Jim, that's about right. Because my experience of trying cases, I mean, I've tried a bajillion misdemeanor cases to courts, to benches, especially most of that in my time as a public defender. Yes, that's pretty much where you'll get the motions to directed verdict. You don't usually get them at felony cases, although it does happen. But yes, you're more likely to get that to happen in a misdemeanor case. So I think that's a fair assessment right there. Yeah, I will not contradict that point. Like I said, as always, you usually do. There's much wisdom, there's much iron in your words, to quote my ancestors. What the heck? Why is it still going here? Do. 7-Eleven, I'm not answering that question. I'm not answering that question about the salamanders. Usually a prosecutor wouldn't bring a dog shit loser of a case like this to trial. It's hard. A murder case like this, though, a lot of them would. Because it looks bad in your community if you don't try a murder case. So politically, I think she had no choice. That certainly is the case. I would have to argue. So I was going to work on this tonight, but there is a interesting ruling out of Ohio, the Fourth Amendment case involving a kid taking his test in college, and the college violated his Fourth Amendment rights. So I'll probably do the video on that tomorrow before we do the live. But just something to think about. I was going to try to work on that tonight, but apparently we're going long today. Oh my gosh. Jeez. Leonard, you're going crazy over there, man. Being a little crazy over there. They don't know it was a murder. Well, remember, Jody, even if it is a murder, they still don't know who did it, and they can't prove he's tied to it. So, yeah. Yep. Yeah, Nick brings on about this. It's true. I mean, if you're a prosecutor, the prosecutor loses nothing if they go to trial, and they lose. I mean, the worst they have to do is pay the court costs, which, your budget's a couple. A place like Delaware County, I bet her budget's like a couple $1 million. So, the cost of trial are not that big a deal. But yes, Lognime, you're right. Jim again. This case is Rittenhouse levels of stupid. Their only evidence is he said their marriage is over from before. Oh, 100% true. His text messages, those are not indicative of anything. They're very bland and very benign. Totally stupid. Yeah, they don't have much, and I think the judge is going to dump this. I don't know if it's 70%, because I would argue a 50-50 coin toss. That is still, the flip of a coin. That's, whoo. I want to risk a case like that if I'm the prosecutor on a coin flip. This whole thing is just bad. So many people complain about their spouses and say their marriage is over. I did that once too. I didn't kill my ex. She's still alive. I can verify that. Well, at least the last time she texted me, she was still alive. We need to change the law so that if you get found not guilty, then you get all your expenses paid by the state and lost wages. Does that have to be in every single case? I think the Kyle's Law thing is very true, but it's. I think that would need some fleshing out there, Jim. But I don't think that's a bad idea. That you get, especially the right of your defense. The state forced you to go to trial. They forced you to go and get an attorney. You didn't get an attorney because you wanted one. You had to get one because you didn't want to go to prison. Yeah, I think at the very least those should be covered. I think Kyle's Law should be in place. Especially let's say it's a case of, you get accused of child molestation and the jury doesn't believe it and they acquit you. Okay. Now, I think there should be a separate finding that if you acquit, do you feel this person's, prosecution was completely unnecessary and that the state should be liable for all costs? I think that's how you would want to do that. Well, Jim is saying if you put qualifiers into it, then they would always screw you on the edges. Sure. But would that work then? That's where I'm thinking you would have to have the jury make a finding. Is this person entitled to all compensation due to them? And if they determine that, then I think that's fair. Or are you just saying automatically a not guilty and then there's no change and you just get everything automatically on a not guilty? That could be possible. 7-Eleven is saying, I killed my ex, but thankfully potentially criminal was my lawyer. Hey, I get results, man. I guess this is another thing from, Law and Crime is claiming they really could have made this case. No, they had awful facts and awful. There was only so much they could show. They basically were given a pile of dog turds and told to make a statue. So they made a statue out of dog turds. I don't see why people think this is. It's not their fault. They got a bad case. That's what happens. So I don't think it's a fact they're not trying harder. They're messing up. It's just it wasn't a good case. Sweet Tooth Fairy saying, California allows relief for those needing testing by agencies requiring drug or alcohol testing to be paid by the licensing agency. I think that's a fair way to do it. Jim, yeah, and I think this is a good point here. Otherwise the state equally has to cover the prosecution and defense, and that would be interesting because that's the issue. Defense is not fully covered, and there are states where they have robust public defender offices and things like that are well funded, but even then, the amount of funding they have and resources they have pale in comparison to the state. So yes, I think an equally as powerful agency would be about the only real counterbalance if you wanted to avoid that issue. But that's something, nobody's going to want a public defender's office that powerful. I mean, most people think Law and Order is a great thing, so I don't know if that would ever happen. So I think we may be stuck with the idea of just, cutting checks to people. And at that point, I'm going to start charging my rates to as soon as we win. Oh, during trial, Your Honor, I raised my rates to $1,000 an hour. Retroactive. And Jim, you're right. Those people who are against it are assholes. You are 100% correct. Chaucerian says, I think we're sitting down. Is this game time again? Let's be real. Public defenders are for poor people. If you have money, you would not want a state-funded attorney. Yeah, in the current state, but if the public defender's office was as powerful and as well equipped as the prosecutor, that would be a whole different story. Lucknow is saying Bronca mentioned something about punishing the prosecutor individually, not the state. But how do you punish them? Like, do you say, like, hey, we're taking this out of your pay? I mean, because otherwise those guys would never go to trial, because if you're making $70,000 a year and you get hit with a $20,000 bill, like, oof. 7-Eleven is saying Law and Order state propaganda. It is. Like I said, it is pro-government. It is prosecution porn. It is police porn. Cops, Live PD, all those shows are. Think about all of them that are up there. Jody, you are correct that the public defenders, why is it? Yeah, are not just for poor people. They go by your income and expenses. But generally speaking, at least in Ohio, once you're 150% above the federal poverty line, you quit qualify for court-appointed counsel, and you have to supply it on your own for the most part. Why not make public defender's office and DA have equal resources? I agree. That's where it should be. The amount of resource out of the public defender calls the police or detective tries to talk to them, they should have that same recognition of authority power as when the prosecutor does. But that doesn't really happen. Are we back? Let me see. Let's see if we're back. Not yet. Everybody's having a smoke and a joke still. Jim is actually correct here. Some public defenders are excellent attorneys who you'd be lucky to have if they actually had time to devote to your case with the same resources. Yeah. I mean, if you want somebody who truly will fight for people, I mean, that's where you're going to find them, especially when they're younger. How many people in this chat could afford to pay someone like Diane? Most of us couldn't. I'm not sure I could afford her for something truly significant. Actually, I know I couldn't afford her for something truly significant. Okay, so Locknap's saying that Bronca proposed an entry on a jury form saying, did the state at least prove beyond preponderance the 50% standard? Yeah, and I think that's a way to do it. You have the jury decide should they award, you know, award award compensation. Yes, I think that could be up to the jury. That'd be a way to handle it. Yeah, 150% of poverty is like 30,000 a year. Yeah, no, that's how bad it is, and the resources that exist, Jim. It's not good. It is not good out there. You're 100% correct, but that should show you how bad things are. Holly Chaucerian fraud saying Hollywood has been trying to influence the opinion of people over the power of the police and law forever. They have, but it's how many police officer shows are out there? How many court shows are out there? Law and Order would be less propaganda if they didn't receive state and federal funding. No, Law and Order would be would not be state propaganda if they had, defense attorneys and private investigators being the stars of the show as well, not just bad guys who the prosecutors go up against. That makes it state propaganda to me. So that's the issue. It's that, like, if you watch the newest reiteration of Law and Order, it's like they always win. And they have these sketchy cases they're taking all the way. No. Why aren't they losing? Why are they, like, the defense attorneys seem like assholes? Like, that's the problem. That's where I get the idea. So. HM says culture wars matter. Yep. Politics and law are downstream of culture. R.I.P. Andrew Breitbart. Very true. Man was very wise and ahead of his time. CG said The Wire is better. It is. It is. Because it shows you how disgusting the government is and how corrupt Baltimore was and still is. If the state is charged for the defense if they lose, that can be helpful. But I mean, depending on where you live, if the case is big enough, then you just wiped out your entire budget for prosecuting crimes. So, that may sound good, but then literally they wouldn't be able to prosecute a murder or something legitimate that actually happens. Chaucerian Fraud says, I think many people will be weary of the state and the defense getting paid by the same boss. Well, not necessarily the same boss. In Ohio, for example, the attorney general is, and the prosecutors are elected officials who operate independently. Within the governor's office, there is the Office of the Public Defender, and they operate as an executive level agency. So they don't get pushed around by anybody, and the governor doesn't fuck around with them either. They operate on their own. So, they get paid. Yeah, they get paid by the state, but they whoop ass. So, and Jim, yeah, you're on point. This is the issue here. It's the resources. The prosecution can throw all kinds of money they want. Mathew Moore, he retained Diane Benashi. He's kind of limited in what he can do after a while. And let's say he runs out of money, then he has to turn to possibly being appointed by the court if he runs out of money. Well, at that point, then Diane, if she wants an expert, has to ask the court for permission to pay for an expert. The court's only going to pay for so much through the state, through the government's own funding. So that's where it becomes an issue. And yes, if you're on the defense, you should have an unlimited purse as well, because the state gets to do whatever the hell they want. Yeah, Jim's right. They would have to be sure they can prove the case and the juice is worth the squeeze. Yeah, Yeah. Um, Karen Ortiz, that's this part though. You're 100% right about. If the state was charged for their loss, then the taxes in those areas would increase. Sure. Oh yeah, they'd make up for it. That's how government always works. Carrie May says Moore wasn't even high functioning enough when Emily went missing to pull off such a calculated staged suicide and leave behind zero physical evidence. Yeah, he was drinking heavily and depressed about his son, who, um, yeah, his son had died, his son had hung himself, and that was all going on, and he was just getting over it. So, yeah, like I said, there's all kinds of holes. There's all kinds of holes in this. I actually need to call my girlfriend and make sure she doesn't start dinner yet. So give me 1 second, guys. I will be right back. All right, we're back. That was perfect timing.
Okay, we're back on the record. All parties, including defendant or president, we're outside the presence of the jury. The state's still making any comments you wish regarding the Rule 29 motion.
Thank you, Your Honor, and I appreciate the opportunity for a much-needed brain break to gather my thoughts. Your Honor, this whole case has started with suicide or homicide. And there certainly is enough evidence in light of the criminal Rule 29 for the jurors to determine this was a homicide.
I've already crossed that bridge.
I'm getting there. I'm getting
You
there.
did.
All right. So you have to start there, Judge. And everything must be viewed through the lens of this is a homicide. Okay? So the evidence admitted must be viewed to support the homicide.
Somebody killed her.
So if you do that, then you have to look at the way in which the homicide occurred and the staged suicide that was set up to try and make it look like it was a suicide, not a homicide. And there's only one individual that needs to make that look like a staged suicide, Your Honor, and that's the defendant. Your Honor, there is no one else that needs to string Emily Noble up like that in Westerville, Ohio, to make it look like a suicide. And the reasonable inference jurors can draw is that that's the defendant. If the evidence is viewed in the light most favorable to the state, Your Honor, and you look at the evidence from a lens of a homicide, then you have to look specifically at his actions that May 25th window. What is he doing in the condo? Because a homicide that has happened and he needs to stage a suicide.
But your position is, I believe, on May 25th, in the daylight hours, it's a fait accompli. It's been accomplished, right?
Yes.
Okay.
Yes. So his
That's not enough.
Tells law enforcement. Well, one, he has to sleep. One moment he goes to sleep. He has to say that, Your Honor, immediately, because his wife, he's got to start building the story that his wife has disappeared, right? He has to tell law enforcement that he doesn't know where she's at because he was asleep. And
This is a shit argument.
I slept in, and by his own words, that's abnormal for me. So he has to say that so that he can say that he doesn't know where she's at, that she's disappeared and she's wandered off. And then, Your Honor, he wakes up in an 800-foot square condo, texts Emily's phone at about close to 12 p.m. He doesn't get up. Then he uses Find My iPhone. He doesn't get up. He doesn't go look for her. He does nothing. If this is a homicide, Your Honor, he's taking those steps to support the suicide, that this was a suicide. He has to start creating those physical records that he doesn't know where she's at. And that's why that evidence immediately afterwards is so important. Now, most telling, well, I won't say most telling, it's a decision for the jury, Your Honor. He tells Officer Hollis when he gets to the scene later that evening about this walk that they go on, this path that they forage. But he says to Officer Hollis, he's never checked.
So you never went?
Checked. He never walked that route that day. He, the defendant himself. If your wife is missing, has disappeared, is engaging in what he even says is uncharacteristic for her, and to the point where you call law enforcement and you've done nothing, and the inference is, Your Honor, he's done nothing because he knows she's dead. If your wife is missing, you are scouring the earth. You most certainly are walking that path every single minute.
Who the fuck are you to say what he should do?
Unless you
Oh,
know she's dead.
you can't articulate that comment.
View that behavior in the light
Bullshit.
that this is a homicide.
Bullshit.
He doesn't go and look for her, even immediately after saying she's disappeared and called law enforcement.
There was a point in time when Officer Hollis was there, I don't know how significant this is, but I'll ask you the question. When I believe Celeste drove up and Officer Hollis said, "Is that your wife?" And he goes, "Yes." And he goes, "No." If he had killed her, would he have said yes in the first instance?
Right, that is a fact for the jury to determine, and what weight to give to that, Your Honor.
That's a fact to determine.
The overall picture for purposes of Rule 29 and whether the evidence can support a rational juror making these inferences. And that is a point that's in the video. But Your Honor, I would argue that his reaction is something different. And I don't want to make every single argument in this Rule 29, Your Honor, about our case. And I mean that
It is about your case, you dumbass!
Get to the point of
I'm not sure I follow you. What were you want to make every argument?
Everything in the Rule 29 is your case. It's your burden of proof, you fucking idiot.
Okay, sure.
Jesus Christ!
And then you have to also consider the defendant's behaviors immediately after the next day and the following day. Also, in the light of a homicide, continuing that he needs to push this, it's a staged suicide. I don't
Maybe
know
he's
where
just a
my
fucking
wife is.
weirdo.
John Kramer says he noticed he was smoking in the condo. And John Kramer said he knew in that instance Emily was not coming home because the defendant.
The same guy who recanted his testimony.
He continues to refer to her in the past tense, which I belabored before, so I'm not going to say that again, Your Honor. So those two things also, Your Honor, point to the fact that he knows she is dead and that she is not coming home, and the reasonable inference is because he killed her. And it's important when he shows up to the interview with law enforcement, if he truly had no reason to know, he had just woken up, like he wants law enforcement to believe, he has no reason to think she's dead, but yet his first words are unprompted, "I didn't do it."
Well, hang on a second.
Those would be my
He's taking
fucking
a
words,
police
too.
department in a cruiser. He's behind doors.
Your Honor, I'm
He's
making a
given his
rule
Miranda
20.
rights.
Your Honor,
Every
I understand, but I'm making an argument for the facts in a light most favorable to the state, okay?
Yeah, but he's in fucking custody for all intents and purposes.
All right? His actions and statements are that of an individual who knows his wife isn't coming home.
Judge is
He was
calling her
on
out.
past tense. He is smoking in the condo. He says, "I didn't do it."
Smoking in the
This is a
bathroom.
Staged suicide, made to believe manual strangulation is like a suicide, and his behaviors immediately after that demonstrate that he is an individual who already knows his wife is dead. He's acting like she is dead, and his behaviors indicate that, and he can't act that way if he doesn't know she is dead, Your Honor. He is the only individual that has the need to make this death appear to be a staged suicide. And, we talked a little bit about his words, and I just want to remind the court, too, that John Kramer also indicated that he overheard a loud argument shortly in the days, I don't remember the exact time frame right now.
A couple of weeks earlier.
2 weeks. 2 weeks before, yes. Thank you.
Thank you. Thank you. Last word?
Thank you.
Judge, as you know, one of the elements for the murder is purpose. It's the mens rea. You need to have specific intention to cause a certain result.
Get it, Diane. Let's go, girl.
The court is right. There is
Let's go,
enough
boo.
evidence in the light most favorable to the state with respect to the issue of, was there a homicide committed? Don't disagree with that. With respect to, is there any link between Emily's possible manner and cause of death to that man? No. It's one of those things where we can
I
say
think we've conceded there's no direct evidence at all in this case.
there's
It's all
no direct
circumstantial.
evidence, but circumstantially also. To say an individual who already knew his wife is dead, Your Honor, that's not circumstantial evidence either. That is inference stacking, and the court well knows that there's an instruction literally against double stacking of inferences. Can you draw one inference from a set of facts? Yes.
Yes.
Can you draw an inference upon an inference upon an inference? No. This case, Your Honor, with respect to connecting any manner or cause of death of Emily Noble to Matheau Moore is completely void of evidence. And I don't say that, and I want to say this because I know how defense attorneys are perceived sometimes. I am not saying that to preserve the record. I am saying that because this is absolutely under no circumstances a case that should go to jury. It is literally nothing to tie him there. You talk about the stage scene. This stage scene, well, first of all, I know that Dr. Smock issued a report and testified, but let's just go to that scene. They want to say it's staged. Okay, they had Dr. Smock saying that. Who, where, what, when do they have to get Matt Moore to that scene staging? Now, I've just heard the prosecutor say that there's a 4-hour window of time during the night when most of us are sleeping, and when, by the way, he said he was sleeping. That is a time when nothing is going on. The cell data certainly supports that. It's during that time that the state is arguing, based on speculation, that that's when he killed him. That's what they've just argued, and they certainly implicitly argued that through the testimony of Detective Gross. What we know, Your Honor, that John Kramer sees her at 9 or 10 a.m. And I want to say something interesting, is that the state just now, in its Rule 29 argument, used John Kramer twice at the end to support the smoking in the condo, right? And I forget what other point about John Kramer. They just can't have it both ways, Your Honor. John Kramer did not come in here and retract his testimony. That's not what it was. He said he cannot be positive that he saw her on the 25th. But we know, Your Honor, from the cell phone records, that on the 24th at 9:39 a.m., she's in Butyl, Ohio. Not only do we know that from the cell phones, but we even have photographic evidence of her there as well at the Springs. We know from the testimony of Detective Grubbs that it's an hour and a half each way. So when you look at what John Kramer said and then his testimony that he can't be 100% sure, the cell phone records are everything. Because what he did say is it's either the 25th I saw her or it's the day before. And we know it couldn't have been the day before. So she's alive on the 25th. She's alive. And Matt, they want to use Matt's words against him, but Matt Moore said to the police that he woke up late morning, consistent with 9 to 10 a.m., John Kramer saying her. And it's not just John Kramer that says that. We know that from Officer Hollis's video, that that's what he told Officer Hollis. And Your Honor, Defense Exhibit G is literally the Westerville police report, that's the press release that says she was last seen at 9 a.m. That's from the Westerville Police Department. That's not influenced by Matt Moore. That's not Matt Moore. That's the Westerville Police Department talking to the public. She's alive on the 25th. He calls 911. We know there's a GPS on his car as of the 27th. The 26th, he's giving statements with law enforcement. He's taking them to the area and saying, she walks this area. Now, the prosecutor wants to say that did he check that area in the absence of a search means he must have killed his wife? But we know from testimony, even from Amy Thomas, I asked her at the end of her testimony, just because you didn't come to Ohio and search for your sister, does that mean you don't love her? And she said, no. That's nothing, that's speculation, that's inferences, and it is certainly not, even when viewed in a light most favorable to the state, enough to put this case in the hands of a jury. Purpose, Your Honor, is a specific intention to cause a certain result. Where does it show he intended to kill her, that staged her? And Your Honor, I want to talk about something that I wasn't allowed to ask about, but now it certainly seems relevant. You know, as a former prosecutor, the state has the power to file charges, put evidence forth in front of a grand jury, and importantly, they have the ability to amend an indictment at any point. This is a case of 2 counts of murder and 1 count of felonious assault. There has been so much about this cooler. First of all, there's no evidence that USB cords were ever kept in the garage. But Your Honor, he's not charged with tampering with evidence. And you know what else he's not charged with? Abuse of a corpse. How does she get to the park if their theory is the crime scene is at the house? And I will tell you that during his testimony,
Hit it, sister.
actually said, we didn't
Ow!
ask him why you didn't do all these things at the house, and he said, certainly, if I ever need to get there, that it was not a crime scene. Because there's nothing to prove that anyone was killed inside of 46 Avenue Cross. To say someone was killed there is speculation and is an inference upon an inference upon an inference. And then they want to take you that she's killed there, and then somehow, under the cover of darkness or lightness, she's moved to an area where we know you can't drive a car along county roads. We know from the women that found the bodies you can't walk through on the other side without crawling under branches. We know he's 6 feet tall. It's not. It's just, Your Honor, there isn't even enough. There's nothing to connect Matt Moore to the body in the woods. And they can't just focus on nobody else would do this. That's certainly not enough to go back to the jury, just because they don't have another suspect. Purpose is one of the elements. There is no evidence of purpose. And if the court is unsure, the best they have from his mouth is the text messages. And they have an individual, and if you want to now believe John Kramer about the arguments, that was the other thing that John said.
I'm sorry about that.
The arguments, that was the other thing they were relying on John Kramer for. The arguments and the smoking. Your Honor, I asked John Kramer, and there was even a follow-up question from a juror. Did he hear arguing the night of the 24th or the 25th? And he said no. Also, Your Honor, with respect to John Kramer and the smoking, I went over the detective of all the photos of if there's any ashtrays or cigarettes taken from the house, and there were none. Your Honor, this just can't be a case that goes back to the jury. It is speculation, and it is truly exactly why that inference stacking instruction exists in OJI. That's what we have here. Thank you.
I'll consider the case submitted unless you want to keep going back and forth for a while.
I just want to make 3 brief comments, Your Honor. Okay. Defense counsel.
And I'll let the defense respond as well.
Defense counsel has commented quite a bit on the credibility on the witnesses, and
I understand where credibility falls in here, so I'm good with it.
Okay, so credibility is not a Rule 29 decision, because you must.
I'm there already. I got
You
you.
must view the evidence in a light most favorable to the state. No one has said that the state's theory is that this crime was committed at the house.
We have no idea where this crime was committed, right?
It could have been committed in the woods, Your Honor, where her body was found.
That's a possibility too.
And the evidence supports,
Ooh, he just called it out.
and I do want to talk about John Kramer for a second, because
Well, we've already come to the conclusion, I'm not going to consider his credibility. I'm just considering the evidence in the light most favorable to you, which I will do. So I don't need to worry about his credibility. No, I mean, I'm not being demeaning. I'm just saying I'm with you on that.
so purpose to cause a certain result. Dr. Smock has established the manual strangulation and the elements needed to establish purpose. Your Honor. There's motive, there's certainly opportunity. He is the only individual who needs to make this liquid stage suicide, Your Honor, in addition to absolutely everything else.
Anything else?
Yes, Your Honor,
24 years and truly over 150 jury trials, and I can't believe that we're into the defense case and we still don't even know what the theory is as to where she's been killed. And that really goes to my point. This is a case that the state has been
Yup.
trying to develop as we go. And
Yup.
quite frankly, it's just not fair. My
Ooh.
client sits here charged with murder, 2 counts, 15 to life in prison. It just isn't, the system has to be better than this. And I really do mean this with all my conviction. How are we here when where she's killed, we don't even know. We don't even know that. And it's not like we know maybe, we don't even know that.
We can have a homicide without a body.
Well, we can have a homicide without a body, but we have a body in a wooded area and nothing to tie Matheau Moore to that. And it's not just the lack of physical evidence. You can't get around purpose. Smock, Dr. Smock, he can talk all he wants to about manual strangulation. There is 0 evidence this man strangled her. 0. I mean direct or circumstantial. And I recognize it's not the court should look at it through the lens of a homicide. The court should look at it, I understand, through the lens of evidence in the light most favorable to the state. It's still each and every element, Judge, as you know, for it to go back to this jury. Where is there even a scintilla of evidence as to purpose? There's none. I would ask the court to grant a Rule 29.
Fucking sexy talk right
I
there.
will consider it submitted, and obviously, since I have to make the decision right away, I will do so on this issue tomorrow morning before we begin anything else in the case. You've had an opportunity to talk about exhibits at this point. Let's at least get that so I can consider those exhibits as I ruminate on this issue. I think I was presented with I think all the exhibits have been agreed except for a few. Is that my understanding?
Yes, Your Honor. There's just a few.
And those were presented to me a while ago? You guys gave those out?
Yes, Your Honor.
All right. Okay, I have reviewed, I don't know what the numbers are. Do you have those still? Okay. I have the opportunity to review these exhibits, which is Exhibit 3, 99, and 107. And I believe it's the argument, who's objecting to this?
They're just my objections, Your Honor. With respect to the text messages, those are text messages between Emily Thomas and Matheau Moore, and separately Celeste Brown and Matheau Moore. They were used to establish a timeline. They otherwise are hearsay.
All right, and you're asking all the exhibits be?
That's correct.
All right.
Oh, and the one-page signal.
Here, if you like.
Yes, if I may.
Sure, absolutely.
These, in their entirety, as to hearsay, this, I understand, they're using this as an issue against this, and I don't have an issue with that, so this needs to be figured out.
You want the top on this one?
Oh, that's correct. I understand the evidentiary rule that they're using for the bottom.
Oh, okay, so you don't object to the bottom, just the top part of that?
I don't think I can. That's where I won't. Oh, and there's an accompanying video with that exhibit where I believe the video was played to essentially for a custodial issue to show how they obtained the signal. I would object to the video because it contains also a number of messages that are hearsay. There's also some other information there that could be perceived as bad acts with respect to using nonviolent things.
Okay, anything you say would like to say regarding these exhibits?
First of all, with regard to number 3, obviously the defendant's statements in that chat are statements that would be admitted into evidence. I think that if the court wanted to give a limiting instruction on how to consider any statements allegedly related to Emily in there, that would be one thing, but I don't think there's any reason to completely remove that exhibit from being admitted into evidence. With regard to State's Exhibit 9, the dentist's office indicated that was a business record. They indicated that.
I'm not objecting to the dental text.
I thought you said 3, 9, and
I have 99, I have 399.
Oh,
100.
Yes, he's in jail. He's in jail.
With Amy, the text messages with Celeste, which I believe you used just to show when she got the last text message, and then the Signal app. Those are the
Gotcha.
3 objections.
So, again, there were other messages as well that were shown to show when the last time a message was read on the phone. Again, the content of the message is completely and totally irrelevant. I couldn't care less. But I think the jury deserves to have the exhibit that indicates what time the message came in and what time it was read, because it further establishes that there is no user-initiated activity on Emily Noble's cell phone after 7:30, 8 o'clock.
Why, don't you have another exhibit from the digital extraction that reflects that?
But this is the actual printout of that specific series of messages to demonstrate that the information that's put in that timeline is accurate and reflects when it was read. So again,
Which exhibit are you referring to right now?
99.
99.
I do not care about the content of the message, but the last message or messages that are in there that indicate a time in which the message was received and a time in which the message was read is directly relevant to the timeline of what was going on with Emily's phone and whether or not she was alive anymore if those messages came.
Right.
And then with regard to Signal app, the video, we did play a short. The entire video, I can limit it to the clip that we played, just of them loading in and clicking into that conversation. And then obviously, I guess I don't know exactly what portion she's asking to be redacted with a screenshot. If I can see that, maybe I can coherently respond to that.
Well,
I'd stipulate to the chain of custody. We don't need the video. It's duplicative of that screenshot. That was the whole purpose of the video. I'll stipulate the chain of custody, not arguing it. I'll put that on the record. So I don't think we need the video. And it's literally has fodder for other things.
all right. The court will not admit exhibits 399, 100, and the top half of 107. I will not admit 106, except for the bottom portion of the May 7, 2020. My marriage is over. That'll come in, but the top portion will not.
I just want to make sure I had that right. Did you say something about exhibit 100 or did you say?
The only, of all these exhibits that we have here, the only one that I'm going to admit is the bottom half of 107.
Okay, so 399 and 106 are out.
399, 100, and 106 are out.
I'm sorry,
And the top half of 3. Now, I presume all of the other exhibits that have been discussed, there's an agreement to admit those. Is that correct?
That's correct.
All right. I do want to make a record on something. You're all admitting the learned treatises, and I think you know that the rule says learned treatises are entitled to be used. They're not hearsay. They're allowed to be talked about in front of the jury, but they will not be admitted. So I just wanted to make sure I have a record that says both parties are agreeing at this point not to follow the rule and agreeing together to admit these for the record. Is that correct from the defense?
I am, Your Honor, because they were publications that were relied and used by the experts. So I am okay with letting them go back.
And same with the state?
No objection from the state.
Okay, well then they will be admitted by agreement of all parties.
Can I go ask just for one clarification thing? Would the state be permitted on 99 and 100 to redact the message content, but leave the date and times of when they were received and read? Again, I don't care about the content. That's the only thing that I believe is objectionable. I don't know how it would be objectionable to have a date and time
Well,
stamp.
what's
when
the
message
defense
was received.
position on that?
What's the objection? If they want to just have black bubbles on it?
Well, would you say that again?
We'll black out the content of the message. It would just show where it came from and the date and time in which it was received and read, and that would be it. The content of itself, which I understand could be a potential hearsay objection, I don't know how the rest of that would be objectionable as to just the date and time that a message was received at that date and time without the content.
Now, you're saying 99, correct?
99 and 100, if I may, Your Honor, may I approach?
Sure. The reason I ask that is all these seem to be on the morning of, well, not 100, but 99 seems to be the morning of the 24th. I don't think there's controversy over that time frame. There's 99 and 100.
So regard to the second page of 99.
Those are some from the 25th.
No, these are the evening of the 24th.
The evening of the 24th.
So they're, the the two messages towards the end here indicate a date of them being read. We're gonna subtract 4 hours. So we got May 24th at 6:26 p.m. and it was read a second later. Another one at 6:27 p.m. read a second later. Then the last message indicates that it came in at 6:33 p.m. but was not read until 4:42 p.m. the next day. So that indicates that this phone never logged into the messaging app in order to be able to read that message. So that demonstrates a lack of activity. If you want to black out that it says 52, I have no earthly idea why that's objectionable to go on the jury that she asked the question 52. But if it is, if there's an objection to that, we could redact that, but still allow the time that the message went in and when it was read. I don't know. I don't know under what evidence that could possibly be objectionable. Same thing with Exhibit 100. There's a text message that comes in. This would be 8:07 p.m. on the 24th. You subtract that 4 hours again. And again, it was not read until 4:42 p.m. Again, I have no idea why there's an objection to a message that says happy birthday, but assuming there is such an objection to the content, we'll gladly black that out, leaving just the dates at which the messages were received and the date and time in which they were read, because again, that supports the cell phone forensics that indicate there was no activity on it.
What's your position on that request?
My position, Your Honor, is that evidence is in the timeline. That said, if the state wants to black out every single bubble and none of the words are visible and just wants it received and sent.
So if it's blacked out, just the information they're
Your Honor,
seeking?
I objected to it on hearsay. I don't think text messages between my client and another person in any form should be going back. And the timeline exists, which adds that. That's the purpose of the timeline. That's actually the.
I'm not following you. Are you agreeing with him or not agreeing
No,
with him?
I mean, I just, it's kind of constantly chipping away. You know what? I'm not agreeing with that.
Okay,
I think
it won't be admitted then. You folks have you had seen copies of the jury instructions? Since we got time here to amongst ourselves?
I haven't reviewed that in any detail at this point.
Okay, well, I would like for you tomorrow to be able to tell me your thoughts.
We have that.
Okay? Should we get to that point? Okay? All right, why don't we shoot for getting in around 8:30? You're going to be here at 9:30, right? Well, let's at least get together to talk about, I think it's time well spent regardless of how the court rules, just to go over these jury instructions. It should take all of 15 minutes. What you have sent to you is the final draft. So
I have my expert coming at 9:30.
what's that?
I have my expert coming at 9:30 and he sat here for 5 hours. So if we could start time at 9:30, that would be great.
All right, well, I think the only thing I have to do is make my ruling. That doesn't require participation from anybody, as well as, well, I think that's it. So we'll do that before 9:30.
And I just want to make clear for the record that in no way, shape, or form did I waive any appellate issue by doing my Rule 29 argument now. That was not my request to do it now. There's no issue of my waiver. I asked the state of Ohio when the court suggested that that was the pace of play that we do, if they would put on the record that they do not see it as any kind of waiver. Because in all my career, I've never done it in this order, and I want to just be really sure for purposes of the record that in no way am I waiving my Rule 29 argument just because of the timing and the way and the order it's been argued.
Actually, I have that experience before, where we did it out of order. Never had a problem with it, but the record should be noted, and I will put my imprimatur on it saying, yes, you have not waived anything. This is, as far as I'm concerned, timely made.
And for the record, we agreed. I mean, he said that. I think the court already did put on the record once about there not being a waiver. We have no objection.
All righty. All right, we'll see you tomorrow. These are not.
Well, so that's interesting. You guys asked me when I'm going to be back on with Nick. I don't know when. That's a kind of entirely up to him. Talk to him. Ask him if he wants to have me on. So that's pretty much what I would say. So, guys, that's it for tonight, really, at this point. Yeah, I need to watch Nick. I heard he had a lot of rants last night, so I will. Yeah, the judges really just stated, the judge is not buying their bullshit. I think they are in a very close position in getting some charges dismissed. And if the murders go, that's it. Pack your bags. So, we shall see what happens. Yeah, I think ultimately it's going to go to the jury, but the judge is going to state he's got concerns. And if it goes to the jury, well, remember, they still have more evidence to present. And that may be enough to tip the scales. We shall see. So it sounds like we're starting at 9:30, but I'm going to be on earlier than that, like probably 9 o'clock, just to make sure we cover the Rule 29 part. So I will do that, guys. I'll be back on at 9 tomorrow. Have a nice night, and until next time, just because you did it doesn't mean you're guilty.